May have repeated mention or but there's one mention which is of extreme urgency. Your logic
Yes, side.
appellate
Appellate set when you take up the appellate set, man.
2 p.m. We come back at 2.
Whenever you take up, if you finish appellate original set.
Oh, so it can be taken up immediately after that.
Yes, yes. Very good. But generally it's 2.
Generally.
Very good. Thank you. Call on the list. What is the you're for the alleged contempt now?
Yes, for the petition.
But I have no other excuse to offer.
Still pending.
Still pending, but in the meantime, there's a change of determination.
Yes, Mr. Ali. Whatever you say, we'll record your submission and pass out.
Because I cannot pay for any further action. Right? It would be very unfair on my part.
Should we take the last?
What was the nature of the direction which is being?
Direction was to release
Incentives.
the incentives.
Shall if they release the?
But we will see the direction. The only first step which has in which they are stuck.
No, we recorded in the last order. I recorded that appropriate orders shall be passed in connection with the rule in the event.
Yes, that's why I'll not embarrass myself.
Rule was issued in this matter.
Yes,
Rule was issued, and there is a reply also to the rule. The reply only says that there is an appeal which has been
obviously. Very embarrassing situation, you said.
That's why I'm not paying for any.
So there is nothing left but to commit them.
They can secure the thumb.
But your Lordship may fix it for hearing one day.
Contempt.
Can you fix it for hearing one? Or maybe not.
Immediately after the vacation, we'll do that.
First Friday after the vacation.
First Friday. It was recorded in the order dated April 25, 2025. It was recorded in the order dated April 25, 2025 that a last chance was given to the alleged contemner to obtain an order from the appellate court, in connection with the appeal which has been preferred, against the parent order. So it was further recorded that in default, appropriate orders shall be passed in connection with the rule. So next para, even today, when the matter is called on by this court, the learned advocate general, appearing on behalf of the alleged contemner, submits that due to no fault of the alleged contemner, the appeal could not be heard as yet. So it is further the court is further apprised that there has since been a change of determination of the appellate bench. Push up next para, keeping such alteration of determination in view, we keep the contempt application for hearing on June 13, 2025. Push up, it is made abundantly clear that on the returnable date, unless there is any order passed by the appellate bench in the interregnum, the contempt application shall be taken up for hearing.
I'm grateful.
Thanks.
Grateful.
My Lord, may kindly make it
known. When did you keep the other matter?
My Lord, it's kept next Friday.
Next Friday. You are for the respondent.
My Lord, for the respondent, but my Lord, our applications are being argued, my Lord. The section 48.
Yes, since a connected application has been since a connected application has been fixed for hearing on May 23, 2025, let this matter be also adjourned till that date.
Grateful.
Yes.
And taken us to prepare our notes. Our notes are prepared, my Lord.
My notes also ready, my Lord. Only Mr. Thakur is on leg, court number 41.
You would submit further? You will make further oral submissions?
Oral submission ready. Written notes is ready on the.
Take the written notes, you'll have to close arguments.
But that was the understanding.
That is
correct. I don't.
So we'll close arguments. Some food for thought in the vacation. Both sides file their written notes of arguments. First up.
Compilation done.
Accordingly, hearing is concluded and the matter is reserved for judgment. Thank you.
Mr. Chaudhary.
This is the journey to the center of the earth.
Yes, but Mala, I will not take your lordship so far. I intend to be very brief today
Yes.
because, my lord, we have already troubled your lordship enough.
No.
My lord, the issue, as your lordship remembers, my lord, is now, my lord, within very short confines. My lord, my learned friend's contention is that, my lord, the tribunal has ignored vital evidence. Now, my lord, two of them, my lord, now established criteria, if, my lord, it's based on no evidence at all, or if it ignores vital evidence. My lord, the question is, what would be, my lord, what would amount to ignoring vital evidence?
Yes.
Because, my lord, here, my lord, what is important is, my lord, the reports of my lord, IIST, my lord, the Shibpur, and my lord, of IIM Madras, IIT Madras, my lord, they were taken on record. My lord, all documents that were adduced by the parties were admitted into evidence. So, my lord, these are admitted into evidence because ultimately, my lord, in the course of oral examination, the parties agreed that, my lord, they will not continue with the oral examination and all documents will be tendered and accepted in evidence. So, the documents are accepted in evidence. Now, my lord, once documents are accepted in evidence, then, my lord, comes a question of weighing the evidence. Now, my lord, naturally, my lord, if one set of evidence is to be, my lord, accepted or appreciated, then the other will have to be discarded. My lord, now the question is, my lord, what is the use of the expression of the tribunal? My lord, tribunal is not, my lord, persons, my lord, really trained in law here, because, my lord, they are all, my lord, engineering experts. Now, my lord, the question is, my lord, if they have said that we will then not consider, does it really mean that they have ignored? My lord, that is the short conspectus of my submission before your lordship today. Now, my lord, your lordship will remember that, my lord, two important facets were that, my lord, lack of greasing and, my lord, the damaged tail seal brushes.
Yes.
My lord, these were the two important considerations. Of course, my lord, our contention was that, my lord, this is not something that could be foreseen. It is the dispersiveness of soil, my lord, the ground conditions, so on and so forth. Lordship also remembers that contemporaneously, when the incident occurred, my lord, there were a set of reports filed. My lord, these reports were considered for the purpose of directing recommencement of work. Recommencement of work had happened through the same agency. And it happened through, my lord, the same TBM of the same make, not the same TBM, identical TBM of the same make, which was operating parallelly. My lord, with the same tail seal brushes, the same greasing. Now, my lord, this being the situation, the next, my lord, set of facts that is important, what your lordship has already considered, is, my lord, in this case, there were two previous, my lord, change of tail seal brushes before the machine was scheduled for a stop. It was scheduled for a stop at a designated area for a change of the tail seal brushes once again. It is then that the incident happened. Now, my lord, when these two tail seal brushes were changed, well, it was changed under the supervision of the general consultant. Well, very important is, when the general consultant is appointed, there is a separate agreement with the general consultant. Agreement defines its role. Well, the general consultant is paid hundreds of crores. These are, my lord, international experts. And, my lord, their job is to supervise every step of the activity. So, my lord, it is under their supervision that, my lord, the greasing has happened, the change of tail seal brushes has happened, and, my lord, it is under their supervision that the maneuvering of the machine has taken place. Because the third complaint was you did not maneuver the machine properly. And, my lord, it is the same set of, my lord, experts who allowed the parallel activity to be continued with, my lord, a similar make TBM of the same make. Well, it is really in these circumstances, your lordship will kindly consider just, my lord, a few, my lord, facets of the report. My lord, may I request your lordship to kindly come to the award now? But your lordship has seen the award. I will be very brief.
Award report. Yes.
Well, that is at volume 2.
Yes. You can refer to the internal pages because we have
Yes,
a separate copy of.
Well, internal page I should refer.
Yes.
Now, my lord, so far as this is concerned, please have a look at, my lord, first, my lord, the portion which deals with the tribunal's assessment. That starts at page 42.
Yes, Mr.
Now, my lord, your lordship will find paragraph 93 at page 42. My lord talks about the assessment of the arbitral tribunal. And now, my lord, at paragraph 93b, Respondent also appointed a consortium of 5 globally reputed engineering consultants as the general consultant. Well, this is very important. For the project, who was required to supervise and closely monitor the project on behalf of the respondent. The duties, responsibilities, and authority of the GC engineer were expressly specified in GCC Clause 2, read with Clause 3.2 and of the SCC. Also, as per the contract, claimant under the GCC Clause 3.4 was mandated to follow the employer engineer's instruction. Now, I shall pause here. I don't need to take it further, because this is the scope of what the GC's role was, and they were therefore to supervise. One will wonder as to why, in spite of the very well-defined role of the GC, they never made any contemporaneous complaint with regard to the tail seal brushes, with regard to the greasing, with regard to the maneuvering of the machine, so on and so forth.
Yes.
And the second very important aspect is, if they were of the opinion that my maneuvering of the machine is faulty, or the greasing is incompetent or insufficient, or the tail seal brushes are of substandard quality, then they should have stopped the operation of the second TBM as well. They were operating under the same contract. Now, second is they now delve on the aspect of ground settlement. Now, here, if your lordship sees, at paragraph 94, incident of ground settlement is discussed. Now, I will not place it because your lordship has seen it. What is important is the tribunal reaches a conclusion that the ground settlement is because of the dispersiveness of the soil, and ultimately is something that could not be foreseen. The tribunal also says if it could have been foreseen, then the GC should have foreseen it. Now this is the second part. Then we go to the expert reports. That is at paragraph 97 onwards. Now, here your lordship will see paragraph 97, following reports are figuring in the entire case at various stages of the arbitral proceeding. So, all the reports are noted.
Yes.
Well, then your lordship will see at paragraph 107, which is at page 69. Well, this is the first report of IIT Madras. Well, this is closer to the incident in 2020. The incident happened on 31st of August 2019. Well, I will not trouble your lordship with this report because this report does not ultimately point any finger whatsoever at the contractor. Then the second report your lordship will find is at page 281, or the internal pages 71. Well, this is the report of the of IAST Shibpur.
Yes.
Now, may I just read this paragraph once?
Yes.
So, here please see that this report is being taken up for consideration. That is very important. Report of Indian Institute of Engineering, Science and Technology, Shibpur on January 22 at page such and such of the Statement of Defense and Counterclaims. This report pertains to the analysis of soil samples and review of pre- and post-incident geotechnical investigation. Disturbed samples were given by KMRCL to IAST Shibpur on 17 December 2021. The disclosed objective of the report was to analyze the soil samples given on 17 December 2021 to IIST, review the existing pre- and post-incident soil reports, comparison and development of soil stratification in the retrieval shaft location with an objective to reveal the parameters to be used for further analysis. As per para 5 of the report, the present investigation was restricted to the 4 disturbed samples given by KMRCL, and the following 5 tests were performed: specific gravity, sieve analysis, hydrometer analysis, liquid limit, plastic limit. Consultant has concluded that it is revealed from all the exploration reports combinedly that the soils available at the tunnel alignment are predominantly sandy silt and very low plasticity to non-plastic nature. The consultant also opined that there is no major variation in soil properties between those reports at various stages and present samples collected from TBM cutter head and tail shield locations. However, as per the written notes, this is where there is a controversy that has been raised by my learned friends. However, as per the written notes of arguments of the respondent has made a statement against counterclaim number 4, saying that the respondent, for the purpose of defending the claims made by the claimant and for effective adjudication of the arbitral reference, required assistance from Dr. John Endicott, Dr. N.K. Pichumani, and Kai Bridges. Apart from the independent experts, the respondent have also appointed institutional experts for reports and views in order to defend the claims made by the claimant in the present arbitral reference. This report is one such listed report as per the statement of the respondent. Thus, this is not an independent report and prepared subsequent to the commencement of the case for the sole purpose of defending the case. This raises the doubts about the intent and evidentiary value of the report. My lord, may I just pause here for a moment? My lord, this is the observation, my lord, that is ultimately hurting me. My lord, now, my lord, the question is, my lord, in view of, my lord, the finding with regard to, my lord, the soil condition, my lord, which ultimately has a direct, my lord, nexus with this report, because, my lord, this report is an analysis of the soil condition. Now, my lord, the tribunal independently, my lord, fairly, my lord, well discussed, my lord, analysis is that the soil condition is something that could not be foreseen.
Mr. Shah, this was a contemporaneous report also or
No,
subsequent?
22.
22.
After 900 days. After more than 900 days. My lord, this is, my lord, of the disturbed sample at the time of excavation. Well, the incident of, my lord, 1919, this is my 2022 report. Now, my lord, so far as this is concerned, my lord, this report, my lord, ultimately is analysis of soil sample. Now, my lord, if your lordship sees this report, which is a part of the evidence, but, my lord, ultimately, my lord, here, the conclusion is that, my lord, raises doubt about the intent and evidentiary value. This is what is doubted. But, my lord, what is important is, my lord, there is a, my lord, well, my lord, discussed part of the award, which talks about the soil condition and concludes that the soil condition is not something that could have been, my lord, easily foreseen. Well, now, my lord, if your lordship, my lord, contradistinguishes, my lord, this part with the other part, the question is, my lord, whether the view taken by the arbitrator or the arbitral tribunal is, my lord, a possible or a plausible view. Because, my lord, when your lordship is testing it on the, my lord, platform of perversity, because, my lord, all the, my lord, patent illegality and my public policy questions boil down to perversity.
Yes.
When your lordship is testing it on the anvil of perversity, the question is, my lord, when, my lord, there is a discussion on the facet of, my lord, the soil condition. And, my lord, there's a contrary discussion, my lord, which only says that the soil samples, we do not find it was very much different from the soil samples that were taken earlier. The question is, my lord, here, will it therefore entail a reappreciation of the evidence? Or, my lord, whether it can be said, my lord, on this, my lord, analysis, that ultimately there is no consideration at all of this evidence. My lord, what is important is, my lord, they see, my lord, the analysis, the sieve analysis, this analysis, and that analysis. First important thing, based on disturbed soil samples provided by, my lord, the respondent itself. Second is, there is no site visit by the IAST Shippool. Third is, my lord, they, my lord, say that we have considered this sample and previous samples and reached a conclusion that they're more or less the
So,
same.
Mr. Shah, you say even if this was considered, then it would not make a major
Possible
difference.
view. My lord, possible view, because, my lord, here your lordships have now, my lord, laid down the test very succinctly. Possible view, my lord, plausible view.
Great.
Now, my lord, the next report, which is very important, is, my lord, the report of IIT Madras. My lord, here that your lordship will find at page, my lord, I'm sorry, no, this is not the report. My lord, yes.
IIT Madras.
Got the page?
Same page.
Yes, my lord. IIT Madras, my lord, at 109.
Same page.
At my lord, same page. Now, my lord, this is the second report, my lord, which the tribunal is guilty of not having considered.
Yes.
Well, at 109, the report was prepared by a team of faculty members from IIT Madras with the help of Dr. G.J. Page, stated to be an expert in tunneling and TBM operations, and all the photographs from the daily progress report of TBM retrieval. The IIT Madras stated in the forwarding letter, and thus it is clear that the water ingress incident on 29th August 2019 is caused due to operational reasons as highlighted in the report. The statement, my lord, this is, my lord, The statement claims was submitted by the claimant on 3rd November 2021, and this report was submitted by the IIT Madras on 17th February 2022. On perusal of the introduction, it appears that this is not an independent report of consultants. IIT Madras studied the geological conditions while the TBM aspects were examined by Dr. G.J. Page. Accordingly, this is the combination of two reports, one by IIT Madras, second by Dr. G.J. Page. As per written notes of arguments of the respondent has made a statement in respect of the counterclaim number 4 on page 105 stating that the respondent, for the purpose of defending the claims made by the claimant and for effective adjudication of the arbitral reference, acquired assistance from Dr. John Endicott, Dr. N.K. Pichumani, and Guy Bridges. Apart from the independent experts, the respondents have also appointed institutional experts for review. Thus, this is not an independent report. Now, my lord, this is the same, my lord, story. Then, please see, my lord, E. This is very important. Moreover, the IIT Madras, in the introduction, has stated that the report has been prepared based on the data supplied and all the photographs from the daily progress report of the TBM retrieval. My lord, TBM retrieval, which happened, my lord, in 2022, my lord, the TBM was cut into pieces and excavated. The tail seal brushes were cut into pieces and excavated. So, my lord, here very important, my lord, E is, my lord, the more telling part. Now, my lord, here what is important is when we talk about E, my lord, up to, my lord, D, my lord, we talk about the experts, and, my lord, we talk about this not being an independent report. But then please see whether E, my lord, talks about application of mind. Moreover, the IIT Madras in the introduction has stated that the report has been prepared based on the data supplied and all the photographs from the daily progress report of the TBM retrieval. It is important to note that as per the scope of work with a letter dated 25th February 2021 of KMRCL, the scope included inspection of affected TBM to study contribution of the component of the machine. Importantly, even though IIT has relied on the photographs of the retrieved TBM, in para 4.2.9 on page 1014 of SOD, the author specifically mentions that the quality of photographic evidence cannot guarantee the accuracy of the comments made by Dr. Lee Blade's report, that is the GC's representative. Hence, the conclusion with respect to TBM brushes is not considered dependable. Also, in the discussions and conclusions at 4.2.10, last para, the report states that the photographic evidence, the tail seal was extensively damaged, either being ripped off when the tunnel segmental lining became skin-bound against the tail skin, or when the grout infiltrated the outer brush seal due to high grouting pressure and low grease pressure or insufficient grease. No basis has been explained for this conclusion. Also, this conclusion is contradictory to the basis of observations about the poor quality of photographs. As per para 4.2.7.1, the sub-para grouting pressure, it is stated that in a large diameter tunnels, the difference in hydrostatic pressure between the crown and invert can be considerable. However, the context of this and the implication on leakage has not been taken anywhere in this. My lord, I pause here. My lord, this shows, my lord, application of mind. And, my lord, on application of mind, my lord, rejection, my lord, of the report on the basis that the photographs are inconclusive, the findings are, my lord, not reached, and no conclusive, my lord, conclusion is drawn. Now, my lord, these are the two reports. Apart from that, my lord, what we have is the observation of the report of the GC itself. My lord, that your lordship finds from paragraph 110. Now, my lord, naturally, my lord, when the GC, my lord, looks at the report, my lord, the GC ultimately, my lord, is trying to also, my lord, protect itself. Because, my lord, GC had certain responsibilities and certain obligations to perform. Now, my lord, so far as the GC's report is concerned,
GC was there, man.
GC was, my lord, an independent, my lord, committee of experts appointed to oversee the project. And, my lord, there's a separate GC contract which runs into several pages, details, my lord, the scope of their activities and pays them hundreds of crores of rupees. Now, my lord, so far as this is concerned, my lord, this now deals with the third report, which is the engineer's report. Now, my lord, this, my lord, has to be taken with a pinch of salt at all times because the engineers were the persons who were monitoring the progress of the project.
Yes.
Now, my lord, here the tribunal again deals with the GC's report, not ignored. my lord, let us see, my lord, how they deal with it. So, my lord, although ultimately they find that there is no evidentiary value to be attached to the report of Shibpur and my lord IIT Madras, your lordship finds that there's discussion, there's application of mind. My lord, perhaps, my lord, a little inarticulately expressed, my lord, because they were not aware of the judgments of Sangyong and my lord, associated builders. But, my lord, nonetheless, my lord, paragraph 110,
Yes.
the background of the report at para A of the report states that KMRCL has formed an expert committee led by Dr. John Endicott, Dr. Pichimani, Mr. Guy Bridges, and Mr. Shuman Dotto. It further states that the expert committee, together with the project director, Mr. Ken Wong, submitted the preliminary fact-finding report to KMRCL on 12th October 2019 in connection with the root cause of the incident happened on 31st August 2019. The report also states further that more than 15 boreholes were done by the contractor soon after the incident, as these were required to ascertain the extent of disturbed ground and soil properties of the disturbed ground for the design of Bobaja retrieval shaft. The TBM-1 was recovered in December 21, January 2022. The GCNA's report has further stated that soil investigation conducted pre-incident and post-incident has revealed that there was no material change on the soil property. 2. There has been no record of any high water pressure. 3. The investigation of the TBM operation records showed that there was insufficient grease being injected into the tail skin to maintain the performance of the seal and stop the ingress of groundwater. The investigation of TBM operation record and inspection of tail seal and brushes after the recovery of TBM-1 has revealed that contractor has incorrectly operated the articulation steering of TBM, which had caused the ring to be forced into brushes, causing accelerated wear, tear, and in some cases, those brushes were lost as the TBM progressed. While the GC accepted the risk of inundation through tail skin, is always a risk in TBM tunneling, he has not been able to give any record of having pointed out any unwarranted activity of the claimant during the current. GC, being an expert in the field with a conglomerate of the best brains in the world, has not produced even a single evidence where GC could foresee the incident based on happening at the ground and raise an alert to the claimant. On one occasion, the GC has even gone to the extent of stating that the GC was not even aware as to when the brushes were replaced on earlier 2 occasions. Since he was present throughout at site, such an argument is difficult to be accepted and can only be considered to shirk away the entire responsibility and pass on the same on the claimant instead of explaining his actions as per the contract conditions and stating the facts. All the actions are a set of reciprocal promises, and the order of such reciprocal promises has to be logical. The GC in the report has also stated that there are no records about the initial flow and there is no conditioned witness statement. This is either lack of monitoring or a deliberate attempt to hide the actual facts and raises doubt on the GC's report. It is also noted that this report was submitted by the GC on 22nd February 2022, almost after a gap of 900 days when the statement of claims was already submitted by the claimant. Even though the claimant disclosed all the post-incident expert views to the GC immediately after the submission of reports, the GC did not react to these reports. The first report, as is evident, was for the purpose of submission to the High Court. No advisory or the supervisory notice or observation issued to the claimant. There was no attempt by the GC to stop the work if so much of stated irregularities were happening at site. Referring to the provisions of GC clause 4.23, the respondent also argued that this provision comes within the purview of accepted matter and is not arbitrable. The claimant correctly pointed out that this provision is to be read as a whole and not in parts. The provision empowers the engineer to certify any reasonable additional cost to which the contractor shall have been put by reason of such condition of unforeseeable physical condition. In the present case, the dispute relates to the applicability of clause 4.23, which is not the subject matter of engineer's sole discretion and is to be considered final and binding. The respondent has referred to clause 4.1, that claimant shall take full responsibility for the adequacy, stability, and safety of all site operations, of all methods of construction, manufacture, and of all the works, irrespective of any approval by the engineer. This has to be read along with first provision of clause 3.4, which makes it mandatory for the contractor to comply with instructions given by the engineer. There is no evidence that the claimant ever defied the instructions of the GC or the engineer who was present at site and steering the project. while AT arbitral tribunal has no reason to doubt the capabilities of the GC, the only plausible answer could be that even the GC was not able to foresee the incident coming. We don't blame the GC since engineering is not a pure science. It is an applied science and all the theoretical steps are required to be weighed from the practical implementation and judgment of experts on ground. There are a large number of empirical formulae which are relied upon in engineering where constants have been arrived based on past experience or past failures. Engineering evolves continuously. KMRCL has employed technically qualified and experienced contractor to execute the project and the best brains in the world to monitor this on their behalf, whose directions to the claimant were mandatory. There is no indication that at any time there has been commission or omission of any misconduct by anyone or the claimant refused to obey the directions of the GC or overruled the directions of the GC, who was deputed by the respondent as the representative. Misjudgment, if at all, happened by the entire set comprising of expert contractor, expert GC, and KMRCL officials was by way all concerned and not the claimant alone, and such circumstance can be defined only as unforeseeable and nothing else. It is thus apparent that this report of GC was prepared solely for the purpose of only defending the stand of the respondent to avoid creating liability on KMRCL. This is evident from the counterclaim number 4, where it is expressly stated that all connected reports relied on by the GC were for the purpose of preparing the statement of defense and not for finding the cause of the incident. The delay on the part of the GC of more than 900 days also raises the doubt about the intent of the report. Well, I shall pause here for a moment. This takes care of this report. All that I want to show that ultimately, there is consideration of the reports. It is
GC report non-consideration was one of the grounds also.
The non-consideration of the
So
report.
that was Shibpur and
Shibpur and IST mainly, not really the GC.
GC is thoroughly considered.
Yes. Now, this is really the entire focus of Mr. Chaudhary's arguments. Because all the other points that have been taken are not really points of concern. In fact, your lordship was really concerned about these questions, and your lordship flagged it to us also, so that we could respond to that.
Yes.
Now, so far as this is concerned, now, the question would be, therefore, what would amount to ignoring vital evidence? Because these are the expressions used, in the judgments of associated builders, Sangyang, and so on and so forth. Ignoring, in my respectful submission, would be, I do not consider it at all. But here you will also find that there is consideration. To what extent elaborate considerations required is again a matter of your lordship's opinion on the subject. But here your lordships are not sitting here to give opinion. Your lordships are here testing the perversity of their word. Now, with greatest respect, I will not trouble your lordship with the judgments that Mr. Chaudhary has cited because
Mr.
we have
Jha, before moving on to that,
Yes.
now perversity, non-consideration, there's a shade between non-consideration and consideration, but discarding or refuting on irrational grounds.
That's it.
I mean, why should that also come within perversity?
That's it. Now,
One may very well argue that suppose the tribunal says that I have the report, I consider the report, but I don't like the paper on which it is printed. This is a
yes.
but that can be done also. But then there is a consideration, there is a refuting of the report, but on a ground which is not appealing to a prudent mind.
That's it.
Now here if the AT only said that look, this has been prepared at the behest of the respondent, they appointed the commissioner, for that reason only I'll overlook it.
Well, that would be wrong.
Only that would be wrong, but you say that there was independent consideration also.
Well, that independently would be wrong because here, your lordships are testing it on the anvil of natural justice also. Now,
Very limited
today,
extent,
yes,
but yes.
If today, I offer a piece of evidence and that is brushed aside without any consideration of any nature whatsoever, then that would be wrong.
Any consideration worth the name?
Yes, worth the name.
There,
Yes, worth the name. Worth the name.
there may be a consideration, but
Whatsoever is not right. Worth the name.
Yes.
Worth the name.
yes.
Now, importantly, the tests that your lordship have devised to answer these sort of situations is whether this would ultimately shock the conscience of court.
Yes.
Here I come before the tribunal with an argument. My argument is considered and rejected is one thing, but jettisoned without consideration is another thing.
Yes. Yes.
So that is the test of shocking the conscience of court. Secondly, your lordship has seen here that the interpretation of the contract. because the tribunal says that I find from the contract that the GC has been appointed. I find from the contract that GC has been assigned a role. I find from the contract that GC has been assigned a responsibility. I find that they have not raised any contemporaneous disputes with regard to compliance with their directions, taking into account their observations, etc., so on and so forth. Then the question is whether thereafter the refutal of that piece of evidence is within the purview of the jurisdiction that the tribunal is legitimately entitled to exercise. Because the question is error of jurisdiction and error within jurisdiction. Now, the next part of it is when your lordships are now talking about public policy and patent illegality. Then ultimately your lordships are looking at whether there is perversity, because your lordships have now also laid down that if there is an error of law, that in itself is not good enough to set aside.
Definitely.
So the question of perversity is the question that looms large. Now, all the decisions that Mr. Chaudhary has relied on, he has not cited the decision relied on in its note. They are of the general propositions with which we are very familiar. Amongst the propositions are non-consideration of terms of a contract. You ignore a contract because you are the creature of a contract, and then you proceeded to render an award which is contrary to the terms of the contract. Bad. Ultimately, you misconstrue a contract in a manner in which no reasonable man could have done so. Bad. But when you consider a contract, and you reach a conclusion which is a plausible conclusion of the contract, then that is acceptable.
Yes.
Now, in this context, I shall rely only one judgment, which is perhaps the latest in the whole line of judgments on the subject. This is a 2025 judgment. Na, এটা কিছু দিন ওকে 2025 ভলিউম 2 আছে না আপনি অনলাইনটা দিচ্ছেন ও এসসিসি টা নেই না ঠিক আছে অটোমেটিক দিন আই হোপ দ্য পেজেস প্যারাগ্রাফস ম্যাচ well may I just hand it up?
Yes, you have a copy or
Yes, I have a copy. Well, I have the SCC copy. This is SCC online copy. That is the only problem.
no difficulty? No.
Should match. Paragraphs should match.
No. What is the other citation?
No, the other citation is 2025 volume 2 Supreme Court cases, page 417. Now, here, if your lordship will see paragraph 168 first, then I shall come back to paragraph 74. I hope it starts the same way. That should be, of course, the page number.
No, there is no paragraph 168. It ends at page 152.
May I might have discovered the SCC copy. No, এটা দিয়ে ওইটা SCC. এটা এত মোটা কেন?
Yes, exactly.
One side, both sides. I think that is the difficulty.
Oh, yes. It is fair. Please erase the.
Yes.
No, I have tried to fail. Yes.
Well, at
Page
page
168.
521, paragraph 168.
No, but that ended at para 152.
Yes, I don't.
That cannot be explained by both sides.
I'm
don't know.
equally perplexed.
Anyway, let us forget that. Better to shred it. Better to shred it. I mean, not for any other reason, because you may be citing it before some other court and be embarrassed. Yes. 168, Mr.
Paragraph 168.
Paragraph 168.
Well, we have given due consideration to the above submission. In our view, a distinction would have to be drawn between an arbitral award where reasons are either lacking or unintelligible or perverse, and an arbitral award where reasons are there but appear inadequate or insufficient. In a case where reasons appear insufficient or inadequate, if, on a careful reading of the entire award coupled with the documents recited or relied therein, the underlying reason, factual or legal, that forms the basis of the award is discernible or intelligible, and the same exhibits no perversity, the court need not set aside the award while exercising powers under Section 34 or Section 37 of the 1996 Act. Rather, it may explain the existence of that underlying reason while dealing with the challenge laid to the award. In doing so, the court does not supplant the reasons for the arbitral tribunal, but only explains it for a better and clearer understanding of the award.
It is rather opening up the scope of 34 a bit.
It does. It does, my lord. Ultimately, my lord, it attempts to, my lord, draw a distinction between, my lord, award. My lord, this is the important, lacking or unintelligible or perverse, or, my lord, where the reasons appear to be inadequate or insufficient. This is, my lord, the distinction. My lord, my lord, dare say that, my lord, the recent judgments have created more confusion than have cleared it.
Yes.
Well, including the, my lord, last judgment where it, my lord, seeks to ultimately say that, my lord, an award can be, my lord, reconsidered by the court.
That, Mr. Shah, least said the better.
I am, my lord, completely perplexed. And, my lord, in fact, my lord, the dissenting view of Justice K.V. Vishwanathan is perhaps, my lord, what
Better.
makes some sense. Now, my lord, if your lordship will see this, my lord, this therefore is only, my lord, I have cited this only for the purpose of saying that, my lord, if an award, my lord, gives, my lord, insufficient reasons, or, my lord, is ultimately, my lord, not explained, my lord, to the extent it should have been explained, then perhaps, my lord, the court can even supplant that, but not, my lord, really change it. It will not, my lord, it is only clarificatory in nature.
Cannot supplant that.
Sorry, it is only clarified.
Clarificatory. Yes.
Clarified that. Now, my lord, if your lordship, now please have a look at, my lord, paragraph 74 onwards. My lord, this ultimately is really a reiteration of all the principles that have been stated before. My lord, I will not really, my lord, like to trouble your lordship with this, but, my lord, this ultimately goes on to recount. My
The
lord,
legal assistants have a very difficult task in Supreme Court.
I'm sure. I do not know, my lord, to what extent they're expected to perform these tasks, because, my lord, times I'm surprised whether, my lord,
It will be evident from the judgments.
yes.
The
Well,
role and extent of jurisdiction of the.
Yes, and, my lord, with the cut copy paste age, my lord, things have become, my lord, so much easier and so much more, my lord, dangerous.
You can only pray that our jurisdiction is not merged with Singapore.
Exactly. And, my lord, if your lordship, my lord, recent, my lord, newspaper report.
That's why you
Yes,
that's why I said. Twice.
Not one, 3 awards.
Twice, but the second one it was taken off the website.
Yes.
Link was sent. I went tried to go there for obvious curiosity, but could not
It
find.
is very embarrassing.
Page is not found.
Very, very, very embarrassing. Very
You don't
embarrassing.
practice what you preach, Mr. Shah.
And, my lord, ultimately, when we are trying to make India an international arbitration hub, well, if this is what, my lord, ultimately is brought to light, I don't know, my lord, how we really show our faces. My lord, when, my lord, our arbitrators are part of international tribunals.
We don't understand the major difference between a hub and a hubby. One will tolerate, the other will not.
My lord, in fact, well, I was, my lord, telling Justice Shonji Banerjee, my lord, when his lordship was, I'll just, my lord, take a 1 minute on their side.
Yes, yes, sir.
My lord, when, my lord, Justice Banerjee was still, my lord, presiding over the, my lord, Shillong High Court, Meghalaya High Court, Shillong.
Oh, you went there to move.
Yes, I was doing a matter before his lordship.
Yes.
My lord, then his lordship, my lord, called me to the chambers after the
Obviously,
matter.
yes.
And, my lord, in the course of discussing, his lordship was, my lord, deliberating on what to do after retirement. And I naturally suggested arbitration because, my lord, I have known his lordship for a long time. And I suggested that, my lord, he is required, my lord, more particularly in international forums, because I have seen how poorly our Indian arbitrators fare in international forums, because, my lord, they are completely overawed by, my lord, the foreign members of the tribunal. So, my lord, we needed a person who can hold his own. Even, my lord, persons who have, my lord, retired from the Supreme Court with a great deal of reputation, my lord, while sitting in international arbitration, they've just completely collapsed. And, my lord, the international tribunals are not free from bias at all. So, my lord, I was just telling his lordship that, my lord, we need a person, my lord, who will be able to
Hold his ground.
yes, hold his ground. And, my lord,
Absolutely.
when, my lord, we are looking at such situations and then we come across reports where, my lord, these awards are set aside as being, my lord, ultimately carbon copies. but then it becomes.
Plagiarism is the worst kind of an allegation which should come against a
No.
judge.
Students will suffer the consequence of plagiarism. Their papers will be cancelled. They will be failed in their exams. But my lord, the similar consequences do not visit my lord.
Every time I go to a lecture, Mr. Shah, I mean, disoriented after the lecture. You cannot compare the two. What happens, the ground reality and what is said on the podiums. So it's all glitz and show more than groundwork.
And my lord, today,
But the system is attuned to that. The system is tuned like that, Mr. Shah. I mean, should not say this in open court, but Mein Kampf, Hitler's. Now there was a beautiful statement there that once a mediocre person goes, a B grade person goes to a particular place, he'll ensure that B and C come in. He'll ensure that A does not come in. And that was his argument against democracy, which I could not, discard. Mein Kampf goes Ori midway. After just the middle of it, his own thing. But he was so logical, and
well, that is why he had
analysis of democracy was too good.
That is why he had an entire nation following him.
He has an intellect. He had an intellect. If it was correctly guided, I mean, brilliant intellect.
I could only start reading Mein Kampf. I could never complete it.
After halfway, when I saw what was coming, and same I did with Nirotsi Chaudhury's Passage to England. When I read there that the intellects of UK or that part of the world is more three-dimensional because the weather is three-dimensional, something like that. I mean, because in tropical countries it's stark sunlight and all. So the mentality is also three-dimensional. Because of that, I stopped there. And I could not tolerate it anymore.
Well, when you don't receive too much sun for most of the year, well, these things happen.
Yes. The shadowed delivery of the tropical sun is required sometimes.
That is a nice expression.
No, Shakespeare, Morocco, Prince of Morocco.
Oh, I don't remember my Shakespeare so well.
This is squarely plagiarized without the quotes. This is pure Shakespeare. No, it was in our syllabus. That's why. I don't read so much otherwise. Yes, Mr. Please. So page 74 onwards.
74 onwards is the general discussion. Lot you'll find Dyna Technologies.
Yes, is the usual.
On the question of what is reasons, how much reasons is reason, and how much is not reason. Well, all these are discussed. So I don't intend to.
The beauty of your argument, Mr. Shah, is that you know where to draw the line. I mean,
no, there's no point. Your lordship, will be hearing the same arguments over and over again.
Unnecessary.
No yes. Irritating the judge, if I may use that.
Not that, but unnecessary.
So, these are my submissions. If your lordship wants me to, only if your lordship wants me to, I can prepare a very, very short and concise note and hand it up.
So that I don't miss out on anything.
I'll try to do it before the vacations.
Do that, then I'll have the vacation for you.
Grateful.
Thank
you.
Nothing. Reply.
Grateful, my
reply, Your Lordship, after vacation, a short reply maybe.
Not really. It's a continuing matter for quite some time.
Actually, Chaudhary is engaged in some other quota.
You cannot keep it after that. You are passing it over. Let him come.
Your Lordship.
Passing it over. I want to conclude it now. Or I'll keep it on the last day, last Friday.
He's not there actually, Your Lordship. He's
He has to come today. Where is he engaged? Which court?
No, he's not in Calcutta.
No, he came. He's there. He came just now.
We'll keep it after this.
He came.
Yes. So what do you do, Mr. Shah? Then
I leave it to your lordship.
we'll keep it after the vacation. You can file a written notes whenever you like. I mean,
in that case, I shall file it immediately on the reopening, if your lordship.
Yes, we'll keep it after that. The first Friday also.
Grateful.
I'm grateful, Your Lordship.
Third Learned Senior Counsel appearing for the respondent, pushed up on the prayer of the appellant, in order to enable the appellant to give their rejoinder reply, let the matter stand over till June 13, 2025, the first Friday after reopening.
I'm grateful, Your Lordship.
Please come prepared with the written notes also.
Your Lordship.
I'm not saying anything in my order. Please come prepared. I'll
Your Lordship.
take those on.
Your Lordship.
Thank you. What? আচ্ছা এটা ঢুকবে হ্যাঁ থ্যাংক ইউ এটা একটু স্টেবল করে কোথাও রাখতে হবে। হুম। এই লিস্টটাও দিয়ে দিলাম তোমাদের না এখানে আছে এখানে আছে
Lordship, I'm appearing for the petitioner. I'm led by Mr. Joyanto Mitro, senior counsel. He's on his legs with another. I'm praying for.
So Bose has been waiting for this matter for quite some time.
No, no.
They have been coming in.
My lord, before I begin, I must tell your lordship.
First you
Then-
take your breath. So,
No, no, it's okay. There are two. Ye de tako, junior this. There are two matters. Setting aside of a
Ma'am,
award.
please be there. Please be there. He has to have somebody with him. Otherwise he cannot appear.
There are two matters. Setting aside of an award. In one of them, hearing was concluded. Mr. S.N. Mukherjee had made submissions. The second matter was identical. You just wanted to know the page numbers. Mr. Bachawat started. And so I don't know who will be addressing when I finish. Only thing, prayer from Mr. Joyanto Mitro, me, is next. If you want to, if it spills, then please don't keep it on 23rd. And so I really want a response because you don't want it piecemeal.
So it's better keep it on 13th then.
My lord, that is entirely for your lordship. But if they complete, because I would be taking, say, half an hour, I'll finish by 12. But the question is whether the other side will complete, because it's up to until 1:15, I guess.
Not even 151, I have another division.
So, my lord,
Up to 1.
on that basis, whatever your lordship feels, because that's what we discussed yesterday with Mr. Mitro.
Then Mr. Bose, for the sake of continuity, let us keep it after the vacation. or-
That is entirely for your lordship. It's just that we are here eager to do the matter and finish it because we had made our submissions. Yes, as long as we are not praying for any adjournment, let it
No,
not
no,
be recorded.
I'll record that here.
That the other side is not present, at least.
We'll record that.
That is for your lordship, my lord, and that is all, my lord.
None appears for the respondent, although the appellant is
he's here, he's
represented
here.
through
Malad, he's
counsel.
One of them has
None
come
appears
panting,
for
huffing,
We
and
start today. Would you be able to finish today?
So can we come back?
On your
after-
prayer.
Yes, on my prayer.
On the prayer of the respondent, the matter is adjourned till
heart attack hobe.
No.
June 13, 2025.
Hobe.
Please give all the news. Yes.
He's carrying
They're eating so much, na? In this weather, how the juniors can eat in lunch so much is something. I mean,
Yesterday there were 120 club kachoris in the World Library Club. It was finished in half
this
an
is
hour.
not good.
Distributed among how many?
Amongst
No, no, upstairs it doesn't come down. They also
come down
No,
here?
no,
that's-
no. They
that-
bring
that-
some of
that
them.
is the
I
hand
said,
side.
I
Cup
mean,
kachoris, how much can you consume?
Lord, he had 10. He had 10.
Yes, the metabolism of a
my lord, no, in this weather it's not good. And he has,
I had 3.
he has a history. I mean,
I'm
from
history from grandfather.
I always say, his father is also worried. No, he's told me. I mean, what is this?
all right. But he's a surprise. His metabolism must be extremely
Well,
good.
yeah. Good batting.
We have a very good name for him, which I can't disclose.
My lord, so, your lordship, it's
On
on
13th.
13.
First Friday after.
Yes, 13. Fine.
So
Very
great.
good.
My please, Lord. I am appearing for the award holder, my lord. So there is also section 34 application filed against us, my lord. They were to make submission on that, my lord.
My lord, I appear on behalf of the petitioner. My lord, Mr. Pradeep Chandra was making arguments in the matter.
Yes.
My lord, actually, he's not well today, my lord. So we're just requesting if the matter could be posted post vacations. They have their vacations in June, my lord. So if it could be posted any date in July, my lord, we could come and finish with our arguments.
July would be too late. July would be too late. July would be too
They
late.
have their vacations, my lord, in June. That's the only difficulty. Otherwise, I wouldn't have made that prayer, my lord.
How does what does that have to do with our court?
My lord, he's the arguing counsel in the matter. He was arguing.
If he
the
has a
matter
vacation
before
there, it will be easier for him to appear before this court.
But he'll be out of the country during that. Our courts open
That cannot
on
be a
10th.
consideration. That cannot be a consideration. We can keep it immediately after reopening of court of our court. We cannot take into consideration the Supreme Court's vacation for fixing our matters. Sorry. Absolutely not. You have to change counsel then. That's not a valid prayer. Please don't make such prayers before this court. Just because the Supreme Court will be on vacation and the counsel who practices in the Supreme Court is appearing and he'll be abroad, that is not a good law. We can only consider our High Court's vacations. Sorry. So give us a date when you shall keep it. You are for the petitioner. Section
Under
30.
those circumstances, my lord, would keep it post the reopening. On
Post
any given
reopening, then we will keep it post. Learned counsel appearing for the petitioner seeks an adjournment till the month of July 2025. Full stop. However, such long adjournment is refused. Full stop. In order to enable the petitioner to move its case, comma, the matter is postponed till June 13, 2025, when it will be listed under the same heading.
Grateful. Grateful, man.
June 13 won't be
Yes.
the last week of this month.
You are appearing, ma'am, in this matter 11?
Yes, ma'am.
Yes.
9.
9, forget 9. 11, none appears for the parties at the time of call. Let the matter stand adjourned till June 13, 2025.
Milord, item number 12, I'm appearing on behalf of the petitioner. This is my section 11 application, Milord.
Lords, I appear.
Lords, may
I appear for respondent number 3 to 9, Milords.
Milord, may I file the affidavit in reply? Milord, I am led by Mr. Jishnu Chaudhary.
You have filed your
Milord, he's
opposition?
Lords, my opposition.
You have filed.
I filed an application. Yes.
No, have you filed any opposition? No.
I have not filed any application. I have filed an application. My simple point in the application is, my lord, this is a commercial dispute. My lord friend should have filed this before the commercial division.
Yes, what do you say to that?
Milord, we
decide
have
that first.
There was no direction.
It's a legal argument also basically on the
Milord, it's an
papers are there.
argument, Milord, I'm led by Mr. Chaudhary. We'll make submissions on this
Jishnu
point.
Chaudhary or Shobhoj?
Mr. Jishnu Chaudhary. Milord, he's on legs, Milord, today. Your Lordship keeps it on the other side of the vacation. This has been pending for some time, Milord. We are otherwise ready. We'll.
Very well. The affidavits in opposition and reply filed to be kept on record. Full stop. You are for respondent number 1 in the learned counsel appearing for the respondent number 1 in the main application under section 11 of the Arbitration and Conciliation Act 1996 seeks to press GA1 of 2024, comma, which challenges the jurisdiction of this court to take up the matter in the sense that it is argued that the dispute pertains to a commercial dispute and as such ought to be heard by the appropriate court having jurisdiction to take up such matters. What was it? Dispute?
Into a purchase of a
No, wasn't this assigned to this court?
No, my lord, this was before your lordship, and your lordship had determination. This is part heard before your lordship.
Part heard this.
Your lordship was hearing my learned.
Right. Accordingly, let G on the prayer of the petitioner in the application under section 11, comma, let the matter stand adjourned till June 13, 2025. First of it is made clear that on the next returnable date, comma, GA1 of 2024 shall be taken up first. The June 20, June 20.
Grateful, my lord.
On the prayer of learned counsel for the petitioner and the respondent number 1, the matter is adjourned till June 20, 2025. First of it is made clear that on the next returnable date, comma, GA1 of 2024 shall be taken up first before proceeding further with the hearing of AP 167 of 2020.
Grateful, my lord.
Lords, just for an indulgence, Lords, a copy may be served upon the respondents.
Please serve everything on
2 to 9.
everything on everyone.
My simple point is,
Serve it to them also.
for my lord,
They can also they also have a right of hearing on everything.
Grateful, my lord.
Grateful.
Oh, sorry.
13, my lord, Mr. Tapas Kumar Dey is appearing on behalf of the petitioner, my lord. My lord, as instructed by his clerk, my lord, I'm to pray, my lord, short pass over, my lord.
What do you mean by short pass? Mr.
Well,
Mitra has
I
to
would
get
pray for
long pass.
a short adjournment because one of my learned junior has been elevated to this honorable court on the bench. So, my lord, I am in this predicament.
When should I keep it, Mr. Mitra? You have to.
Anytime after the vacation, so that I can make alternative arrangements.
Should I fix it on June 13th, which is the first Friday available after the vacation?
My lord.
That will be about we reopen on Monday, and that will be the first Friday.
Well, Lord, can it be on the next? Because
The
I
Friday
should be
after
coming back on the 30th.
for the 20th then.
20th.
My lord.
On the prayer of learned counsel for the parties, the matter is adjourned till June 20, 2025. 20th June.
Deeply obliged.
Your Lordship, I appear for the petitioner in this matter. Your Lordship, this is that matter where we challenged the order of the Calcutta Stock Exchange. Mr. S.N. Mukherjee is leading me. He had concluded his submissions. And Mr. Anirban Ray was making his submissions
Yes.
for the Calcutta Stock Exchange, Your Lordship. That's Your Lordship's last order of 17 January 2025, Your Lordship.
None appears for the respondents at the time of call. Push up. It is pointed out by learned counsel for the petitioners that on the last occasion, the arguments of the petitioners was concluded.
Lord, no, Your
In
Lordship.
item 14, my lord.
Yes.
Yes, my lord,
14.
Mr. Ray was on the other side. He was to complete his arguments.
Yes, yes. Push up next para. যেখানে ছাড়লাম ওখান থেকে next para. It transpires from the order dated January 17, 2025 that none had appeared for the respondent stock exchange on the said date as well. Full stop. It was further made clear that the arguing respondent should be present on the returnable date. Full stop. However, even today, none appears for the respondents at the time of call. Full stop. Next para. As a last chance to the respondents to complete their arguments, the matter is adjourned till 13th June. 13th June.
Very well, my lord. Very well. Very
June
well.
13, 2025. Push up. It is made clear that in the event the respondents remain unrepresented on the returnable date when the matter is next called on as well, the arguments may be concluded.
I'm so grateful.
Grateful. Arguments may be closed.
Grateful. My lord, kindly pardon me for my late entry, my lord. I couldn't join on the election.
No,
Grateful.
it's all right. No difficulty. Yes.
My application.
Yes, Mr. Ganesh.
But Mr. Omnaran Ray was the other side, but now Justice Omnaran Ray was my other side.
Then,
but to be honest, I would also not be. I'll come back after. I'll give them another notice, and then come back after the vacation.
We hope Mr. Rai, Justice Rai was not the advocate on record.
No, he was.
No.
The advocate
they didn't
should be
align for
present.
Should have been here.
Yes, yes. None appears for the respondent at the time of call, although the petitioner is represented through counsel. Full stop. We'll put it on them. You are
for civil. So the bank is.
আচ্ছা যেখানে বলে although none appears for the respondent বললাম, none appears for the respondent bank. Full stop. Next para. Accordingly, let the matter stand adjourned till June 13, 2025. Great.
Thank you. Lordship, item number 16, I appear on behalf of the competent authority.
For the petitioner, Lordship.
Here for
325. Lordship, I am for the petitioner in this matter. I seek for a very short passover if possible, Lordship.
Short passover means nothing.
Lordship, I am led by Mr. Vishwarup Bhattacharya in this matter. He's on his leg before court number 3.
Court number 3 is Justice?
Gaurav Kant. Honorable Justice Gaurav Kant. Gaurav Kant, sir. I apologize.
Let passover. Passover.
Grateful, Lordship.
None appears for the parties. Let the matter stand adjourned till after the upcoming summer vacation of this court.
My lord, Mr.
For whom?
Rohit
For whom?
for
Not
the
for
respondents.
Respondent.
Mr. Rohit Banerjee is appearing for the respondents since he is not able to come to court.
My lord, I appear for the petitioner, my lord. May I have my lord's kind leave to appear virtually, my lord?
Yes,
This
yes,
is my, my lord, this
yes.
is my Section 11 application, my lord.
Mr. Rohit Banerjee for the other side is seeking adjournment to his junior, Mr. Sen. What do you do?
My lord, I cannot stand in the way, my lord, when a senior seeks an adjournment, my lord.
On the prayer.
One indulgence, my lord. Possibly, my lord, I'm speaking for Mr. Banerjee as well on the last occasion.
After.
My lord, an affidavit direction may be given, my lord, because I'm certain, my lord, they will seek an affidavit in opposition, my lord. May that be given so that it's complete, my lord, so it's ready for hearing once the court.
Very well. We'll keep it on 20th.
I'm very
well. Then
I'm very
affidavit in
grateful.
opposition. Very well. So an adjournment is sought on behalf of the respondent. Full stop. Learned counsel appearing for the petitioner rightly submits that in order to expedite the matter, comma, directions for affidavits may be given. Full stop. Accordingly, the respondent, one respondent or several? Respondent is directed. Respondent is directed to file its affidavit in opposition by May 23, 2025. Full stop. Reply, if any, shall be filed by June 13, 2025. The matter shall next be listed on June 20, 2025. Please file your opposition, if any, within a week. Tell me, sir.
Grateful, my lord.
Thank you.
I'm deeply obliged, my lord, deeply obliged.
Thank you, Mr. Chair. Yes. None appears for the parties at the time of call. Let the matter stand adjourned till after the upcoming summer vacation of this court.
Lord, I was praying for Lord adjournment. I'm in the process of obtaining change, my lord, in the matter, my lord.
Oh,
and for the petitioner, my lord, some papers have come, but the entire paper has come.
On the prayer of the petitioner, let the matter stand adjourned till June 13, 2025.
Deeply.
Appeared for the State Bank of India.
Yes.
Well, I think this writ petition has become infractious because they are really agree by the the denial of natural justice in connection with the master circular fraud. The company was declared under the master circular fraud. What has happened, subsequently, show cause notice was issued to the company and its directors. Thereafter, the show cause they replied to the show cause notice. Then, the show cause notice was revised. They also gave a reply to the revised show cause notice, and thereafter, a final order has been passed.
So then this has become infractious.
We have filed, my lord, I am appearing for CBI. My lord, we have
CBI.
Yes, we have filed an intervening application as we are not party to this.
But Mr. You are for the petitioner.
No, I am also for CBI. GA1 is our application.
I can hand over to Lordship.
So then if the application has been rendered infractious, then we can record Mr. Lahiri your
this bunch of papers.
So we can keep this on record and say that this has become infractious. Consequentially, your application also becomes infractuous.
Yes, because according to, as I, my lord, gathered, subject to correction from my learned senior friend Mr. Lahiri, that it reached finalities.
Mr. Lahiri, at what stage had they come up in this challenge? They had challenged what?
They challenged it prior to this. Lordship looks at the date of affirmation of the petition.
No, what did they challenge? The show cause notice itself?
No. They challenged lack of show cause notice. They said that this cannot be done without following the principles of natural.
They had been declared fraud, classified as fraud. That was reopened and a new show cause notice given.
Show cause notice was given, What has happened, their grievance was that the account has been declared as fraud.
Yes, without show cause. Without hearing them.
Without hearing. They wanted the Supreme Court guidelines to be followed in case of Rajesh Agarwal's case. Now, the writ petition was affirmed in the month of, these are all later developments. The writ petition was affirmed in the month of
15th of May 2024.
15th of 2024. The first show cause notice was given, Lordship, and it looks at the bunch of papers, 10th April 2024. This was suppressed in the writ petition. Be that as it may, Lord.
But they had been.
They have given.
No, they were. How could they be classified as fraud before that?
Well, this was reversed, my lord.
That is what I'm asking you. That was reversed and fresh.
Then the fresh.
The we'll record it and dismiss the application as improper.
Lordship kindly comes to me, lord. Looks at a bunch of papers, my lord. Show cause notice, reply to the show cause notice, then, my lord, a revised show cause notice, reply to the revised show cause notice,
Sir Lahiri,
then we'll final order.
you have handed over documents, you are submitting something. Should I disbelieve that?
No, I'm just.
You have handed over the documents, you have submitted, that is sufficient.
My lord, only.
Lordship only can look at the last order, 20th December.
So they have been declared as fraud again after hearing.
Yes.
We'll record that only. And I will keep this on.
That's the order dated 20th December 2000. The last document. 20th December, reasoned order. 20th December 2024. SBI letterhead. Has been also got it. Reasoned order.
Yes.
And only one thing.
Yes.
If your lordship kindly permit me, I want to add, my lord, what fell from my learned senior.
So, like, you are for the SBI.
SBI. My lord, so far the judgment of this becomes infructuous, no doubt. So far the judgment of Rajesh Agarwal is concerned, my lord, it has been subsequently taken aback with a judgment of the Honorable Supreme Court. My
Sir,
lord.
Mr. Mitra, please hold it with you and please just apprise us when some other matter is taken, because that will be relevant, important for us to advocate.
Yes.
Now, my lord, only one thing I must point out here: the petition is Prakash Chandra Agarwal.
Yes.
But the focus was given to the other directors and the company, not Prakash Chandra Agarwal.
Prakash Chandra Agarwal also.
No,
The
Prakash Chandra
last
Agarwal.
one in the 10th April 2024. Prakash Chandra Agarwal's name is also there.
Yes, but in the last order, my lord, that was
Huh,
passed on 20th December 2024.
Yes.
Here, my lord, Prakash Chandra Agarwal's name doesn't occur. But according to me, that doesn't matter because the Supreme Court's guideline was give notice to the borrower. Prakash Chandra Agarwal is not a borrower. We gave notice to the borrower.
But if he's affected,
he replied.
Mr. Lahiri will do this. We'll record your submission. We'll give them another opportunity. We'll ask your learned advocate and record to give a notice to their advocate and record. We'll keep it whenever you say.
After vacation.
Whenever you say. After vacation, we'll keep it. Then or next Friday is the last Friday.
Next Friday also, Lordship may keep it.
We're keeping it for that purpose.
I have
An
some
hour to
difficulty.
bring an
my lord.
early end to
You're for the petitioner.
No, my lord. I'm appearing for Reserve Bank of India in the matter.
Yes, right.
Yes.
Next
But,
Friday, I have some difficulty, 23rd. If it is, my lord, after reopening any date, my lord.
We are keeping it after reopening. We are recording
Yes.
Lahiri's submission and
Yes, my lord. Because 23rd also I have got some personal difficulty.
very well. Mr. Lahiri, apart from you, everyone is going out of town. What are you doing?
Miller, today, Miller, something has happened. The car was parked before the number 11, Miller. Car is in room number 11. So,
Chunk has fallen.
Glass has fallen from
Oh
above.
my God.
And Miller, the windows of the car has been
Your
broken.
car.
I'm just now hurt.
But that is very risky then. We may go down anytime.
Anytime, Miller. I understand there was a glass from room number 17.
Oh.
He has shown me the picture, Miller, and there's a total Miller.
Very risky.
Anyway, Miller, my submission is
yes
that Supreme Court's order in case of 2023 SCC order required notice to the borrower. Order didn't require, Miller, notice to all the directors and other persons that may be affected. Now, we have given notice to the borrower.
But if you declared the director also as in the capacity of a director as classified as fraud.
Fraud in relation to the company, not in relation to a particular director.
But he's also affected as a director because
He
the
says
fraud,
he's
he's also labeled as fraud. I mean,
No, he's not. Only the company.
Only against the company.
Only the company. Not the directors.
We'll give them one chance, Mr. Lahiri, if they have something to argue on that. We'll record his submission. Learned Senior Counsel appearing for the State Bank of India submits that in view of subsequent developments, the present writ petition has been rendered infructuous. Push up next para. It is submitted that although the writ petition was filed sometime in May 2024, there was a prior show cause notice issued on April 10, 2024, which was suppressed in the writ petition.
And reply thereto was given.
First up, reply thereto was also given by the noticees.
Advocate.
First up, next para. Subsequently, there was a revised show cause notice, to which also replies were filed. First up, thereafter, it is submitted, there was a fresh hearing and reclassification of the company as fraud, double inverted mode, under the concerned master circular of the Reserve Bank of India. Full stop, next para, learned senior counsel hands over certain documents in support of his contentions. Full stop, next para, learned counsel appearing for the CBI seeks to intervene. Full stop, however, comma, since a question has arisen as to whether the writ petition itself has been rendered infructuous, comma, uh, for the sake of, for the ends of justice, comma, an opportunity ought to be given to the writ petitioner to ventilate its stand. Full stop. Accordingly, the learned advocate in record for the State Bank of India is requested to serve a notice on the learned advocate in record for the writ petitioner, indicating that the matter shall be listed under the heading to be mentioned on June 13, 2025. Full stop, it is made clear that in the event, comma, despite notice, comma, none appears for the petitioner, writ petitioner on the next occasion, comma, appropriate orders would be passed in the absence of the writ petition.
Well, only one thing, Lordship can record my submission. We have passed a reasoned order. Supreme Court wanted a reasoned order. We have passed a reasoned order.
যেখানটায় বলেছি classified, reclassified as fraud with a reason order. Reclassified as fraud with a reason order. It will appear as to be mentioned on the next day so that we can take it up early.
And Milord, it's parted today. Lord, kindly makes it parted.
No question of parted. It will appear as to be mentioned. And that's why I have recorded at length your submissions. Whoever takes up the matter, if I am not there also, then no, I have to take up the matter. This was assigned to me.
Yes.
Specially
Yes,
assigned.
Your Lordship. It was any which way specially assigned.
I mean, this High Court or in profession, I'll have to take up this matter. Yes.
Grateful, Your Lordship.
Milord,
22, you are appearing also. Oh, similar.
yes.
Same
No, no, not similar. 22, Milord.
Yes.
They are challenging the LOC.
Achha.
And regarding LOC, Milord, the
But petitioner has to be there.
No, Milord, question is, Milord, I tell you, Lordship, Milord, there's some time. Milord, the Supreme Court, I find, Milord, Bombay High Court struck down the LOC. And
No, Justice Patel's order.
Yes,
So Justice Patel's order, I have some reservations because
Interim order.
entire that notification, probably with utmost respect to Justice Patel's erudition, could not be struck out. But the grounds, actually, Mr. Lahiri, the government or the authorities, immigration authorities, they have to have a larger say in the matter. Because you are just acting as a post office.
Yes.
That is the difficulty.
Would
Whoever the bureaucracy thinks that yes, this person should be roped in, they are sending a request and you are issuing an LOC. You have to be more careful on that. You have to have a role in the notification. You have to have a layer of adjudication there to see whether it's a fit case for that, or it is being used as a means to realize the dues.
Milord, this point has got to be explored, Milord.
That I have stated before many forums, but nobody listens. Mr. Lahiri, you can tell your client. I mean,
this is the order passed by the Supreme Court.
Supreme Court has taken that
appeal. No, it was not taken it. But very cryptic order. I am also not satisfactory. I don't. But Lordship looks at the order of the Supreme Court against the interim order.
Because repeatedly, Mr. Lahiri, we have been, we are having to set aside on the ground that it is not satisfying the conditions of the LOC criteria.
Yes.
But if you had a say in that, probably it could be improved. I mean, many matters would not come to court.
Milord, here what the Supreme Court has done, Milord, it has simply, Milord, quoted the findings of the Bombay High Court and said that since the writ petition has been finally disposed of, this appeal, which is carried from the interim order, is no longer, Milord, having any force in it. This is the Supreme Court.
Justice Patel's order no longer has any force.
Milord, I do not know whether it's from Justice Patel's order or some other order. Milord, it is an appeal carried in respect of an interim order of the Bombay High Court, passed in respect of LOC. I mean...
No, Justice Patel's order was probably a final order. It was set aside.
This is Justice Patel's order, Milord. I am carrying Justice Patel's order.
Yes, that was probably the final adjudication, wasn't it?
I think so, Milord. It is so elaborate in its scope and effect.
Justice Patel won't be so naive to at the ad interim stage to set aside. He's an extremely erudite person.
I think, Milord, it was finally disposed of.
Could have been.
And then the Supreme Court has passed this order. Since the writ petition has been finally disposed of, no further point in keeping the SLP pending from the interim order.
Oh, so then this was against the interim order.
The interim.
But whether this has been challenged subsequently, we
Well,
don't know.
that is to be seen, Miller.
But this you have much scope of argument whether the entire notification should be set aside because the government has that much leverage. Should have. This is a delegated legislation in a sense.
Realistically, as I could understand, the courts have really gone that these are all done by an administrative office memorandum. There is no set down law on this point, no statute on this point. And how these rights of the citizens to be governed in the absence of a clear statutory direction.
That's
should
very
be left in
debatable.
the hands of the executives. Well, these are the points, Miller, to travel the courts, Miller.
But probably the notifications put in some guidelines. If the guidelines are given there and the office member and the government has the power, it's very debatable. We'll look into this, but for that we need the petitioner first, writ petitioner.
These also may come along with this other one.
Yes.
After the
Mr. Lyrie, you keep your judgments for the time being. We'll take those when the time comes. None appears for the writ petitioner at the time of call. Although the respondents are represented through counsel. You are for respondent numbers 5 and 6.
State Bank of India.
Only Pramanik is your advocate on record.
Yes.
Then 5 and 6 is in the list. Although the respondent numbers 5 and 6 are represented through counsel, accordingly.
My lord, I am appearing for respondent number 3, Reserve Bank of India.
3, 5 and 6. Accordingly, let the matter stand adjourned till June 13, 2025. Yes. 3, 5 and 6.
June 13.
No, তুই mention না এটা normal হ্যাঁ এটা hearing special আছে
The first
আরেকটা
one is
পাস ওভার ছিল না
June 13 দুটোই কোর্ট
the first one is to be mentioned.
first one to be mentioned that is independent
Yes.
from this. Yes.
Well, both will be listed on June 13th.
June 13th. First one has to be mentioned. This one we don't know whether this will be taken up or not.
Actually makes it part of Miller date.
No.
Specially assigned.
It's specially assigned, Mr. Lyrie.
Oh, yeah.
I cannot avoid.
Yes.
These matters, all of these I cannot avoid.
Yes.
I'll have to take up.
But
Yes.
Yes.
Lordship,
Yes.
competent authority.
You are consistent, but they have changed.
They have changed. Your Lordship, I am appearing for petitioner. I am led by Mr. Bishuru Bhattacharya. He is.
You were led by Mr. Bhattacharya in the morning also, but you asked for passover. So you start the matter now.
I was in other court. My another colleague took the time. I am praying.
What is the matter about?
It's against irregularities against a competent board of board. Respondent number
passed by the competent authority.
That
and
confident. Mr. Chaudhary is, Mr. Bhattacharya has become a specialist on that.
Yes, Your Lordship.
Well, then we'll adjourn it till after the vacation.
And
An adjournment is sought on. An adjournment is sought. Yes, sorry.
They are seeking adjournment for last 3 days.
no, Your Lordship. This is not correct.
In this matter, affidavit has been
This is
exchanged.
not correct.
Board of manager has been changed. Nothing.
Oh.
Board of managers has been changed, but there were some irregularities
They
which
filed another
they have.
before
We have
Justice
sought
Sinha-
for.
Before Justice Sinha, Justice Sinha sent it to again to competent authority and competent authority.
That has been filed by separate residents, Your Lordship.
But against the same in the same subject
That,
matter.
no, not against the judgment matter.
Last for
Po-
last
after
two-
after
You are for
the
respondent
judgment,
numbers?
I'm respondent number
after the judgment passed on
Respondent
14th of
numbers?
May.
Board of managers, 3 to 5.
An adjournment is sought on behalf of the petitioner, Pushab, learned counsel appearing for the board of managers, opposes the prayer and submits that repeated adjournments are being sought on behalf of the petitioners. Pushab, next para. For the ends of justice, comma, a last opportunity is being given to the petitioners to move the matter. Pushab, let the matter stand over till June 13, 2025. Pushab, it is made clear that in the event on the next occasion when the matter is called on for hearing, comma, none appears for the petitioners or any adjournment is sought on behalf of the petitioners, comma, the matter may be dealt with in the absence of the petitioners. Appellate side session. Did I record anything that they none appears or something? What was the order?
নামটা নিয়ে নিন।
No, then don't. Yes, for which one? Appellate side?
Yes, Your Lordship, both of us are guilty, is the other side.
The
11,
appellate side?
item 11, when it was called.
Original side?
Original side.
Yes.
So
What did I do?
it is a short matter. One matter can be.
No, what did I, what order was passed? Some order was passed.
Yes, I think it was in June list.
13th June it has been fixed.
Yes.
No, both all sides are represented.
Yes, yes.
Nobody is left out.
Nobody is left out. And we both just missed the bus at that.
No, 13th June আপনি নিয়েছেন ওটা? 11 না? কে নিয়েছে? তাহলে ওটা যেন না ছেপে দেয় তাহলে। Then I'll hear this matter. I'll take up this matter right now.
Lordship.
তাহলে 11 নম্বরটা কল। ওকে যে নিয়েছে 11 নম্বরটা একটু বলে দেবেন যে যাতে এটা না ইয়ে করে, না রেকর্ড করে। শুনছি এটা। 11 নম্বর ফাইল। বসুন। Yes, Mr.
Yes, section 11 application.
Right.
This clause is at page 101.
Yes, 101.
If I may read this clause, Your Lordship. At the bottom, yes. All disputes, may I read it, Your Lordship?
Pretty wide. Pretty wide.
Yes.
The cover. Yes.
And on 103,
yes.
If I may read that, all disputes and differences between the parties hereto regarding the construction or interpretation of any of the terms and conditions herein contained or touching these presence or determination of any liability shall be referred to the arbitration by the arbitrator appointed by the court under the provisions of the Arbitration and Conciliation Act or Arbitration and Conciliation Amendment Act 2015.
This is a misnomer because court does not have any power. Court under the act is the
That is the point which I had argued it on one earlier occasion.
So this part should go, but your intention to go to arbitration is clear.
Yes, and I have come fortified this time, Your Lordship, with how court can this.
There is no provision under which the court under this act can.
Yes, I will just.
It can once he is appointed, remove subsequent stages. Yes.
No, Your Lordship.
29A maybe.
Your Lordship, the power emanates from the agreement between the parties.
Yes, yes.
And I have to place the judge section, Your Lordship. There are non-obstantive and unless otherwise agreed. So, Your Lordship, this has been interpreted by Supreme Court. I will just have to place that judgment. That in that case, the paramount intention of the parties that court should appoint will have to prevail.
Oh.
Yes.
You are for the petitioner here.
I am for the petitioner.
So that is against you in a sense.
That's
how can the court do it? It's the High Court Chief Justice under Section 11 who can do it.
Yes. So I have made an application under Section 11.
You are on the right side. That is what I am saying.
Yes.
There is no provision for the court under this act. The court under this act is the principal civil court of original jurisdiction.
Yes.
There is no provision in the 96 Act, Mr. Gupta, for the court to appoint an arbitrator unless it's at the 29A stage or subsequently.
Yes.
Court can replace an arbitrator subsequently. But
Yes.
there is no provision in 1996 Act for the court, the district court, the original court, to appoint an arbitrator for the first time.
But by agreement,
therefore, this clause has two parts. The parties agree to go to arbitration, and that arbitrator should be appointed by court.
Right.
So we should read down the second part because it's contrary to the first part. It militates against the first part. If there is something in the second part which renders the first part nugatory, your intention to go to arbitrator nugatory, then that extra clause should go. So this court part will ignore. We'll say that
arbitration may be arbitrator may be appointed.
Yes, arbitrator has to be appointed.
Yes.
You have to argue on that.
Yes,
there is no provision for the court to do it, right? So then we have to read the intention of the parties was to go to arbitration.
Lordship,
then this part, the second part should go, that the court should appoint. We can constitute this to be the High Court.
My contention is Section 21 notice has not been served upon me. File an application for the Section 11. Until and unless Section 21 application has been served, the question of limitation.
Then we will come back in 5 minutes.
Yes.
Yes. You take your objection first. I think that will be better, Mr. Gupta, so that you can answer comprehensively. There was no notice, previous notice.
Notice under section 21 has been served upon me.
Yes.
But this is a mandatory provision. If your lordship kindly come to the section 21, this is specifically incorporated that commencement of arbitral proceeding unless otherwise agreed by the parties, the arbitral proceeding in respect of a particular dispute commence on the date on which a request for the dispute to be referred to the arbitration is received by the respondent. Now, your lordship, I cited only one judgment. But in this judgment, it is specifically incorporated that if the section 21 notice has not been served, limitation for filing of the section 11 application does not commence. Secondly, what claim has been made by the claimant regarding the arbitral proceeding, that has not been noted by the respondent on the basis of that section 21 notice if this is not served. If your lordship kindly come to paragraph 17 of this judgment. Seventeenth at the judgment at this stage, the section 21 of the State Act pertaining to the commencement of the arbitral proceeding.
Paragraph
17.
Yes.
Commencement of the arbitral proceeding. And now, your lordship kindly last line, unless there is a request for referring the dispute to arbitral, it cannot be said that arbitration has been invoked by a party. On the paragraph 17, last line. And next paragraph 18. 7 line. The limitation is to be calculated for filing such an application under section 11 of the State Act. Until and unless section 21 notice has been served, the commencement of the section 11 limitation regarding section 11 does not arise. Section 21 of the State Act, it is contested that come of the consideration of the judgment relied upon so and so. The Supreme Court has observed that the application under section 11 for the appointment of the arbitration cannot be filed only after a notice.
Where are you reading?
The paragraph 18.
Yes, 18. Yes.
This has been discussed in detail in the context of the point from where the limitation is to be calculated for filing such an application under section 11 of the State Act. So, section 21 notice is a mandatory until and unless that has been served. When section 11 application does not lie. Now, your lordship, next paragraph 19, subparagraph 31, middle portion, after 4th line, the mere fact that the parties have named the arbitrator would not imply that the parties have agreed to waive the requirement of the notice contemplated under section 21 of the State Act. The notice under section 21, as we have seen, serves definite purpose. Now, your lordship, kindly come to paragraph 25.
Yes.
Hence, considering the position of the law, clarifying of the court in this case, kindly come to 1, 2, 3, 4, 5, 6, 7, 8, 9 line. Hence, unless there is a request by a party that the dispute is to be referred to arbitration, merely stating the claim and dispute in the notice would not suffice. And the last paragraph 26, last 2 line. Therefore, merely because there is an arbitration clause, it cannot be said that the court ought to exercise jurisdiction under section 11(6). Therefore, my contention is, until and unless section 21 notice has been served upon the respondent, section 11.
Let's come to section 21 once. unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. If both parties agree and they say that, yes, we want to appoint arbitrator, we want to start from that date. But it's a question of a further notice. Then also a notice is to be given. That would be a peculiar understanding of the section. But yes, you are right. Not under section 21, but section 11 itself contemplates such a situation. Please come to section 11.5. 11 subsection 5. 11 is self-contained.
Yes.
11.5 says failing any agreement referred to in subsection 2. So 2 says parties are free to agree on a procedure. There is no procedure here. Failing any agreement in an arbitration with a sole arbitrator, if the parties fail to agree on the arbitrator within 30 days from a receipt of a request by one party from the other party to so agree that the appointment shall be made on an application such and such. So there has to be a request under section 11.5. And within 30 days, you have to wait for 30 days. If within that 30 days, there is no such appointment, then you can take resort to 11.
Yes.
So section 21, I very respectfully differ with the view of the Bombay High Court that even if the parties agree, that would be a futile exercise. You and I agree that let's start arbitration on such and such date. We have to give a notice to the arbitrator only. You need not say that, yes, we agree, but you still give in writing and I'll just sign it. That's a futile exercise. That's why this clause is there unless otherwise agreed. Section 21 notice need not be given as a prerequisite of section 11. But yes, section 11.5 notice has to be given. A request has to be made because this mandate of 30 days starts from that. Section 11 is not dependent on 21. It's entirely independent. 11 nowhere refers to 21 even. But 11.5 itself says that if parties fail to agree on arbitrator within 30 days from receipt of a request by one party to so agree to an appointment.
Yes.
Therefore, under section 11.5, there has to be a request that are you agreeable to appointment of such and such?
And that notice has also not been served.
You can argue that. On that I'll hear Mr. Gupta.
Yes.
So section 21 notice is something else. Anyway, principle is a section 11.5 because otherwise we can't calculate the moratorium for filing 11.
Yes.
You have to leave 30 days from that request. But you have to argue on this also. This does not say request in writing. If they have pleaded something that there was a request, we can go easy on that because the purpose of the statute is in favor of arbitration. It's entirely skewed towards arbitration. So you have to the courts interfere as little as possible and relegate parties to arbitration if they have an intention to arbitrate. So we cannot throw a spanner in the wheels if there is a chance of facilitating arbitration. Well, we take your judgment and we'll hear. This is your objection, only objection. Yes, Mr. Gupta.
You're much obliged, Your Lordship. The point about the unless otherwise agreed part which Your Lordship has
That is there, yes.
that is settled. I will not go into
But
that.
section 11.5 you have to overcome.
Yes, I have a judgment of the implication on that part, unless otherwise agreed, which I will only cite if required.
No, you cite it, Mr. No difficulty. Give the reference for your learn.
It's 2022-9 SCC 286. So the head note, Your Lordship,
Yes.
says it. Yes. So I am just referring to it. It's well settled.
2022?
22-9 SCC 286. So the paramount intention of the parties will prevail when it's the section begins with unless otherwise agreed.
Yes.
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 Now I'm coming to that part. 11.
Yes.
Yes. So now I will actually
11.5 stand.
No, 11.5. If I may join issues, your Lordship, on that count.
Yes.
I will actually read 11.6, which is applicable in my case. 11.6,
Hmm.
where under an appointment procedure agreed upon the parties, here again. And here an appointment procedure is agreed, which is approach the court, which is there in the clause itself. A party fails to act as required under that procedure. B, the parties or the two appointed arbitrators fail to reach an agreement expected of them under that procedure. C, a person, including an institution, fails to perform any function entrusted to him or it under that procedure. All three not applicable in my case. Then I continue, Your Lordship. The appointment shall be made on an application of the party by the arbitral institution designated by the Supreme Court in case of international commercial arbitration, now, Your Lordship, or by the High Court in case of arbitrations other than international commercial arbitration, as the case may be, to take the necessary measure unless the agreement on the appointment procedure provides other means for securing the appointment. So here again, same situation, Your Lordship, that it has been an appointment procedure agreed, and High Court will now appoint simply the arbitrator. So 11.6 will apply in my case. And here, Your Lordship, another on a different aspect of it, they have agreed to this. It's a sale agreement, and now they are not handing over the flat, Your Lordship. So this part payment has been made. About 42 lakhs has been paid.
This is the development agreement which contains
Yes,
the
Your Lordship.
Agreement for sale. Agreement for sale.
This is an agreement for sale. Yes. And this is very clear. So Your Lordship may appoint the.
Yes, what do you say? Reply.
My lord,
Because I started with you, therefore you have to have a reply on this judgment also.
my lord, section 11.5 is the mandatory provision until and unless that notice has been
But
served.
11.5 as rightly argued by Mr. Guptu, this is not an 11.5 scenario. This is an 11.6 scenario.
Yes.
Where there is no prior contemplation. Because 5 says failing any agreement referred to in subsection 2 says parties are free to agree on a procedure.
Now,
Yeah, his argument is the procedure was that the court will appoint.
yes, my lord, kindly come to the arbitration clause. All dispute and differences between the parties here to regarding the construction of the interpretation of any terms and condition herein content to or touching this present or determination of the liability shall be referred to the arbitration by the arbitrator appointed by the court. If the court will be appointed arbitrator under section 11, then previously notice was maybe served upon the respondent.
There is no provision for the court. The language used here is to be appointed by the court under the provisions, quote unquote court, under the provisions of the 96 Act. 96 Act defines court as the original principal civil court having original jurisdiction.
Yes.
That is the district judge. There is no provision in the Arbitration and Conciliation Act for the first appointment of an arbitrator by the court under this statute. The district judge cannot appoint an arbitrator. The scope of a court, the language court, is used only from section 29A onwards for the first time. 15 also, certain circumstances may be read with 29A. In those circumstances, court can replace an arbitrator, substitute an arbitrator.
Yes.
But first appointment has to be made by the Chief Justice of a High Court. So it's specially mentioned court under the provisions of the Arbitration and Conciliation. Court is defined in Arbitration and Conciliation Act not to be the Chief Justice. 11 is an exception.
Yes.
11 is an exception which does not refer to court. It refers to the Chief Justice of a court in certain cases, or otherwise, if it's international, then Supreme Court and all these things. Chief Justice of the concerned High Court.
Yes.
Not court, and court is defined. In section 2, court is defined. Court is
Principal
defined.
civil court of the district.
Yes, yes. So therefore, so we have to read down this provision by excluding the requirement for the court to do it.
And if that is so, my lord, then my contention is the until and unless they serve a notice regarding the appointment of arbitrator,
What is your answer to 11.6? 11.6. No, 21. If court appoints an arbitrator under section 11, then 21 is given a go by. Where is the scope of 21?
Yes.
Unless otherwise agreed by the parties, arbitral proceedings in respect to a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. Two interesting questions have been raised in the present application under section 11 of the Arbitration and Conciliation Act 1996 within bracket for short, comma, double inverted, the 1996 Act, double inverted closed, bracket closed, full stop. The arbitration clause contained in the development agreement, comma, which is relied on by the petitioner, comma, provides that all disputes and differences between the parties thereto regarding the construction or interpretation of any of the terms and conditions therein contained or touching those presents or determination of any liability shall be referred to the arbitration by the arbitrator appointed by the তারপর within double inverted পুরোটা block letter court double inverted close under the provisions of the Arbitration and Conciliation Act, 1996 and stroke or Arbitration and Conciliation within bracket amendment bracket closed Act 2015. Full stop. Learned senior counsel appearing for the petitioner argues that since there is no provision for the court, comma, as defined in section 2 of the 1996 Act to appoint an arbitrator, comma, the said provision ought to be read as an intention of the parties to refer the dispute to arbitration. Full stop. It is contended that in such a situation, comma, there is no prior requirement for a notice under section 21 of the 1996 Act. Full stop. Learned counsel, learned senior counsel cites নামটা এখান থেকে দিয়ে দেবেন আমি সাইটেশনটা বলে দিচ্ছি such and such reported at 2022 9 SCC 286 in support of the proposition that wherever the phrase double inverted unless otherwise agreed by the parties double inverted close is used in various sections of the 1996 Act, comma, including section 21, comma, it indicates that it is open to the parties to agree otherwise than what the statutory provision in question provides for. Full stop. Next para. Learned counsel appearing for the respondent opposes the application and contends that a notice under section 21 of the 1996 Act is a mandatory prerequisite of a reference being sought under section 11 of the 1996 Act. Full stop. By placing reliance on the said provision, comma, it is argued that the arbitral proceedings in respect of a particular dispute commences on the date on which a request for that dispute to be referred to arbitration is received by the respondent. Full stop. Hence, comma, it is implicit in the provision that a notice under the said section is mandatory. Full stop. Next para. Learned counsel cites a coordinate bench judgment of the Bombay High Court in the matter of এইখানে নাম্বারটা আছে এখান থেকে দিয়ে দেবেন in an unreported judgment where the learned single judge, comma, inter alia, comma, observed that unless there is a request for referring the dispute to arbitration in the context of section 21, comma, it cannot be said that arbitration has been invoked by a party. Full stop. By relying on a judgment of the Supreme Court reported at 2021 5 SCC 705, comma, it was observed that in the context of the question of limitation, comma, there has to be invocation of arbitration under section 21 of the said act. Full stop. The mere fact that the parties have named the arbitrator would not imply that the parties have agreed to waive the requirement of notice contemplated under section 21. Full stop. The learned single judge went on to observe that the party to the arbitration agreement against whom a claim is made should know what the claims are. Full stop. Next para. Learned counsel further argues that in the present case, no such prior notice was given, and as such, comma, the scope of disputes on which arbitration is sought cannot be ascertained. Push up next para. Upon hearing learned counsel for the parties, comma, it is seen from the provisions of section 11 of the 1996 Act that the same is a self-contained provision. Pushed up. I do not find within the four corners of section 11 any prerequisite being stipulated for a prior notice under section 21 to be issued. Full stop. In subsection 4 of section 11, comma, in a scenario where the appointment procedure in subsection 3 within bracket applies and a party fails to appoint an arbitrator within 30 days from the receipt of a request to do so, comma, a reference under section 11 may be sought. Full stop. Next para. Under subsection 3 within bracket, comma, failing any agreement referred to in subsection within bracket 2, comma, in an arbitration with 3 arbitrators, comma, each party shall appoint 1 arbitrator, and the 2 appointed arbitrators shall appoint the 3rd arbitrator, who shall act as the presiding arbitrator. Full stop. As such, comma, the situation contemplated under subsection 4 within bracket requires a mandatory prior notice stroke request, comma, only after 30 days from which an application under section 11 can be made. Full stop. However, comma, the conditions stipulated in subsections 3 and 4 of section 11 are not met in the present case. Full stop. The only other prerequisite stipulated in section 11 for a prior request is in subsection 5, which provides that failing any agreement referred to in subsection within bracket 2, comma, if the parties fail to agree on the arbitrator within 30 days from receipt of a request by one party from the other to so agree, comma, an application under subsection 4 within bracket shall be made. Full stop. Subsection 2 of section 11 provides that the parties are free to agree on a procedure for appointing the arbitrator or arbitrators. Full stop. Next para. It is conspicuous that the present arbitration clause does not contemplate on 3 arbitrators being appointed, comma, as such, comma, precluding the operation of subsection 3 and consequentially subsection 4 in connection therewith. Full stop. Next para. Subsection 5 within bracket, comma, on the other hand, comma, only comes into operation if an agreement is not existing between the parties under subsection within bracket 2, comma, which relates to a prior agreement on the procedure for appointing arbitrator. Full stop. The said scenario is also not attracted in the present case, comma, since in the arbitration clause in question, comma, a specific procedure was provided for appointment of an arbitrator. Full stop. As such, comma, there is no prior requirement in the present case for a notice under notice stroke request to be served before moving the High Court under Section 11. Full stop. As rightly contended by learned senior counsel for the petitioner, comma, the present situation is governed by subsection 6 of Section 11, comma, which provides that where an appointment procedure is agreed upon by the parties, but a party fails to act as required under that procedure, comma, the appointment shall be made, comma, on an application of the party, comma, by this court, comma, in a case as the present one. Full stop. Next para. It is conspicuous that subsection 6 does not stipulate any prerequisite of a prior notice stroke request for appointment of arbitrator, comma, as opposed to subsections 4 and 5 of Section 11. Full stop. Thus, comma, in the present case, comma, it is the pleadings in the application under Section 11 which are required to be looked into to ascertain the scope of the dispute between the parties. Full stop. The judgment of the Bombay High Court is not applicable in the present case, comma, since the provisions of Section 11 within bracket 6 do not require a prior notice. Full stop. The consideration in the judgment of the learned single judge of the Bombay High Court was more around the starting point of limitation, and in such context, comma, the requirement of a notice under Section 21 of the 1996 Act. Full stop. The question which has fallen before this court was not under consideration before the Bombay High Court. Full stop. Rather, comma, the ratio laid down in Delhi Airport Metro Express Supra is applicable. Full stop. Also, comma, read in conjunction with the object and purpose of the 1996 Act, comma, it is well settled that the courts shall interfere with the process of arbitration as little as possible, and it will be the endeavor of the court to facilitate arbitration, comma, rather than throwing a spanner in the wheels of the arbitral process. Full stop. Next para. The Supreme Court, comma, in unambiguous terms, comma, held therein that if there is an agreement between the parties, comma, the arbitrator shall be bound by the same, and where in sections of the 1996 Act, comma, the phrase double inverted unless otherwise agreed by the parties double inverted clause is mentioned, comma, it is open to the parties to agree otherwise than what the statutory provision in question provides for. Full stop. The other question which remains to be considered is, comma, in the teeth of the arbitration clause providing in the present case that the appointment has to be done by the court within the contemplation of the 1996 Act, comma, we find from Section 2 I find from Section 2 within bracket 1 within bracket small e of the 1996 Act that in case of domestic arbitrations, comma, the expression double inverted court means the principal civil court having original civil jurisdiction in a district. Full stop. Next para. However, comma, throughout the 1996 Act, comma, there is no scope of the first appointment of an arbitration by the court as contemplated in the said Act. Full stop. The operation, the invocation of jurisdiction of the court under the said statute comes into play only if there is a question of substitution of arbitration under section 29-A or any other similar provision in the 1996 Act. Full stop. Next para. It is only section 11 which permits a court of any sort, SORT, to appoint an arbitrator. Full stop. Section 11, however, as opposed to the expression double inverted court, double inverted clause, uses the expression Chief Justice of the concerned High Court. Full stop. It is to be kept in mind that there is a gulf of difference between the Chief Justice of the concerned High Court and a court, double inverted মধ্যে, under section 2 within bracket 1 within bracket small e, that is the principal court having original civil jurisdiction in a district. Full stop. Thus, the second limb of the arbitration clause in the present case, being unworkable and militating against the intention expressed in the first part of the parties to submit themselves to arbitration in case of a dispute, the second limb of the arbitration clause should be read down. Full stop. Construed in such fashion, the arbitration clause clearly provides that the disputes as raised in the present application are squarely covered by the said clause, and as such, there is no impediment otherwise to refer the matter to arbitration. Full stop. In such view of the matter, there is no impediment of the matter being referred to arbitration. Full stop. The scope of the dispute is can readily be inferred from the averments made in the application under section 11 itself for the respondent to apprise itself of such scope, without there being any prior requirement of a notice under section 21 of the 1996 Act. Next para. Hence, AP 164 of 2024 is allowed on contest, thereby appointing, give a name, what is the valuation? I mean, what should an advocate or what? You can agree to someone.
It's about 1 crore.
96 lakhs 49,000
Should he or she be a senior advocate or a judge or whatever you say?
Senior advocate.
Judge.
Senior advocate.
You say judge.
Any district judge, you know.
District judge, we are not aware. Can you give it?
Very well, your lordship.
You can appoint some. You can agree on a name of any senior advocate. There are so many senior advocates now, even in this court. So you can agree on anyone.
I think it's
as your lordship.
Your lordship, yes.
Well, appointing Mr. Anindam Banerjee, a senior advocate, as the arbitrator to resolve the dispute between the parties, subject to a declaration under section 12 of the 1996 Act being obtained from the said learned arbitrator. Full stop. Anything else is required? The remuneration of the arbitrator and the procedure shall be decided in accordance with the provisions of the 1996 Act.
Deeply obliged.
Thank you. Good. আরেকটা বই ছিল, হ্যাঁ একটা বই, এগুলো কি কোর্টের দুটোই? শুরু তো করি, 10 মিনিট আছে। মেনশন এগুলো অ্যাটলিস্ট হ্যাভেলসের লিস্টে তো নেই আমার কাছে। আপনার কোর্ট অফিসার কোথায় গেল?
অর্ডারটা দাও, পুরো অর্ডারটা দাও, পুরো অর্ডারটা দাও।
আরে লিস্ট একটা দিন আমাকে। আপনাদের লিস্ট আছে? মেনশনে কল করুন।
Yes.
My lord.
On that side, yes.
Oh, sorry.
Same matter.
Yes. Well, these 4 matters have stood assigned before your lordship because of this order. I'm sorry, my lord. Now
Because of which order? If I
this
knew, I
order which
wouldn't
has
pass.
been passed by Justice Joyshen Gupta. Now, Justice Joyshen Gupta passed this order because of your lordship's order, which was passed in a CBI proceeding, my lord. So now, my lord,
So this will appear.
my lord, we have one request, subject to what your lordship would indicate.
Yes.
The issue is that the next date before the lower court is on Wednesday. Mr. Luthra, Mr. Siddharth Luthra will be appearing in this matter. Tuesday, he has some personal difficulty because of a medical issue. His wife is undergoing chemotherapy. So, Marat, if it could be fixed on Monday at any time, because Wednesday is the next date, and we're expecting there would be coercive process issued because of
These are ex parte matters.
these are ex parte matters, so
fresh
we do
matters.
not need to serve in terms of motion.
Monday কিছু আমার fixed আছে 10:30
No, if your lordship keeps it at anytime post 2, your lordship places your lordship's list.
No, 10:30 would be all right for you.
Well, at 10:30, your lordship
Difficult.
knows Delhi. It's not us.
2 p.m. তাহলে
2 p.m.,
তো আছে
3 p.m., whenever it suits
fix
your lordship.
fix নেই তো। তাহলে this will appear at 2 p.m. on Monday. 19th. 19th, 2.
Grateful, man.
Most
Great, great.
My lord, kindly permit
Bracket
me
at
to
2 p.m.
mention.
বলে দিয়ে দেবেন ওটা, হ্যাঁ? Yes.
My lord kindly permits me to mention, I have already mentioned this recalling application which I have preferred. I mentioned it on 8th of May.
আসছে না কেন?
At that point of time, my lord was pleased to fix this matter today, my lord. My lord kindly sees. I have preferred a recalling application and the impugned order.
1 minute.
The point, my lord,
We have
once
to take one unless the matter is released from that list, we cannot take up the matter.
then first I have
So
to
appearing in the
release-
list of their lordship.
My lord, my lord, my lord.
Can I
My lord, I
snatch it from the other
My lord,
court?
I'll
You should mention
mention
there
it
and
there,
get it released
my lord,
first.
my lord.
You have to ascertain. You had to ascertain. This is embarrassing for us. It's
My lord,
appearing
my
in some other court. You are going on mentioning, and you are saying, insisting that I had mentioned it is not appearing. Mention before that court where it is appearing.
My lord.
My lord, permission to mention one matter for inclusion. My lord, I've mentioned this matter.
What is the
before.
matter? Application or
Review matter, my lord.
review application?
Review application, my lord. I've mentioned this matter before, my lord. Your lordship is allowed, but the matter is not in the list. my
আসেনি
lord.
কেন? Gone out of the list.
It is not in the list, yes, my lord. Not,
কেন?
it's not
আসেনি
appearing
কেন?
in the list. Second, may I have mentioned your lordship has allowed this, my lord.
দেখে দিন, দিয়ে দিন লিস্টে।
My lord.
আপনি একটু যেটাতে সিঙ্গেল বেঞ্চ তো একদিনই বসে যদি না আসার সামনে পরের ফ্রাইডে পর্যন্ত ওয়েট করতে হবে। এনশিওর করুন যেন আসে পরের ফ্রাইডে। 1 কি করে ডাকছেন? Yes.
But I'm opposing this, my lord. My lord, a bizarre situation has happened. I am, my lord, the plaintiff in a suit for recovery of possession and mean profits. Now, my lord, I have obtained a decree at the first appellate stage for recovery of possession. To execute that decree, I had filed an execution proceeding way back in 2008. During the pendency of the execution proceeding, a second appeal was preferred, my lord, by the unsuccessful defendant. In that second appeal, conditional payment of certain amounts were directed. They could not match the condition, and therefore I executed the decree for recovery of possession. I have got back possession. Subsequently, my lord,
these are assigned to me. These were
this is assigned to
cut from the other list.
General
assignment.
General assignment. Then, my lord, then, my lord, in that decree which I had got for recovery of possession, there was also an entitlement to get mean profits, for which I applied under Order 22. There I got a decree of mean profits, including interest up to the date of vacating, but I did not get, my lord, interest pendentility and future interest. Being aggrieved, I filed an appeal before this honorable court. only for the purpose of enhancement of that additional interest penalty and future interest. During the pendency of that appeal, Namlord, after that, the judgment debtor himself had filed an appeal before a wrong court, that's the Alipur court, owing to pecuniary jurisdiction. Subsequently, he withdrew it. And
appeal against the mean profit decree.
Yes. Now, that appeal against the mean profit decree has now been dismissed on contest by the Honorable Division Bench of this Honorable Court. In the impugned application, in the impugned order, when I had put the decree for mean profits into execution, I had applied for attachment. In that, the Honorable Court has been, the learned court below had been pleased to direct a writ of attachment, my lord, to be issued.
There's a difficulty. I have a division bench to Justice Bishas at 1. So it's already 1, Justice Bishas is there. So we'll continue after the recess. I have 2 p.m. fixed matters.
Vacation report.
But those 2 p.m. fixed matters are contempt regular. Contempt rule issued. So immediately after that, I'll continue with this matter.
I have a 2 p.m. fixed matter before the Honorable Division Bench.
If that is over before this matter, not over before this matter is over, then you can ask for an adjournment.
Or can we come back later?
No, no. Let's now.
Next day.
Next day would be perhaps after the vacation.
Why after vacation?
Only one Friday left.
Or last Friday, yes. Due to paucity of time, the matter cannot be completed today. Accordingly, on the prayer of learned counsel for the parties, let the matter stand adjourned till June 13, 2025.
Grateful. Obliged.
Your Lordship, kindly see last order, my lord, dated 25th of April, my lord. That is non-compliance, my lord, para 4, my lord.
I am for the contender.
Till date, my lord, no adjustment, my lord, regarding my lord pension.
Yes, my lord. My junior is there, my lord. I would ask him to hand over the one document which will reveal that the PPO has already been dispatched, but it is in transit at post office, my lord. From at post office there. Mr. Partho will hand over the
copy. That is postal communication only. No documents has been, my lord, annexed. This
The document is coming through post. How could we annex it until we receive it? The PPO number is there, my lord. From bottom third serial, the PPO dispatch number and date on 9th of May 2025.
Yes.
It was dispatched.
The Chakravarti will keep it on the first Friday after vacation. If it does not reach within that area, then maybe you'll have to implement the postal authorities also in the one.
Yes, my lord. New party, my lord.
So much trouble in giving pension to someone.
AG Bengal culture also not.
AG Bengal, my lord, very difficult. They were not even providing us this paper also.
Yes, we can
After
understand.
much persuasion, kindly see the
We
one
can understand
we have
your
made.
predicament. I mean, as counsel.
Yes, my lord.
Learned counsel appearing for the petitioner submits that till date no PPO in respect of the pension of the petitioner has been handed over. As such, it is submitted that stringent measures should be taken against the alleged contemner in terms of the order dated April 25, 2025. Learned counsel appearing for the alleged contemner hands over printouts of email and postal documents indicating that the FPPO, that the pensionary benefit has been authorized in favor of the petitioner vide capse FPPO নাম্বারটা এখান থেকে দেখে টুকে দিলেই ভালো হবে, ভুল ভালো হয়ে যাবে তাহলে, and has already been released with a speed post on May 9, 2025. Puts up next para to await the service of such postal article, comma, let the matter stand over till June 13, 2025, when it will be listed under the same heading for passing appropriate orders. The printouts handed over in court today be kept on record. Full stop copies thereof are also handed over to the learned advocate for the petition. এইটা দেখে একটু এইটা হবে, এই নাম্বারটা শুধু, এটা না, এইটা আমি বলে দিচ্ছি একবার। 142518925 stroke capital P stroke 25 stroke 11 stroke 470746.
চ্যাট বক্সের থেকে নামগুলো নিয়ে নেবে, স্পেলিং গুলো ঠিক করে দেখে নেবে।
Lordship, I beg to appear for the petitioner, Your Lordship.
Yes.
Lordship, the alleged contemner is present.
Yes.
Would I appear for the alleged contemner?
Yes. What was the nature of contempt?
My lord, complaint was lodged against a member of the Bar Council.
That was not disposed of.
That was not disposed
The
of. My lord,
explanation, Mr. Dutt.
my lord, to be very honest, my lord, there is no explanation to offer. I can only pray, my lord, if your lordship gives us 2 months' time.
Why 2 months? Some explanation has to be there, otherwise he's guilty of contempt.
Yes, definitely, my lord. I will not.
He should be penalized at least. Some fine should be imposed.
My lord, your lordship considers whether it is deliberate or not.
Why not deliberate? You say there is no explanation.
Explanation in the sense, my lord, for not complying with the order.
Lordship,
what is above the law, Mr. Dutt?
Absolutely, absolutely.
That message should go. Yes.
Moreover, my lord, I am a member of the judiciary, my lord. I have to, my lord, uphold the majesty of the judiciary. There is no doubt about that. But, my lord, it appears to me that, my lord, that there has been some, my lord, communication gap, my lord, in the functioning of this council.
Yes, what do you say?
Your Lordship, even time was given for the purpose of the communication notice. The communication notice was also sent after a gap of some months, Your Lordship. That means there was enough time in that regard also.
Explain that.
Your Lordship, the order was passed in the month of May. This order was also, even though there was no order, there was no order of communication of this order, but still it was communicated in the month of August of 2024.
What was the period given for?
2 months.
Your Lordship, the period was 2 months. So in the month of May, this order was passed, and the learned advocate for the Bar Council of West Bengal was also present. But even after that, the communication was done after 2 months. That means there was a time of 2 months given even after that. Lordship, Lordship, even after that, it was not disposed of. So there was a time period which was even we had crossed that time, and after that we had communicated also. That means there is a delay of even after of 2 months, Your Lordship. With due respect, Your Lordship, this is a willful contumacious act, Your Lordship. Yes. As far as the petitioner is concerned, Your Lordship.
Not the chairman. It's not the chairman.
It was just given, direction was given upon the Bar Council of West Bengal, but someone has to be the person who is authorized to represent the Bar Council.
Number 6.
The name of Bar Council of West Bengal has been mentioned.
Bar Council functions through its functionaries.
Your Lordship, right.
Who is responsible for the actions of the Bar Council? The chairman or the secretary?
Assistant Secretary,
My lord,
the chairman is the head. Why can he liability
my
principle?
lord, your lordship was pleased to direct the respondent number 6. Respondent number 6, I find, is the assistant secretary of the Bar Council.
Then the assistant secretary has to pay the fine. Some fine must be imposed, Mr.
Yes, as I've said, my lord, I would not, my lord, defend.
There is no apology also coming forth.
My lord, kindly permit us to file an affidavit to this. Because the rule has been served. Today they are appearing for the first time. But I believe, my lord, there's some mistake in the cost title also. Because if the direction was on the respondent number 6,
yes,
then the person holding the position of assistant secretary should have been made the contemner. Now the contemner over here is the chairman. But I don't want to.
Only Bar Council of West Bengal was mentioned. For that, the chairman is the head of that body. Lordship.
Well, let us see the direction first.
Yes, with the second page of the order, 15th of May, 2024. Second page top.
Yes, directing the respondent 6 to dispose of the complaint.
Now 6 I find is the assistant secretary.
6 in the petition.
This is contempt.
Oh, it's a contempt data.
Writ petition 6 was the assistant secretary part.
There are 2 6.
But I don't have a copy of the writ petition.
There are 2 6s.
2 6s.
Bar Council represented by chairman.
That was a typographical error, Lordship. If there is any.
Both 6s should have complied with. Then both should be guilty. They should share the penalty between themselves, Mr.
But yeah, give us an opportunity to purge the contempt. Let us come back now.
But there has to be an apology on record, Mr. The learned Advocate General, appearing on behalf of the alleged contemnor, submits that there was some communication gap for which the order of this court could not be complied with, and seeks 2 months' time to dispose of the complaint lodged by the writ petitioner, lodged by the petitioner against the respondent number 7 in the writ petition. Post of next para, learned Advocate General further submits that an opportunity be given to express apologies in the matter. Post up accordingly, the alleged contemnor is directed to file a short affidavit expressing his apology by June 13, 2025. Full stop. The matter is postponed till July 11, 2025, when it will next be listed for passing further orders. Full stop. In the event the order of this court is not complied in the meantime by disposing of the complaint lodged by the petitioner with the Bar Council of West Bengal, comma, appropriate penal measures shall be taken against the alleged contemnor.
But the alleged contemnor is personally present, my lord. Your lordship.
The alleged contemnor is personally present in court. Full stop. The alleged contemnor shall remain present on the returnable date as well.
Right.
Because if it's not complied with, we'll deal with the contemnor.
Much obliged, your lordship.
My lordship. I'm grateful.
Thank
you.
Your lordship, I am for the petitioner.
Yes.
Again, bow down before your lordship. I'll just ask for time again, your lordship.
Why?
We contacted her yesterday. It is a match suit, your lordship. Transfer of suit regarding a match suit.
No, no. On the last occasion also it was adjourned.
Lordship. But again, yesterday I just contacted her.
Talks of settlement have failed.
Not failed yet, your lordship. They are still in the term, means deciding the terms. It's about the child, your lordship, for the betterment of the child, your lordship. I called her up yesterday. She said that please take some more.
Learned counsel for the petitioner seeks further adjournment to resolve the matter between the parties. Full stop. Keeping in view the good intention behind the adjournment sought, comma, for the purpose of exploring avenues of amicable settlement, comma, let the same stand adjourned till June 13, 2025. Full stop. However, comma, in the event the parties fail to arrive at an agreement in the at a settlement in the meantime, appropriate orders, the revisional application shall be taken up on merits. If you fail to arrive at settlement in the meantime, merits.
Lordship.
Yes.
I appear on behalf of the contemnor, your lordship, alleged contemnor, your lordship.
What is the allegation of contempt?
Yes, your lordship. Allegation of contempt.
A copy has been given to you?
Yes, your lordship.
What is the alleged contempt?
Yes, your lordship. May I file the affidavit of compliance, your lordship, in the second.
What was the nature of the order?
The nature of the order was, your lordship, that we have the alleged contemnor has published some notice, your lordship.
Publish some notice means?
Publish.
This is that matter which regard to section 95 and 96 of the Insolvency and Bankruptcy Code, where because of the initiation of the moratorium against an individual, certain notices were quashed by your lordship in the writ petition. In violation of that, they had published some notices.
Sale notice.
Yes, sale notices in Bombay.
What have they done now? What have you done?
Your lordship's last order, if your lordship kindly sees your lordship's last order, they had undertaken to purge the contempt, and they have done that. Last order.
You have checked up you have got a copy of this?
But we have got a copy of this, yes.
This is sufficient, Mr. Gupta?
Yes, they have removed. I've been instructed that.
An affidavit of compliance is filed in terms of the order dated April 25, 2025. Pushed up. Learned counsel, heard learned counsel for the parties, pushed up. It transpires from the affidavit and from the submission of learned counsel for the parties that the alleged contempt has been purged by the alleged contemner by issuance of further notice withdrawing cancelling the fresh notices issued in violation of the order of this court under section 13 within bracket 4 of the 2002 Act in the same mode and manner in which the incriminating fresh notices were issued. Full stop. Next para. In view of such action on the part on such bona fide action on the part of the alleged contemner, comma, there is no use in keeping the contempt application pending, comma, since the act of contempt has since been purged. Full stop. Accordingly, CPN 7 of 2025 is disposed of as infructuous without an arrest to purge.
Gratefully.
My lord, I am led by Mr. Shanti Ranjan Das in this matter. My lord, the petitioner is more than 90 years old, and my lord, it has not been possible to communicate with the petitioner since 2023. My lord, kindly keep the matter after vacation. So
What
that,
will happen after the vacation?
my lord,
If you could not contact since 2020, then what can be done?
my lord, there has been efforts to communicate with the petitioner, my lord.
Efforts to communicate means he doesn't have a phone number.
My lord, yes, phone number is there, but my lord, it has not been possible to reach the petitioner. Certain efforts have been made.
An adjournment is sought on behalf of the petitioner. Full stop. It is submitted that the petitioner is a nonagenarian and could not be contacted. Full stop. Accordingly, on the prayer of the petitioner and keeping in view the advanced years of the petitioner, comma, the matter is adjourned till when?
After vacation, my lord.
Till June 13, 2025. Thank you. None appears for the parties at the time of call. देखिए आगे row रखते हैं. Let the matter stand adjourned for the day. Same.
My lord, Mr. Shoptushira appearing in this matter, my lord. He is engaged at courtroom number 37.
You move the matter. What is the contempt about? This is happening for the first time.
Yes, my lord.
There was a previous direction for service.
Could have, my lord. Kindly adjourn the matter.
First time আসছে. On the prayer of the petitioner, the matter is adjourned for the day.
Lord, I appear on behalf of the
Lordship,
CSU.
item number 10, Lordship, I am for the petition, Lordship, I am praying 1 week's adjournment, Lordship.
Why?
Lordship, 2022 matter, today I am not with the brief, Lordship, only.
These are not appearing in the list previously.
No, first time, Lordship.
On the prayer of the
Only not today, Lordship, I will, on the next
the
day.
prayer of the petitioner, the matter is adjourned.
As Lordship's, Lordship.
I don't please anything. Whatever you say, whatever you please.
Not today only, Lordship, on the next day I will move the matter. Lordship.
On the prayer of the petitioner, the matter is adjourned for the day.
Lordship,
Next.
grateful.
Your Lordship, yes. No, Mr. Yusuf is there. He's leading me, Your Lordship.
Yes, call on the next matter.
Lordship, we have complied with Lordship's order, Lordship, and I am filing also my complaints. Affidavit of complaints, Lordship.
বাড়িতে কাজ আছে
Today no one is appearing, Lordship, because the order is already complied.
It is complied.
Waiting for the petition.
Order complied.
Yes, the money has been returned.
The affidavit of compliance filed in court to be kept on record. First up, learned counsel for the alleged contemner as well as the petitioner submit that the order of this court has been complied with. First up, accordingly, CPAN 38 of 2024 is disposed of as infructuous without an order to cost.
Grateful, grateful.
Grateful, my lord.
Thank you.
Grateful.
Thank you.
Item number 12, your lordship, I am for the applicant. We have received the copy of the opposition, so we intend to file a reply, your lordship. Kindly grant some
Opposition has not been filed. File করেছে আগে? না, no opposition has been filed. None appears for the alleged contemner at the time of call, full stop. Accordingly, let the time for filing opposition be extended for a week from date, full stop. The time for filing reply is extended till June 13, 2025. The matter shall next be listed on June 20, 2025. Opposition 1 week, your reply within 13th June, appearing on 20th.
My lord, I am for the petitioner. My lord, pursuant to your lordship's direction, I have already served upon the alleged contemner.
Yes.
There is a delay in complying the order.
What was the nature of the order?
Learned district magistrate was to hold a hearing upon giving
Yes, my lord, for my lord, quantum of deciding my compensation
Why did you do that? What is the explanation?
No, my lord, delay I will explain later.
You have done it now?
Yes, a notice has been sent. Notice regarding hearing has been sent. My lord,
you file an opposition explaining the delay.
Yes, my lord.
In the meantime, you proceed with the hearing.
Yes.
Learned counsel appearing for the alleged contemner submits that although there was some delay in complying with the order of this court, a notice of hearing has been given in terms of the order of this court. In the meantime, full stop, next para, the alleged contemner is directed to proceed with the proceed in furtherance of the notice and conclude the hearing at the earliest, in compliance of the order of this court. In the meantime, full stop, the alleged contemner shall also file an affidavit in opposition to the contempt application, including therein the explanation as to the delay in such compliance. Full stop, such affidavit in opposition shall be filed by June 13, 2025. A reply, if any, shall be filed by June 20, 2025, when the matter shall next be listed under the same heading. Affidavit of service filed today be kept on.
Grateful.
June 13, and in the meantime, please try to. Yes, 14.
Appearing for the alleged contemner, my lord.
What was the nature of the order which you did not comply with?
Receive a payment of some amount was due, my lord.
Why didn't you pay it?
Receive affidavit in opposition, lordship.
What is your explanation in the affidavit?
There's a delay, my lord. 2 weeks delay there. Filing on the affidavit in opposition. You already served the.
So what is your explanation in the opposition? What about container number 2?
Contemner 2, my lord, is the DM, my lord. Contemner number 1, additional district.
You have filed opposition for 1 and 3.
1 and 3, my lord.
Why, DM is above the law or something? You will issue a rule against the DM.
My additional district magistrate, my lord.
So,
in the meantime,
he's above the law.
My lord,
he'll be in court and explain why he's not here.
My lord, we already filed a review application, and that will, my lord.
What review? Affidavit in opposition has been filed by 1 and 3. Why not 2? 2 is not the DM.
My lord, 2 is not the DM, my lord.
2 is block development officer. You are not appearing for him. You are appearing for all.
Yes, my lord, we are appearing for.
So what about the block development officer?
The contemner number 1 is the answering respondent, my lord.
Pardon? 1 and 3 you have filed. No difficulty.
They are the answering respondent, my lord.
Every contemner, alleged contemner, is an answering respondent in a contempt application. I'll direct the video to be present personally. Yes.
Lordship, I'm praying for not today, Lordship, because my senior is not present in court. He's suffering from fever, Lordship.
Why aren't you prepared in contempt matters? And contempt, you don't have a say even. It's between the court and them. If you don't file a reply to the opposition, then you're gone. We'll proceed on the basis of the opposition. What is your explanation in the opposition?
Keep in the next week, my lord. Only one's accommodation, Lordship.
Pardon, I can't hear you.
Lordship, only for accommodation, Lordship. On the next date, I'll come and explain this regarding that.
No, in the opposition, what is your explanation? Opposition is filed for a reason. What have you stated in the opposition?
Certain amounts will already paid, my lord, and due to the lack of funds, lords, we are not.
Learned counsel for the petitioner seeks an adjournment, full stop. Accordingly, the time for filing reply is extended till June 13, 2025. Full stop. The time for filing affidavit in opposition by the alleged container number 2 is extended till May 23, 2025. Please do that. May 23, 2025. Full stop. The reply, if any thereto, shall also be filed by June 13, 2025. The affidavits in opposition filed by alleged container numbers 1 and 2 today be kept on record. The matter shall next be listed on June 20, 2025.
Grateful, madam.
But please ensure that the
Lord,
container.
Sorry for my
No, not your word.
My lord, 15, my lord, who already complied with, my lord, we got the electricity connection, my lord.
And last occasion, he did not appear. I filed a compliance report, my lord.
Who is for whom? He is more eager than you to say that you are for the petitioner.
My lord.
Learned counsel for the petitioner. What is this affidavit?
Compliance.
Learned counsel for the petitioner submits that the order of this court has been complied with in the meantime. Who's up? Learned counsel appearing for the alleged container number 2 also stands by the same and files an affidavit of
That
compliance.
has already been filed last occasion.
Stands by the same. Pushed up, it transpires from the affidavit in compliance filed by the alleged container number 2 that the order of this court has been complied with. Accordingly, CPN 1484 of 2024 is disposed of as infructuous without any orders to cost.
Okay.
I am for the petition.
Lord, I am appearing on behalf of the alleged contemners, my lord. There are 2 orders passed already in this matter, my lord. After the orders having been passed, my lord, steps have been taken to zeroize the account. Because, my lord, this pertains to some credit card transaction.
To do what to the account?
They have coined the term zeroize.
Zeroize means?
Zeroize means was also
Zero eyes.
no zero
eyes.
zero
eyes.
just to make the account
Yes,
zero.
IZD.
My lord, there are some.
Your client will be zeroized if you don't comply with orders.
My lord,
It is
it's
been
not
complied,
complied, my lord. Kindly see the credit score, my lord.
Let us zeroize you.
My lord, I'll just indicate.
You
But I have got
jargon
the
and all
approvals,
this.
my
My
lord.
lord, April also
My
they
lord,
have
I'll-
reported against me, my lord. Kindly seize the
My lord, I'll indicate your lord.
red tick, my lord. April, my lord, on the first page, my lord. On the first page, there is a the first page, my lord. Kindly see.
Taken.
2025.
What's the nature of the case?
Zeroizing.
My lord, there was a credit card fraud, my lord, which we took all the measures to report that to the police and to the to the
No,
SBI.
what did they direct?
My lord my lord directed one that they will not claim anything from me unless and until that police investigation is over. Second, my lord, they will reverse my credit score, my lord.
Yes, absolutely.
They are coming to my house. They have sent, my lord, I can show, my lord, they are sending.
Reverse the adverse civil listing
Yes.
and restrained from making any claim.
My
They
lord,
have not made any claim.
They are making claim, my lord. I can show that also, my lord. Recently, my lord, yesterday night, they are sending, my lord, SMSs. Further, my lord, they are what they are doing yesterday.
And the zeroization, what about that?
Yes, your
Nothing.
lordship,
It's
my lord.
still pending, my lord. They are claiming the
My
money.
lord, I'll indicate your lordship.
No, zeroization pertains to that civil rating.
No. Pertaining to the claim. My lord, there is 1,50,000 on that particular credit card that is showing outstanding. Approvals have been received from the settlement committee to make the account zero.
I mean, the liabilities
Liability will be zero. Yes, your lordship. My lord, it will be reflected in the coming month. The statement date is 3rd of June. In that particular statement, it will be zero. My lord, I am only seeking some time to file an affidavit of compliance as well as to apologize before your lordship because of the delay that has occasioned in taking steps.
What about the reversal of the civil?
It will also be reflected, your lordship.
My lord,
It will also be reflected.
We'll give it till the 13th June.
Yes, your lordship. It will also be reflected.
Learned counsel appearing for the petitioner hands up a printout of the relevant website indicating that the order of this court has not been complied with. Full stop. It is seen from the order dated December 7, 2023, passed in WPA 10311 of 2023, that the respondent bank stroke alleged contemner was restrained from making any claim whatsoever from the plaintiff on the basis of the amount which was fraudulently debited from the account of the petitioner on the strength of the petitioner apostrophe credit card as well as from reversing the civil ratings of the petitioner. Push-up learned counsel appearing for the alleged contemner submits that the procedure for reversal of the adverse civil listing of the petitioner is in process. Full stop. The alleged contemner has already taken steps for zeroizing the account of the petitioner as well, comma, which will result in the credit liability, the credit card liability of the petitioner to be shown as zero in his account. Full stop. Some time is sought to complete the process and an opportunity is sought to file an affidavit in opposition to explain the delay as well. Full stop. Accordingly, the alleged contemner is directed to file affidavit in opposition. Do it within a week.
Yes, Your Lordship.
Within a week from date. Full stop. Reply, if any, shall be filed by June 12, 2025. The application shall next be listed on June 13, 2025. Full stop. It is made clear that in the event the order of this court is complied with, in the meantime, comma, the alleged contemner shall be at liberty to file an affidavit of compliance as well. But file that affidavit in opposition explaining the delay.
Yes, Your Lordship.
In addition to that, if you comply,
We just indicate the statement and the compliance affidavit.
My lord, another thing, if they mark me as, my lord, settled, my credit score will not improve, my lord.
they'll also reverse the adverse steps. That is also one of the prongs of the order.
17 man of the petition, my lord.
First time? No,
This is the reply, my lord. Opposition.
Let me have the opposition first. What is the opposition?
My lord.
They have already filed.
has been filed.
Well, this is the reply.
This is the same matter
এই
where
পজিশনটা কোথায় গো? এখানে দিয়েছো action? আচ্ছা।
Well, let me place my case, my lord.
Place your case.
Well, the
Yes,
petitioner are the farmers, my lord. They are producers maize seeds for the state of West Bengal, my lord.
Right.
And my lord, they are after cultivation, my lord, they
Subsidy scheme.
subsidy scheme.
They were to pay you on the subsidy scheme.
Only they have paid the money, but not subsidy has been paid by subsidy has been not given by the state.
Subsidy has to be given by way of money.
They purchase the seeds, my lord.
They means who?
The state government.
Acha.
They already purchased it, but subsidy amount is not paid to the petitioners, my lord. So, my lord, initially they said that you have the lot, not the land papers, you have the cultivation certificate. On the cultivation certificate, on the basis of cultivation certificate, we are not paying you. We file the application before your lordship. Lordship says clarify the scheme, and my lord says that if the cultivation certificate is available to the petitioners, they will get the subsidy. My lord, we have
You have got the certificate of cultivation.
Yes, yes. We communicated the order, my lord. And communicate after 1 year's passing of the communication order, they says that the certificate issued by them, it's not the original one.
Oh, I held that the production of land documents was alternative with certificate of
Yes,
cultivation.
yes.
You have now produced the certificate.
Certificate is always given with the bills. With the bills. Now they are saying these are not genuine. But we in your reply, my lord, from page 15, the cultivation certificate is not on a single day issue, my lord. We have to apply. They have visited our place, my lord. Thereafter they
So certificate of cultivation was given to them when?
In 2022, 2021.
At the time of applying for the scheme.
Yes. And my page 15 onwards, my lord.
Page 15 of the reply.
My reply. This is the procedure, my lord. They say every document they have annexed. Thereafter, they issued the cultivation certificate, and with bills, my lord, they are collecting the cultivation certificate, and now says give this as the genuine. Well, page 15, my lord, regard issuance of cultivation certificate, notice issued. They applied for the same. Everything is.
You furnish this cultivation certificate along with the application for the scheme.
Yes, yes, my lord. Initially, they are saying as you are giving the cultivation certificate, so we are not giving you the subsidy because you have to pay the give the land or purchase.
No, that was turned down by this.
That was by the court. So,
yes, what is your explanation?
My lord, the cultivation certificates that is being relied by the petitioner, the certificates are not genuine. The certificates
you accepted the certificates and then only you accepted their applications for subsidy.
My lord, now
They were held to be eligible for the subsidy.
Now, my lord, what we have been instructed with regard to, we have filed a report to that extent and
You
opposition
are
to
stopped
that
from
extent.
saying that.
My
You
lord,
accepted on the basis of that they applied for cultivation. They applied for the subsidy scheme.
Now, my lord, the thing that they are saying is that they were never issued from that office.
No, I'll issue a rule of contempt. You are in contempt of court. You are now setting up these pleas to deprive the farmers from the money. Sorry, very sorry. Show us the relevant paragraph of your affidavit in opposition.
My
to
lord,
that document. So convenient, isn't it? Not genuine. Yes, where have you stated that?
my lord, the annexure 12, my lord.
No, where have you stated there? Where is the
Stated that
pleading?
they're not genuine.
Show us the pleading in your opposition.
The time of claiming.
Yes. Who is that?
My lord?
The alleged contender?
One of the alleged contempt.
Yes. Yes, please continue.
My lord, paragraph 3 of the subparagraph 3 of paragraph 4.
But you accepted their applications for subsidy on the basis of these cultivation certificates.
My lord, that was accepted because that was prior to filing of the writ petition. Then the writ petition, these certificates were produced as annexures. And when they were produced as annexures in this writ petition, the Honorable Court was pleased to direct that on the basis of the cultivation certificates, they may be given subsidy.
You did not take this point that these were fake at that point.
My lord, we did not have that instruction or information at that point of time. That
What
were there.
information? Those were given by them at the time of applying for the subsidy.
Yes, my lord.
So those were all along with you.
Yes, my lord. But at the time of filing of the writ, at the time of moving of the writ petition, we did not have that knowledge that these were not genuine. Only after making an inquiry.
How could you accept their applications for subsidy if you did not undertake an inquiry without being satisfied? How could you accept the application for subsidy? Were they found eligible for subsidy?
They were found eligible, but my lord, after
Cannot
it was,
set up this plea afterwards.
They were.
What is? They have annexed certain things. Page 15 of the reply is very clear.
Yes, ma'am.
No, but Mr. Kushal, page 15 is not the certificate.
That is the seed corporation, my lord.
Page 14, my lord, is their letter that we are entitled to get the subsidy. Page 14 of 14. And
So where is the certificate of subsidy? Certificate of cultivation.
Certificate, man.
Page 15 is not the certificate.
No. We are entire procedure. We have annexed.
Where is the certificate of
certificate? Page 33 onwards.
That is issued by the Assistant Director of Agriculture. And this is the letter that has been issued by the District Manager of the State Seed Corporation.
Page 33 is issued by the Assistant Director of Agriculture.
Yes, my lord. These signatures are not genuine.
But
This
on
is
the
our
basis
contention.
of this only you had found them eligible.
These signatures are not genuine. That is our contention in this application for contempt.
Where is the communication by the Assistant Director?
My lord, it is at page 12 of our opposition.
Alleged contender is the Deputy Director.
Deputy Director.
Page 12.
Page 12 of our opposition, my lord. The paragraph at the bottom.
Yes. You're saying won't do. You should have verified at the time of when you granted held them to be eligible.
My lord, at the time of moving of the writ petition, this information was not available.
Prior moving, it was prior to that. They were found eligible to get the subsidies. They moved this code because despite that.
Prior to the writ petition.
No, cannot take this stand now. Sorry, you pay them their dues. I'll keep it on 13th of June. Pay them their dues. the affidavits in opposition and reply filed to be kept on record. Full stop. The stand now being sought to be taken by the alleged contemner is that the certificates of cultivation issued to the petitioners by the Assistant Director of Agriculture was fraudulent, since the purported signatures of the Assistant Director appearing on such certificates is not genuine. First up, learned counsel for the alleged contemner places reliance on Annexure B to the affidavit in opposition, which is a communication dated July 5, 2024, issued by the Assistant Director of Agriculture, Jalpaiguri Sodor Block, wherein it has been stated that the documents of the petitioners sent by the alleged contemner as cultivation certificate were not issued by the said office and are absolutely fake and manufactured. Push up next para. However, such stand now sought to be taken by the Assistant Director of Agriculture as well as the alleged contemner is diametrically contrary to the acceptance of the self-same certificates at the time when the petitioners applied for being eligible under the subsidy scheme floated by the respondent in the writ petition. Push up the respondents, on the basis of the self-same certificates of cultivation, were found eligible for the subsidy scheme in question. Pushed up as such, the presumption is that the respondents in the writ petition were well aware as to the genuineness of the said documents. First up, it should be presumed under normal conduct of a prudent person that while accepting the petitioners to be eligible under the subsidy scheme, the genuineness of the certificates of cultivation produced by them were admitted and or verified by the respondent alleged contemner. Full stop. After accepting the petitioners as eligible for the subsidy scheme, the alleged contemner cannot now resile from such position by a mere communication from the end of the now Assistant Director of Agriculture and disown the said documents by saying by deeming those to be fake and manufactured. Pushed up, the alleged contemner is stopped from taking such plea after having accepted the self-same certificates of cultivation furnished by the petitioners and having held the petitioners to be eligible on the basis of the said certificates for this scheme. Pushed up, upon such benefit having been extended and having been exercised by the petitioners, it does not now lie in the mouth of the alleged contemner to deny the veracity of the certificate. Pushed up, accordingly, time is granted to the alleged contemner to comply with the direction of this court and to disburse the subsidy amounts in favor of the petitioners within June 13, 2025. Pushed up next para. The matter shall next be listed on June 20, 2025, when a compliance certificate shall be filed by the alleged contemner. First up, the alleged contemner shall be personally present in court on the returnable date, when the matter will be listed for appropriate orders. 20th. 20th, your client will be present in court.
20th.
20th. If it's not complied with, we'll take appropriate action immediately, then and there. Yes.
18th, my lord, I am this. Not for the response.
Yes, now we face the wrath.
I have complied the
Lordship's
order.
order has been tested before the Honorable Supreme Court, and this is the
Don't
order.
require to be so solemn about that. Tested and the test has failed.
Failed.
I have failed or the
No.
No, Lordship, the
test has failed. Period.
Yes,
Now
sir.
comply.
They have complied already.
No, Lordship, not complied.
My lord,
Now, Lordship, the total amount as on today, Lordship, the disbursed 4,72,440. But whereas the petitioner still now entitled to get, Lordship, the 1,70,000.
Are you prepared with an affidavit of compliance or
My
something
lord,
like that?
due
Yes.
to amalgamation, my lord, there is no signatory for the last
Amalgamation between whom and whom?
three banks, my lord. Paschim Banga Gramin Bank, Bangio Gramin Bank, and Uttar Banga. Now it is
Bank has stopped functioning.
my lord, there are
Accounts are being opened, you are not paying anybody, nothing.
already paying that, my lord, but there is no signatory there. New incumbent should be added, my lord. We have paid, my lord.
How is the bank functioning?
But also there are three sponsors, my lord. One UCO that is covered by the
The bank has stopped its functioning.
It is not functioning, my lord. Pay they paid.
If it's functioning, if it's opening new accounts and paying customers, you pay them.
He already paid.
Entire amount.
No.
Entire amount, my lord.
File an affidavit.
No.
Entire amount.
File an affidavit to that effect.
Yes.
And lordship, my submission is even day before yesterday, they have deducted 4,000 and odd from my pension account.
The direction was not to.
No, lordship, the
Let new incumbent be added, my lord. I am filing up. Because the entire management change.
You have to restore the entire amount.
Yes.
And restrain from deducting any amount. You are still deducting.
No, my lord. This is the statement with me, my lord. Enter statement.
Learned counsel for the alleged contemner submits that a new incumbent has joined in the post of the alleged contemner. Post of the particulars of such incumbent shall be furnished by the learned advocate for the alleged contemner to his counterpart appealing for the petitioner. Do it today. The details.
Yes, sir. Rakesh Kumar Agarwal. He already sent a letter, but not added.
During course of the day. Push up next para. Such new incumbent shall be added and consequential amendment to the cause title of the contempt application shall be carried out by the learned advocate for the petitioner during the course of the day. Push up next para. The alleged contemner shall file affidavit.
In compliance, my lord. I've already paid my file.
Now, since the alleged contemner submits that the alleged contemner has already complied with the order of this court, comma, an affidavit of compliance shall be filed annexing relevant documents by May 23, 2025. Full stop. A copy thereof shall be handed over to the learned advocate on record for the petitioner. Full stop. The matter shall next be listed on June 13, 2025 under the same heading. Full stop. Exception, comma, if any, to the affidavit of compliance shall be filed by the petitioner by the next returnable date. You also give a copy to them.
May I hand over the
প্রথম লাইনে অ্যাড করে দাও সংখ্য একদম সবকিছুর আগে learned counsel for the petitioner hands over a server copy of an order whereby a specially petition against the parent order of this court, comma, out of which the contempt arises, comma, has been dismissed by the Honorable Supreme Court. The same is kept on record. Yes.
রাকেশ কুমার আগরওয়াল একজন
এতে কেন আছে?
Can dispose, my lord.
What is the can?
Can filed by them.
I filed that
dispose of হয়ে গেছে বলছে?
Appeal has been preferred. Lordship, that information I could not given at the
time. Can recall order is there? Recall application?
Yes, that has been disposed of.
Already disposed of? চেক করে নেন না কেন অর্ডার শিট থেকে চেক করে নেবেন
Last order
it is disposed of, man.
তো আমি কন্টেম্প নিচ্ছি কন্টেম্পটের কানেকশন যদি কোনো অ্যাপ্লিকেশন থাকে সেটা দেবে ডিসপোজ অফ বলছে তো সবকিছু ডব্লিউপি তে বলছে আজকে রিসেন্টলি ফাইলড
No, we have not filed, my lord.
কি বলছেন আজকে কোত্থেকে রিসিভ করলেন দেখি হ্যাঁ
Not communicate this information, so I could not comment. Lordship,
this is still pending.
No, last occasion it was disposed of. Lordship, kindly call the last order.
Order sheet দেখো last
order.
Disposed of, last.
Disposed of.
তাহলে লিস্ট আসছে কেন আগের অর্ডারে যদি ডিসপোজ অফ তাহলে কি করে রিসেন্টলি রিসিভ করলে ভুলভাল কথা বলছো থ্যাংক ইউ
My lord, I appear for the alleged container in item number 20, my lord, may be taken after 19.
After?
After 19. 19th is attached with 20, but my lord, both are separate matters. My lord, may 20 be taken after 19.
20 will be taken after 19.
Yes, my lord, 19 with 20 was called.
20 was 19 and 21. So 19 will be taken up first.
Manual for the petitioner.
What is the contempt?
My little lordship, I appear for the contemner. But your lordship may recollect, your lordship was pleased to pass an order regarding my lord release of my lord insurance claim in favor of the farmers. And there was a default on the part of the bank to deposit the premium. When the writ petition was heard by your lordship, unfortunately, my lord, the insurance company did not appear. Very candidly speaking, my lord.
Yes.
My lord, the petitioner relies on the Bongo Shosho Bima operational guidelines. My lord, mere payment of what we could not, which we ought to have appeared and apprised your lordship. My lord, mere payment of premium would not, my lord, create a situation where claim has to be settled. In this case, my lord, we have examined the facts. We have explained in our affidavit in opposition that no claim was submitted. No claim was reported in terms of the operational guidelines. My lord, the loss was never assessed. And as such, my lord, at this stage, my lord, settlement of claim without there being any claim in terms
Mr.
of
Mujumdar, there is no challenge to this order.
no, there is no challenge. But my lord,
There is no
we
challenge.
only
This
one
order
thing, my lord,
stands.
what we have done, my lord, subject to your lordship's kind consideration.
Yes.
We have taken out a recalling application before your lordship. That is also
That is appearing before us.
I think so, my lord, subject to your lordship's kind.
Recall. Appear করছে? Recallটাকে লাগিয়ে নিতে হবে। Contempt যদি
My lord,
same
we
order
do not
recall
stand in the way of payment to the farmers. My lord, the payment has to be made by the bank in view of the default committed by the
No,
bank.
your role was as per that order, as I see here,
Yes.
was upon the bank making the payments of premium
My
or
lord,
whatever you want to
my lord,
regularize
your
the
lordship
issue.
knows better than all of us. There has to be in any insurance case, there has to be a claim. Claim, the law requires, the guidelines require the claim has to be submitted within 48 hours. The claim has to be examined. My lord, the bank is the nodal agency. The claim would have to be forwarded to the insurance company.
But the order in contempt that says that you have to regularize the.
We cannot at this stage because there is no claim. How can we assess the loss after 5 years?
No, no, the insurance.
But these are 19.
The policy was to be
bank
regularized.
bank file the
For a
opposition.
policy to be in place, there is no claim required.
No, my lord, claim is required. That's the guidelines.
How claim will follow a policy? There has to be a
There-
policy first.
my lord, there is a policy. Policy is linked with the loan. Policy is linked with the loan. It is as if, my lord, the loan is covered by the policy. So once the policy is linked with the loan, my lord, obviously, my lord, if there is any loss, there are 2 situations or 3 situations on which, my lord, loss can be, well, suffered by the farmers. Well, if the loss suffered by the farmers, they have to report it to the bank within 48 hours. The bank would forward the claim, if it is in the prescribed form, to, my lord, the insurance company, who is one of the contemners before your lordship, whom I represent today. The insurance company would appoint a loss assessor come surveyor. The loss assessor can surveyor will cause inspection, make inquiry and submit its report. On the basis of the reports so submitted, my lord, then only, my lord, the claim can be settled. My lord, all these steps were never taken. And that we have explained. In fact, the writ petition clearly says that this Bongo Shosho Bima Yojana, that has to be followed.
But this was not about the settlement of the claim.
Yes,
This
my
was
all settlement of the claim.
No. Let
Mother,
us
I
come,
may
let us
be
come to the
totally
order.
incorrect. I am maybe totally incorrect.
Mr. Mujumdar,
I'm sorry, my lord. I may be totally
First,
incorrect.
let us come to that order.
Yes, my lord. Certainly, my lord.
Where is that? Which page of the contempt application?
Page, my lord, it is,
Yes, I've
if
got
your
it,
lordship
I've got
can take the page 12 of my recalling.
Or let us come to the last page of that order.
Yes, certainly, my lord. I will come
Please
to the last.
read from para 9 onwards, Mr. Mujumdar, of that order. Disposed of by directing the insurance company to extend the time for depositing the premiums by the bank.
Right.
First.
Yes.
Secondly, respondent bank's role was to immediately commence paying the due installments of premiums
Right.
on behalf of the petitioners under the said scheme to the company.
Right.
The arrears which have fallen due shall be paid at one go by the bank. That's for the bank. All premiums
12.
thereafter shall be paid by the
Paragraph 12.
12 is upon such payments being made by the bank.
Right.
the insurance company shall regularize the insurance policy of the petitioners and honor the same as and when required.
That is the past period now. That's 2019. For every year, the policy for every year. It is policy, it's an annual policy. Yes. It's always an annual policy. We are talking about 2019-2020 policy.
But you cannot take the plea that there was no policy, therefore we won't pay. Because
I will never take that plea. Why would I take that plea? There must be a policy. Policy is in place, but there was no claim in terms of the operational guidelines.
If you say that there is a policy in place, then your role is over as per this order. This order only directs you to regularize the insurance policy
Then,
upon the bank paying premium.
Today, I face a very difficult situation. Kindly do not take me amiss, kindly, the petitioners the policy will be regularized once the bank makes payment. Now, today, the subject matter of the writ petition is a period of 2019-2020. Your Lordship will kindly take the prayers in the writ petition. Regularize would also mean and include, to the best of my understanding, settlement of claim, if any. They say that they have suffered loss during the Rabi season, 2019. So, what do? I put the question to myself with all humility.
These policies are annual policies.
Yes, obviously, like any insurance policy.
The policies, insurance policy is not an annual policy.
National insurance.
Premium payment may be annual.
But policies are always annual. Any policy. These are the general insurance kind of policy. Policies are always annual. Car policy.
Right. This is not
a fire policy. And we were only for the period 2019-2020 so far as this scheme is concerned. We are not there.
You should have preferred a challenging.
Why should I thought that I should come back to your Lordship?
Then this order does not stand.
I have to come back to your Lordship. Your Lordship was not posted with all the facts. Why should I go to the appeal court?
No, then we have to hear the recall application.
Yes.
Then you take up the recall application first.
My Lord, the bank has filed the opposition. Already they have paid paragraph 4 of the opposition. They have paid the premium. Paragraph 4 of the opposition filed by the bank. Bank liability to pay.
If it is a case of misreporting, it is bank's liability to pay. I do not say for once that the farmer should be deprived. But whose liability? I put the question to myself.
My Lord, there was no fault on the part of the bank. Actually, the actual facts could not be brought before your Lordship at the time of hearing of the writ petition. Only premium which was due was for the year 23-24. But prior to that, all the premiums were paid.
What about the submission that it is an annual policy for 2019-20 only?
Lordship, the premium has been paid annually. Lordship, the actual facts has not been brought before your Lordship by the petitioner himself, because for the year 2090, for this cluster 2 in which this Bakuda region falls, my Lord, the National Insurance Company was in charge of this policy under this scheme, my Lord.
You have been paying premium till date?
Yes, my Lord. From 2025, the state government will pay entire premium. That notification also I have annexed, so there is no requirement for bank to make premium to pay premium, my Lord. After 2021, my Lord, the another insurance company, namely, my Lord, Agricultural Insurance Company of India Limited, was entrusted with this policy, my Lord, to which the petitioner the bank has already paid premium.
So bank has paid till 2024?
Yes, my Lord.
The annual, it has been renewed?
Yes, my Lord.
All the premiums have been given?
My Lord, only 23-24 premium was paid after filing of this content. But prior to that, which was at the petitioner place that we defaulted from 2019 itself, that was incorrect. So prior to that, premiums were paid within time.
So all the premiums have now been paid up to
Yes,
2024, up to current?
Yes, my Lord. And for 25, does not require to make payment because the state government will make payment of the entire premium.
Up to 2024, they have paid the premium.
My period.
Then you regularize their.
My period with which I am concerned is 2019-2020.
So not only that, because as per the order passed by this court,
I was not there. My contract ended there with the bank.
So it is not you are.
Your Lordship will find the prayer is confined to 2019-2020, subject to correction.
That was paid within the time itself. There was no default. That
I have taken instruction from the insurance company. The payment of premium was paid. Correct?
But details were not uploaded.
The premium was paid by.
Yes. The details were not uploaded. The claim forms were never submitted. The claims were never reported. That's the situation.
If they make the claim now, you will pay.
If they, then I have to assess. How can I go back and assess now? In 20, I cannot set the clock back. I cannot make an inquiry or inspection.
So you are the insurance company is this you are national insurance.
Yes, my lord, national.
You are no longer in charge of this.
No. From we have also refunded the premium. ঠিক করে বলুন.
Refunded means
to whom?
to the bank.
To the bank. We have refunded the premium.
The national insurance company was in charge till when?
This is
Up to when?
2019. That is
Up
the
to
period.
2019.
That is the period.
After that, national insurance company
No longer associated with this issue.
There is no question of refund to bank. From 2020 onwards, the premium has been paid in favor of Agriculture Insurance Company India Limited.
Not my case. I am not agriculture insurance company.
So they are not the contemners then. National insurance company.
2019 they were, my lord. Now
Yes.
2019 they were.
Yes, 2019, my lord.
2019 did you make a claim? They are saying you have not made a claim even.
No, I made to the application that has been considered. That's why I came before the report.
Where is the application? I put the question to myself. There is no claim form.
No.
In the writ petition, you had annexed that application. Let's see that.
One application was filed only in 2021. After 2 years.
Where is that annexed in page?
That is at page 11 of what? This is writ petition. I cannot. The immediate reporting is the the provision says. The provision
cannot reopen the order, Mr.
I cannot. I will not. I don't want your lordship to reopen the order. But
Contempt we cannot.
I will only kindly take my recalling once. What I have stated. But today I have refunded everything. The bank cannot deny that I have not refunded the premium amount. Am I correct?
Have you got a copy of the writ petition by any chance?
Yes, I have got the copy. Kindly take the
page 11 there.
Would your lordship take it from my iPad?
No, I have a copy.
Yes, certainly.
You come to page 11 of that.
Absolutely. Writ petition ta dao. Oh, writ petition ta amar kache geche. ঠিক আছে. Page 11.
You refer to the UPAT. I'll refer to this writ petition. Hard copy.
Page 11. Yes,
11,
that
11.
is the application.
That is that app.
এটা আমাকে ফরওয়ার্ড করেছিল।
এটা ব্যাংকে দিয়েছে। As per guideline, they have reported it to the bank.
They have reported it to the bank.
And that could be on.
Please arrange. This is a claim.
This claim has to be made within 48 hours as required under the guidelines. Because that is immediate assessment.
There's an order of the court, the guidelines.
Kindly, they say that the guidelines are to be followed in their writ petition. Kindly take the writ petition for once. Otherwise, I would not have moved this application. Kindly take the writ petition for once.
Yes.
Kindly take, my lord, paragraph. Yes, 7.
Yes, 7.
Your petitioner states that as per notification dated so and so, being so and so, Navanno, etc., the governor is pleased to accord approval for implementation of Bangla Shosho Bima in all districts of the state during Rabi 2019-2020 season for the crops. Your petitioner craves leave to produce the said notification at the time of hearing. But the entire claim is based on this Bima Yojana.
Yes.
And the Bima Yojana says that the reporting has to be done within 48 hours.
I've got a copy of the Bima.
Yes, annexed to my affidavit in opposition as well as my application.
Your recall application?
Yes, both.
Which page? Recall application?
Kindly take the Bima Yojana.
Page 27.
Page 20.
Opposition.
Your lordship is looking at the opposition or recalling?
No, the recall application.
Kindly take recalling page 15.
Page 15, yes. Operational guidelines.
Annexure B.
Yes.
Now, kindly take from clauses 14. Now, 14 is post-harvest losses. Now, kindly take time and method of reporting the claims.
Yes.
Immediate intimation within 48 hours by the insured farmer to anyone as detailed below. Intimation must contain details of survey number wise insured crop and the average affected, premium payment verification to be reported in next 48 hours by the farmer or bank. Whom to be reported? That is the channel of reporting. Intimation may be given within 48 hours by farmer, either directly in the to the insurance company, concerned bank, local agriculture department, government, district officials, or through toll-free number at the insurance or to the insurance company. First mode of intimation will be centralized toll-free number. In the absence of such facility, the report can be given to the banks or government officials, and the same would be forwarded or intimated to the insurance company immediately. The banks would verify the insured details like crop insured, sum insured, premium debited, etc.
The first place they did not apply even within 48 hours.
No.
After
They
2 years.
kindly take appointment of loss assessors.
Yes.
Appointment of loss assessors. Then just my lord.
That's like any
claim. This reporting was not done.
Did you give a clear refusal to them saying that you have applied beyond time or something like that?
Because my lord, this is beyond 2 years. I am no longer there associated with the scheme. This is a typical situation. The impasse can only be solved if the bank owns up the responsibility because we have refunded the premium.
In respect of that 2019-20? Refunded the premium means whatever premium was
premium was deposited with us by the bank, we have refunded to the bank.
Have you got any document to show that?
I have no such instructions, my lord. No, I have no such instructions.
Show that from somewhere. We'll fix the liability on the bank.
Kindly, 1 minute, madam. I'm so sorry, madam. Kindly.
I'm not the Punjab National Bank. I'm the
Punjab National Bank.
I'm IDBI
Punjab
Bank.
National Bank will come to later.
I have the document so far as Punjab National Bank is concerned.
But Ms. Ojha is appearing for this.
IDBI Bank.
May I just indicate, another way of solving this impasse. Today, the best interest of the farmers are to be considered.
Only that.
Only, I understand that. There is a direction given by the Honorable Division Bench in another batch of matters, where the Principal Secretary? Principal Secretary Agriculture Department has been directed to look into the issue and resolve the impasse.
Looking into issues won't do. They have to get the money. They have to see the color.
They have done something. They have done something which we have indicated in our affidavit, in the application also. They have tried. So that
if you show us that you have refunded to the bank, I'll just direct the bank to pay them.
Today, my lord, I put the question to myself. So far as Punjab National, I have the document.
IDBI.
But that I have to. I will not make any statement of the record. I have to take that instruction. But today, my lord, if the premiums are deposited,
wherever the premiums are, we'll direct them to pay them to the farmer.
If your lordship directs us, my lord, today, so far as IDBI Bank is concerned.
Yes, we'll produce your papers regarding that.
And whatever, may I just make one submission, subject to your lordship?
Yes,
may I just indicate, today, my lord, suppose the premiums have been paid, must have been paid, because my client's instruction has been deposited. Premiums we have not refunded, so far as IDBI is concerned. Assuming, I have to take that instruction. The question still remains that there has not been any claim before us in the proper manner and within appropriate time. And their case is based on this Bima Yojana. This is a typical situation regarding impossibility of performance.
Yes, what do you say to this? Because we have to take up the.
Kindly allow me. May I come back immediately on the reopening week, Friday? Let me take instruction regarding IDBI. I will apprise your lordship the facts, but whatever we have done with IDBI or not, and your lordship may take a call then.
So let me just pass an order on Can 1 directly.
Yes.
Can 1 of 2025
is affidavit in opposition is on similar line, my lord. We have
the affidavit in opposition to the contempt application is taken on record. Can 1 of 2025 is an application for recall of the order dated January 22, 2024, in connection with which the contempt application has been filed. Bishop Leonard Senior Counsel appearing for the applicant / alleged contemptor submits that the order dated January 22, 2024 was passed on an erroneous premise inasmuch as the correct facts were not posted before the court. Full stop. Despite service of notice, comma, the insurance company could not be represented on the said occasion, for which, comma, it is submitted, comma, the correct factual matrix was not before the court. Full stop. It is submitted that insofar as the National Insurance Company is concerned, comma, it was a part of the scheme in question only for the year 2019,
Till
2020.
2019, madam. Till 2019.
Only up to 2019.
2020 or 2019 should be.
2019, 2020, my lord. 2019, 2020.
2019-2020. Full stop. Next para. However, comma, by placing reliance on clause Roman XIV within bracket Roman IV XIV, comma, subclause 1 within bracket small c within bracket small I, comma, it is submitted that in order to get advantage of the insurance scheme in question, comma, immediate intimation within 48 hours by the insured farmer was to be given as per the process as laid down in the operational guidelines for implementation of the concerned scheme, that is the Bangla Shosho Bima. Full stop. Next para. It is submitted that it will be evident from the annexures to the writ petition, comma, in which the order was passed, comma, that the application making the claim was made by the petitioner about 2 years after the expiry of the scheme. Full stop. It is further submitted that the schemes are annual in nature and after the year 2019-2020, comma, the National Insurance Company is not connected with the said scheme at all. Full stop. Hence, comma, at the juncture when the application making the claim was filed by the petitioners, comma, the insurance company was not in charge of the insurance of the scheme. Full stop. Next para. Learned senior counsel for the applicant stroke alleged contemner further submits that he will take instruction as to whether the amount of premia which were collected by the insurance company up to 2019-2020, comma, which were lying with the said insurance company were refunded to the IDBI bank. Full stop. Next para. Upon hearing learned counsel, comma, it transpires that in the event the liability of the National Insurance Company was spent by the year 2019-2020, comma, the premise on which the order in question dated January 22, 2024 was passed is invalidated. Full stop. Accordingly, to give adequate opportunity to the applicant stroke alleged contemner to apprise the court of the correct facts and as to whether the premia were refunded to the IDBI, comma, the matter is postponed till June 13, 2025 when it will be listed under the same heading. You produce documents, Mr. Mujumdar, and give copies to the bank as well as them.
Well, whatever is there, we will produce.
Then that order has to be recalled.
Yes. Well, may I take your lordship's kindly?
Yes. The next matter will not be appearing.
Well, I have Mr. Ahmed in there. Well, actually, there is another division which I have to run.
Not another. There is a division wage. This is not a division. That is already gone.
That is already gone.
So let be here. At least on this.
Well, identical, but in this case, PNB.
PNB, yes, PNB.
Yes, your lordship. Lordship, there is
PNB, they have refunded.
Lordship, again, my lord, we have paid. If my lord may kindly takes up my opposition, your lordship. Things are a slight different, my lord, in this matter.
Mr. Mujumdar, if you, I should not make this comment. If you look at the representation of the petitioners, you will feel that the court should do something, go one extra mile for them.
I understand, my lord, but what
if you look at the quality of the representation of the petitioners, that would suffice for you to understand.
I understand
why the court is taking a proactive role in this.
I will try to resolve.
And this is content, we know our limitations.
Your lordship is.
We have your cooperation always. The council cooperate.
We will do so, but your
that is the only reason we are sticking to these things so much. Because the
understand,
order is without premise or not, we want to get these people something.
my lord, if these people are to get something, my lord, I
No,
think
not illegally, unlawfully.
no, my
Because you are depriving
that
somebody
is
else
why-
there
that
from
is
the
why, my
state
lord,
exchequer.
today your lordship, my lord, as fell from my lord, a balance has to be struck.
Balance has to be
between
struck, definitely.
competing interest of the community at large.
Yes,
and the
yes.
section.
Yes.
And your lordship has always followed that principle, my lord, so far as I understand, my lord.
But the meal we had in the morning, Mr. Mujumdar, you and I are produced by these people.
Yes, ma'am. Well, I
If
had
they
only
have a strike for a month,
I had tea in
then
the
we'll all be starving.
I understand, my lord. My lord, I told Mr. Ahmed that what are you doing in this matter? And why?
Yes, I was rather surprised to see Mr. Ahmed for
I
this
told him that why
on
are you
this side.
appearing in this matter?
Yes, he should be penalized for this in some other matter, where he appears for the correct
Or
parties.
he pays the amount.
He has to pay the amount, yes.
He pays the amount.
Yes.
That takes care of everything.
He will mint money, but it will be mint with a hole.
That's why Mr. Muzna at the outset had said that no.
So, Amit, I thought actually he was, I mean,
That's why
wrongly.
No. He is here with me.
Yes, Ms. Roychudi, what is your stand in the matter?
Yes, Your Lordship. Lordship, firstly, my lord, after your Lordship's order, we have communicated to the insurance company several times. We have sent letters, my lord, which are duly annexed in my opposition. My lord, thereafter, nothing done. If my lord
After the
may kindly
contempt
come,
application, you sent the premium to this insurance
not
company.
after the contempt, my lord, before the contempt only, we have sent on getting no reply, my lord. Again, we have sent the money back. If your Lordship kindly comes to page number 50, your Lordship, of my opposition.
Have we encashed that draft? No. We have not encashed the draft. Whatever
Malla,
draft,
that is not known to us. It has not been refunded back to us even. If Lordship may kindly, Malla, takes page number 51, Your Lordship. I'll be placing, Malla.
Demand draft was given.
but we
Yes,
have
Your
not.
Lordship. Demand draft is
Mr.
also
Mr. Mujumdar, please ensure this that demand draft is brought to court. We'll give you time, June 13th.
We will bring it to the court.
You bring it to court, and Ms. Roychudil, please be present on the next returnable date.
Lordship.
They'll return you the demand draft. We'll direct you to pay the. But how can you direct that even? Because this is
Yes, Your
insurance.
Lordship. This is the insurance company who has to do.
In terms of the guideline, if there is
Why
misreporting,
guidelines in any
If
event? There
my
has
lord
to be an
may,
assessment as to whether the claim is genuine.
in case of misreporting, it is the liability of the bank. The guidelines.
my lord, if I may indicate only one thing, Your Lordship. Lordship, when the writ petition was moved, my lord, the bank has made clear that the bank could not upload the document within the time. That is why,
Not
my
there.
lord, the time was
We are
extended.
not on that, Mr. Mujumdar. The liability you can fix on the bank, they'll pay. But the difficulty is this: the veracity of the claim also has to be assessed.
Yes, well,
Who will
that-
assess that you are no longer there?
I am not on that. Well, we come back to your lordship on 13th. That would be better, my lord. That would be appropriate.
I'll direct you to bring that demand
Yes,
draft in
yes.
any
Demand
event.
draft we have to bring.
Lordship.
Learned counsel appearing for the bank submits that the premium which were the premia which were refunded by the insurance company to the bank has again been tendered to the bank by way of a demand draft number 756969 dated December 6, 2024, comma, as it transpires from the communication dated December 6, 2024, annexed at page 50 of the affidavit in opposition of the alleged contemner number 1. First of next para, learned senior counsel appearing for the insurance company submits that even if any such demand draft has been handed over, comma, the same has not been encashed. Pushed up, the insurance company, the alleged container number 2, actually, you are the added.
2.
The alleged container number 2 shall the learned counsel for the alleged container number 2 shall furnish in court the said demand draft on the next returnable date for the purpose of returning the same on the bank. Full further orders fixing liability for the payment to the petitioner, comma, if the petitioner is so entitled, comma, under the concerned insurance scheme shall be passed on the returnable date. The matter shall next be listed on June 13, 2025, along with again number ta diye deba.
Deeply obliged, Your Lordship.
Your lordship's time.
Yes. Affidavit of
opposition, my lord.
একটা লাইন অ্যাড করে দাও affidavit in opposition filed to be kept by the alleged content number 2 be kept on record. Yes.
It's a new electric connection. My lord, kindly see for a moment. Your lordship's last order, 25th April 2000. Kindly see for a moment.
Above the ground or below the ground? Submersible or
Submersible pump, my lord.
below the ground? Underground.
We have connected, my lord, but fully defected, my lord. Where?
Court cannot go there and cure the defect.
Kindly for a moment. My lord, 25th
There
order.
has-
Your
there is
lordship's
a limit up to which the contempt court can go.
Your lordship's order, kindly see. 25th April. They are not complied, my lord.
Yes, Mr. Mukherjee, what is happening? Defective connections and all.
This is with due respect, my.
We'll direct the connection to the electricity connection to the council of the alleged container to be cut off.
Madam, what happened, my lord? Truly speaking, this is absolutely, my lord, with due respect, it's totally wrong, my lord. Because, my lord, after your
Use the
lord,
microphone, Mr. Mukherjee. Yes.
this is absolutely wrong because,
Why?
my lord, after your lordship's order, my lord, an intimation has been given to the petitioner to be present when we will make the inspection in their presence. They choose not to present, but they were there from the very distance, and it has been found, my lord. If you
They're there from a distance, they're looking.
they are looking. Now, my lord, kindly see that everything is within the within proper form, and it is not a bamboo. It is, my lord, permanent structure, and, my lord,
You choose to give a bamboo to your consumers, then what can the court do?
no, not bamboo, my lord. Always not. We are not.
It's a bamboo pole. You have set up a bamboo pole and given electricity connection.
This is not bamboo pole, my lord. If you actually permit, my lord, I can show from my
What is that?
mobile, my lord, the pictures and video, everything. But it is absolutely normal. It is functioning. Now, my lord, the order was to give connection. We have provided the connection.
If connection means a proper connection.
No,
If connection does not mean just like
if you
that
actually- if you actually see
bamboo
once-
pole.
If you actually see once,
What
my
is
lord,
that?
Videography, my lord.
First, you turn off your internet so that no messages come to you.
No, it is her mobile.
No, you have to give a copy to them also. Come in
But I am
proper
showing my videography, my lord. I am just showing to
Not
him, my lord.
videography, the photograph.
দেখো,
Picture I'm going to do.
দেখো, পুরোটা দেখো।
What does it show?
It is
But the
nothing small. It is
দাদা, দেখো,
ground.
What
দেখো
ground?
পুরোটা। তোমার অ্যালিগেশন তারটা ঠিক না, প্রত্যেকটা তার লাইন প্রত্যেকটা ঠিক আছে।
পুরো defective
না,
wire.
না, একদম নয়।
Fully defective wire.
How can
Anytime it will
this
be my lord,
person
fall
is
down, my lord.
I'll direct an inspection to be held. You have to pay for the special officer. But any special officer won't do. A person having technical knowledge has to go.
But that's why he ought to have been present. He was informed after your lordship's order.
You can appoint the electrician of your house to have the inspection
My lord.
of your house. You have an
It is
electrician.
order is that to give
We'll
connection. We have
ask him to
done.
go and see whether the
Yeah,
connection
right.
is proper.
It is not bamboo, my lord. Kindly see concrete pole, my lord. দাদা এটা পুরোটা
Pole is there, my lord.
লাস্ট অকেশন সাবমিশন ওয়াজ ব্যাম্বু পোল
Not
দাদা
bamboo, my
এটা
lord.
পুরো উল্টো হচ্ছে তোমার ভিডিওগ্রাফি হ্যাজ টু
Yes, what else has to be done by them?
এভরিথিং হ্যাজ বিন ডান
Electric wire. I also, my lord, I have a photograph.
Go to the grievance redressal officer.
if he has grievance he move before other forum, my lord. There is a provision he can move the order.
Anytime, my lord, they will be.
Why he
on the
choose not
art,
to have,
my lord.
and my lord, in his presence
Mr. Mukherjee, you furnish photographs to show the connection on the next occasion.
but if you are see once, my lord,
No, not like this. I have to keep something on record. You produce photographs of that area.
I also some photograph, my lord, is electric
You
wire,
also
my
produce your photographs, produce your respective photographs, and I'll
My
spend
lord,
the whole day
I am
looking through
obliged.
the photographs.
I am. Electric wire.
Let there be a local inspection day after tomorrow. I'll send somebody. Your person will go. You will have a local inspection in their presence.
My lord.
Give the time. Today we are on Friday. It will be on Sunday. Sunday your men will not.
Your lordship.
Monday then.
Monday.
Give us a time. What will be convenient to your client?
11 a.m.
12 a.m.
12 will be better. 12 a.m. will be difficult.
12
এই দেখুন তার।
A dispute has been raised by the petitioner as to whether proper electricity connection has been given to the petitioner in compliance with the order of this court. Full stop, next para. By the order in question, comma, an electricity connection was to be given to the petitioner subject to compliance of formalities. Full stop. It is an admitted position that such connection has already been given. Full stop. Learned counsel for the alleged contemner vehemently opposes the allegation that proper electricity connection has not been given and seeks to rely on the on certain photographs of the locale. Full stop. In order to find out a correct picture of the situs of the connection, comma, The alleged contemner is directed. What is the post of the alleged contemner, Mr.
Station manager.
Station manager won't go. Somebody else.
He is going. She is going, my lord.
She'll go. Directing this alleged contemner to Mr. Mukherjee, no protection will be needed. There is no scope of any.
But only thing, my lord, the name which he has given, he has already changed. New incumbent joined, although my lord, he has not made her party.
The current directing the current incumbent in the current station manager of what? What are the other details? Station manager of
IO Customer Care Center.
Station manager, comma IO, comma Customer Care Center shall visit the locale and hold an inspection in presence of the petitioner and stroke or the authorized representative of the petitioner in order to ascertain as to whether proper electricity connection has been given to the petitioner pursuant to the order of this court. Full stop. The said station manager shall be at liberty to take photographs and produce the same take photographs at the time of inspection and produce the same on the next date of hearing upon furnishing prior copies to the learned advocate for the petitioner. Full stop. Such inspection shall be held on May 19, 2025 at 12 noon. Full stop. Since the date and time of the inspection is being pre-fixed by this order, comma, no further notice is required to be given to any of the parties.
Madam, only one thing may submit.
A written report of such inspection shall be filed on the next returnable date. The matter shall next be listed on June 13, 2025.
Only thing, madam, that today we are in Friday. But if it is on Tuesday, we can get the server copy of your lordship.
Very well, very well. You'll get the server copy tonight.
Tonight,
আচ্ছা very well. তাহলে ওটা Tuesday 19 না করে 20 করে দাও. Let it be on 20th. 20th 12 noon, same time.
The 22 is the same as the item
22. My lord, I appear for the alleged contempt.
আবার second. Same matter মানে exactly same matter. দুবার করে appear. No, same matter means same order is required to be passed.
Not the affidavit, your lordship will kindly keep it on.
Yes, your lordship. In this case also, we have again paid, my lord, to the insurance company.
Punjab Bank is the party here.
Yes,
Only Punjab Bank. All these matters.
Punjab Bank and insurance company, my lord, insurance
No,
company.
insurance company is there, not IDBI or any other.
No, your lordship.
তন্ময় যেটা সেকেন্ড কন্টেম্পটা 20-তে যে অর্ডারটা হয়েছে সেটাই সব করা হবে বাট Mr. Singh, please ensure that affidavits are filed in all these matters.
Yes, my lord, I am ready with the affidavit.
আপনি একটা কাজ করুন, এগুলো সব এক এক করে ঢোকাতে থাকুন, একসঙ্গে ডাকুন। হ্যাঁ ডাকুন।
Lord, I face, my lord, one difficulty, my lord. I have not received the affidavit of the bank, my lord, with me. The bank, my lord, has filed this.
Bank is Ms. Rochester, please furnish
Well,
copies also. I mean, insurance company.
By Monday, your lordship.
22 to 32 same order, different আলাদা আলাদা করে পাস করো আর affidavits গুলো আপনি এক এক করে নিয়ে নিন।
In respect of the 25 and 26, my lord, I am for the Union Bank of India. My lord, I am submitting, my lord, the affidavit in opposition. I have served a copy.
ম্যাডাম ঝট করে নেবেন, ঠিক জায়গায় ঢোকাবেন।
25, 26.
করুন, আমি দিয়ে দিই। আমার কাছে সিরিয়ালি সব রাখা আছে। থ্যাংক ইউ।
আপনি শর্ট আউট করে দেবেন আর পরের দিন সবকটা একসঙ্গে অ্যাপিয়ার করাবেন, ঠিক আছে? সবকটা ট্যাগ করে দেবেন যাতে একসঙ্গে অ্যাপিয়ার করে আলাদা আলাদা করে করলে আলাদা করে
Only item 22, my lord, is addition in the list. Otherwise 21 is deleted, my lord. Then from 19 to 32 all are similar matters.
So apart from
My lord, I am not appearing in 25 and 26.
My lord, 25, 26, your lordship,
26,
yes, your lordship kindly record the filing of the affidavit in opposition, my lord, as your lordship's direct. And copy also has been given.
Order তাই হলো 25, 26 এ the affidavit in opposition filed by the alleged content your
Union Bank 1 to 5, my lord. Yes, 25 and 26 in both the matters.
Alleged container number 1 is also kept on record. So the 25 or 26 it add up. 21 is separate from these.
21 is separate from this, lordship.
Lord, I am handing over a copy of this, Lord.
তাহলে এখানে 21 তো রাখেনি, 21 তো হয়ে গেল। No, 22 to 32 we are calling.
Yes, sir.
So up to 32. Very good.
Yes, sir.
Yes, thank you.
Grateful to your lordship.
Grateful to your lordship. Much
Thank-
obliged.
Yes. কি শর্ট আউট করে নিন এখনই, পরে ম্যাটার টাকার আগে। উদর পিন্ডি বুধের গাড়ি চলে, ঠিক আছে তো? কি হলো? ঠিক আছে, ওইগুলো আস্তে আস্তে ঢোকাবে না, ঠিক করে দেখে দেখি।
Lord, I appear on behalf of the container number 1 and 2, the direction to file affidavits.
পড়ে যাবে না আস্তে আস্তে, অত টাকা
Reply দেবে তো? Lord, this is my affidavit, madam.
What was to be done by you, Mr. Mukherjee?
Madam, we have to give the connection, madam. We have rejected it on the ground. There was a direction to give the connection, but
You have to process the application.
yes, to process the application, but we processed, madam. We were late in giving them a reply because they were techno commercially, there was difficulty. That's why we could not.
If a reply has been given, what remains, Mr. Mukherjee?
Also, there is a specific direction. Also,
Within a time, they have jumped the time.
Lordship, kindly come to your lordship.
So, do you want to use any reply? Yeah, otherwise,
Lordship, I want to, lordship.
what will you say in the reply?
Lordship,
They have already intimated to you that it's techno-commercially not feasible. So they have processed your application.
No, Lordship, when
You cannot override the law.
Lordship, when the writ petition was moved, Lordship, kindly come to the lordship sort. Lordship, kindly come. No. Was obvious.
Yes.
Lordship, kindly come to paragraph 8.
8.
Page 24 of my contempt application.
Yes, I'm looking at that.
Upon such application being made, the WBSCDCL shall process the same, including giving consideration as to whether a switch certificate will actually be necessary for the petitioner to get electricity connection in the locality, and shall raise a quotation in that regard. Now, 9. In the event petitioner comply all formalities, the WBSCDCL shall give connection to the petitioner as expeditiously as possible. Now, Lordship, so far their initial objection was that I have not had no switch certificate. Lordship, switch certificate is not required. Subsequently, Lordship, I complied all formalities. Now they issued the reason order that the total cost will be incurred more than 2 lakhs. So
that's as per the regulations. It's on them to assess the costs. We cannot assess the costs. The regulations provide that if it's not techno-commercially feasible, you have to pay a share. Probably they have to pay a share, Mr. Mukherjee. Mr. Mukherjee, they have to pay some amount.
But,
you have to bear the amount for a station, new substation or something.
Distribution substation.
Yes, you have to pay for a new substation.
Page 18th of the affidavit in opposition.
দুটো আছে না?
One or two.
Same manner, more or less, all the
Page
documents.
18, yes.
On behalf of the
18.
Mr. Babu Hossain, alleged contempt number 1.
Yes, Babu Hossain, 18. Rejection.
Lordship, they have communicated this order on 7th. I don't know. I have my client 7th April. This order has been passed.
This was communicated late, man. I agree to that.
Now, after careful inspection, subsequent estimation, it has been determined the total cost of the proposal scheme amount to 4,08,301. And as per the office order number 50.
No, but Mr. Mukherjee, if they pay this cost, they for the substation you have to pay as per the regulations. You have not given that option. It's not that someone will go without electricity altogether. If it's not techno-commercially feasible, as far as I can recollect from my electricity days, that if it's not techno-commercially viable, then they have to pay for the substation.
They have to. The only thing, these notifications keeps on changing. Would you lordship kind of to keep it on next week so that I can take specific instruction and come if they pay, whether we can give it or not.
To pay, they have to give. But there is no contempt. You can dispose of the contempt by directing them to give you an option to pay. Or you say the notifications may not permit that also.
Because this is keep on changing, because on the last token, I kindly come to page 15.
So bring that notification in contempt and set it aside.
But the only thing I keep it next Friday. I'll take instruction.
Absolutely contrary to law.
I'll take instruction.
They have a right under Electricity Act to get electricity.
Just
And Article 2, yeah, you know the provision.
I'll just take instruction and come back.
Affidavits in opposition filed today by alleged container numbers 1 and 2 be kept on record. First of the stand taken by the alleged containers is that despite being late in complying with the order of this court, comma, upon the application for electricity connection being made by the petitioner, comma, by an order, by a communication dated April 7, 2025, comma, it was intimated to the petitioner that the SMP application was rejected due to techno-commercial feasibility. First up, it is submitted by learned counsel for the alleged contemner that the said intimation and adjudication was on the basis of the extant regulations governing the field. First up, Office Order number 52 dated May 5, 2012 has also been quoted in that regard in the communication. First of learned counsel appearing for the petitioner submits that despite the petitioner having complied with the formalities, comma, the alleged container has refused to give electricity. First up, however, comma, prima facie it transpires that the alleged container has acted within the confines of the WBERC regulations in assessing the techno-commercial feasibility and making the intimation in question to the petitioner. First of, however, comma, in order to explore as to whether connection can be given to the petitioner subject to the petitioner bearing the necessary costs, even if otherwise the project is not techno-commercially feasible, comma, learned counsel for the alleged containers seeks some time. Full stop. Let the matter be listed on June 13, 2025. Full stop. On the next returnable date, comma, the alleged containers shall apprise the court of the outcome of such exercise. Please inform Mr. Mukherjee also in advance whether that can be done. He'll take instruction also whether his client can pay or.
I'm good.
And please bring the regulations also on the next day, the notification and the regulation, so that you can decide on this finally. None appears for the part, key. Oh, watch. None appears for the parties at the time of call. Let them understand adjourn for the day. Over the 3.5 hours. ठीक है, लिखे जान लिखे. आपको कोटा है. ये फागले करो.
Lordship, I am appearing for the petitioner. This is with respect to
compliance of
payment.
the order, we have paid.
Lordship, an amount has been paid, not specified. What is the principal amount? What is the interest amount? How much is the interest?
We have
What
paid
is the interest
principal amount and as per prevailing rules.
Lordship, direct affidavit may be filed by the post office master of the Koshba post office, Lordship,
Well,
or as
we
the
have-
superintending of the offices, post offices, South. Lordship, the direct indicating how much has been paid for interest. Lordship,
No, you're filing some affidavit of compliance.
No, I have come with the
Mr.
order.
Bhattacharya, I'll direct you to file a formal affidavit of compliance, put it on oath, and you also give the breakup as she said.
I'm great.
Principal and interest.
Yes, Lordship. Also, here, Lordship will remember there was a quantum of interest that we had in the order in my writ petition. There was a specific direction that the interest component be adjudicated by the post office. Now, with that, with respect to that direction, if there was any challenge, I was supposed to raise the challenge. I have simultaneously raised the challenge in respect to the quantification of the interest, because the quantum of the interest percentage which has been levied by the post office, that is mere 4% of the amount that was lying with the post office from the
That
date of
challenge you have to
maturity.
raise by way of a fresh writ petition probably.
Lordship, I had indicated in my letter immediately when the meeting was held, I have raised my voice. Subsequently, when it was informed by way of a letter by the post office that we have that the post
Ms.
office has
Artosi, if they have paid the principal and they
Yes.
have paid the admitted interest, I'll have to dispose of the contempt application, but they have to be clear on that and leave, and I'll keep it open for you to challenge the quantum of interest.
Lordship
But in
had-
contempt, I cannot go beyond that.
Lordship, I shall indicate once the affidavit is on record.
Very
Lordship,
well,
may I come back on the next day, Lordship, and I am sure he'll require a week's time before vacation if we can.
No, we'll take it after vacation, definitely.
Lordship, may we come back with after the affidavit is
Yes,
filed?
yes, yes.
And Lordship, keep
We
it
shall file
open
a
for me
report,
to.
madam. We shall file a report, madam.
No, but you have to put it on oath by way of an affidavit and give the breakup.
In the form of affidavit.
Whatever you call it, you can call it a petition also, but it remains an affidavit. The alleged contemners, learned counsel for the alleged contemners submits that the order of this court has been complied with. Full stop. Learned counsel for the petitioner raises a question as to the breakup of the principal amount and the quantum of interest assessed by the alleged contemners. Full stop. Next para. It is pointed out on behalf of the petitioner that leeway was granted to the petitioner to challenge the assessment of the quantum of interest arrived at by the alleged contemners if need be. Full stop. Next para. As such, comma, the alleged contemners are directed to file their affidavits of compliance, a formal affidavit of compliance, stroke affidavits of compliance, indicating the actual breakup of the amount paid to the petitioner, comma, regarding what part of the same pertains to the principal amount and the portion allocated by way of interest. To sub next para, the connected papers shall also be annexed along with the said affidavit of compliance. Full stop. Such affidavit shall be filed on June 13, 2025 with an advance copy to the learned advocate for the petitioner by May 23, 2025. By May 23, give an advance copy to her within 1 week. Very well. By June 9, 2025. By June 9, 2025. Full stop. Exception. Now, liberty is given to the petitioner to take exception to such affidavit of compliance if so required on the returnable date. I have not directed written exception because you may not have the time to do that.
Yes, ma'am.
If you have a written exception, you can bring that also.
Very good. I'm grateful.
Yes.
I am appearing on behalf of the petitioner, Lordship.
Yes.
I reply, Lordship.
Yes.
Lordship, kindly come to
Rajya
the.
Dilo.
Yes.
You filed your opposition on the last occasion.
Already.
Affidavit of compliance.
Compliance. I file a reply. Lordship, kindly come to the compliance report. First, Lordship, kindly come to the page 15.
Yes.
The
15.
impugn order in the writ petition. Lordship, last portion I read out, Lordship. Third paragraph. However, this court by this order does not accept the claim of the ownership right over the surplus by the other parties concerned, which is subject matter of a judicial interpretation by the competent court, nor does this the order bars PW department to initiate the fresh proceeding of eviction encroachment of the surplus if statutory rules and procedures are duly observed. The section 10(1) proceeding was initiated on the basis of the order passed by the so many writ petition was filed order on the basis of the writ petition. The sub-divisional officer remand back this matter, granting liberty to the authority concerned to initiate again 10(1) proceedings. Thereafter, I challenge this order, Lordship. Thereafter, Lordships then Lordship's order.
You were the complainant. You said that there was illegal encroachment.
Yes, I initially I complained against the 8%. Thereafter, authority inserted more than 60%.
Maybe they were found in the unlawful.
Thereafter, Lordships order. Page 30.
Yes.
Paragraph 14. Thus, WPA number such and such is allowed, thereby setting aside the impugned order dated August 31st, 2022, passed by the sub-divisional magistrate, insofar as the observation the said magistrate regarding the notice being insufficient is concerned, and insofar as the proceeding were dropped and fresh proceeding for eviction were directed to be drawn up, the concerned SDM shall now proceed from the stage where the proceeding had reached at the time of passing of the impugned order dated August 31st, 2022. Thereafter, Lordship, at a time limit is there, 2 months, Lordship.
Where is that fresh order?
Thereafter, last fresh order, Lordship.
35.
39.
Page 39, Lordship, start. I am not going to go to the all orders, Lordship. Page 41, regarding point number also. all the plots. Observe that the PW authority land of the government land under the PW authority. Even if last portion lossy for page 42. Lossy got it, lossy? Paragraph number 4. That the 10-1 proceeding initiated by the AEPW roads on 18/10/2017 is therefore terminated by this court at this stage, initially under section 10(1) of the West Bengal Highway Act, due to its reliance on incorrect BLR demarcation report. However, this order does not recognize the title position by the petitioner or OP. PWD are free to start a fresh proceeding under section 10(1). I come before this honorable court against the remand order, then lordship's order, thereafter authority again demand.
What was the reasoning? Let us see the reasoning.
Reasoning lordship, I placed
For the
this
demarcation reports 2 and 3.
2 and 3.
Land schedule demarcation. Ownership of PWD could not be established.
Ownership regarding ownership cannot be decided by the
prima facie it has to be. Otherwise,
Yes.
how can it be held to be PWD land?
Lordship,
If it is not PWD land, there
yes,
is no question of this
Lo-
act application.
Lordship, page 41, Lordship, point number 2,
Yes.
plot number 7. These
Been acquired.
the 29 is out of 36 decimal of plot number 7, Mujar Ason falls under the purview of West Bengal Highway Act 1964. Before that, PW authority submit the plot inspection position document. Next point also, this 4.5 decimal of plot number 246, Muja Hamajita falls under the purview of West Bengal Highway Act. Next lordship, B, plot number 5, Mujar Ason falls under the purview of West Bengal Highway Act.
Yes, right.
Thereafter, lordship order again remanded back on the ground. The BLR report is not authority. Subdivision officer can ask the BLR to file a fresh report.
That liberty was also given.
Yes, I challenge the remand order.
LA case lapsed.
Lordship,
No, they say that it was acquired, but the LA case lapsed.
that is regarding plot number.
Yes.
Lordship, that is regarding
LA1 of
LA1. It was plot number 7.
Achha, not regarding 2, 3 and 4.
Plot
Not
number
regarding 246 and 5.
plot number 6, lordship. That was here, lordship, first page 39.
1 of 65, 66 is regarding plot number
6. LA case.
Achha.
But point number
But regarding the other ones, it could be proceeded with.
Yes.
Yes, what is this, Mr. Datta? You have on frivolous grounds 2, 3 and 4 you have held. You have clearly held. This is just contempt of court, because we had given you opportunity to do open to the SDM to direct the concerned authorities to produce proper land acquisition map and other corresponding documents to substantiate. You have not done that. You relied on whatever was there, and again, this is contempt. He will be present in court.
In my humble submission, my lord,
This is not only on the veracity on the legality of this order. The way he approached plot number 7 to 46 and 5, he held it is acquired under particular LA cases.
there is an indication that these LA cases may have been lapsed.
Not all those.
That was
And he
regarding
held
plot
there.
number 6.
That was regarding plot 6 only, which in any event he has held in the previous page. Page 40. Page 40, we are not on that. He has a right to do that. He has adjudicated properly with regard to that plot. But what about the other? That pertains to LA case 1 of 65, 66. And regarding the other plots, other LA case numbers have been given 95 by such and such.
90, all 95, 2 cases are
All
95.
pertain to 95.
95. And lordship's order is specific order is that on that stage.
Yes.
With regard to this, may I submit, subject to your lordship's kind consideration? First is that the first round of litigation, the matter was remanded back on certain counts why the order was bad. Your lordship had remanded back on certain grounds. Now, good, bad, indifferent, an order has been passed. But in my humble submission, my lord, return of a wrong finding may not be kindly considered to be a contumacious. My lord, it may be a wrong finding, but in my humble submission, that may not be considered to be contumacious.
Yes, Mr. Das, she has proceeded from the stage where the proceeding was reached at the time of passing.
From the started the proceeding from that stage. Thereafter, said lordship passed the order which was under challenge.
It's a wrong order. Mr. Dattu has a point there because regarding plot 7, 246 and 5, it's clear that the order does not touch that. But why do you say it's contempt? It's a wrong order. And in a fresh writ petition, which you can challenge this, you can take the same point that it is not in consonance with.
Then lordship.
Suppose a remand order is passed by a first appellate court. Trial court goes beyond that. Do we file a contempt application? We file an appeal against that and say that it was beyond the remand order.
No, lordship's order from that stage.
That he has done.
Yes,
From that stage he has done.
in the initial order also remand order 10-1.
Maybe there will be 10 remand orders, but we have to see whether on this case there is a contempt of the order, the deliberate and contumacious violation.
Then another. Lordship petitioner come to the court set aside the order and say, remand back this matter, and authority also remand back this order again and again, every time. Lordship then litigant is going. Another thing, lordship, kindly see the my contempt petition. I annex the whole order. Lordship was specifically directed within 2 months. The authority fixing the date of hearing after 2 months, every 2 months on interval. If lordship was directed with complete the proceeding within 2 months. Thereafter, lordship, kindly form order number from my contempt petition, lordship. It was page 27, from 27, I annex the whole order. 27, page 27, date fixed on 17th January 2024.
And also he has not complied with the order. It was kept open for him to direct concerned authorities to produce. He has just shirked his duty. Borders on contempt, Mr. Dattu.
But he has, in a way, my lord, remanded the matter and directed.
Previously has done the same thing.
But in my humble submission,
he has a habit of remanding. Let him be remanded now to his home.
He has returned the same finding. I accept it, and there has been some delay. But my lord, the reasons of wrong reasons may not be held in contempt.
No, this is not merely wrong reason.
Return of wrong reasons.
Not only that.
Then, my lord,
there is an element. Well, issue a rule, let him come.
May I then use an affidavit in opposition?
No. How many opportunities? What will you do? The order is before us. It is contempt.
If I may be allowed.
I'll issue a rule. You can show cause against that rule. And he'll be present on the next date. And he'll file a show cause.
If I may be allowed to at least explain.
Explain what, Mr. Dattu? The order is before us. Order will speak for itself. He has not given any we had given him opportunity to direct the concerned authorities to produce a proper land acquisition map and or other corresponding document. He has relied on a single 2 reports filed by the BLRO, not called for anything else. And why did he issue the notice after 2 months?
Every 2 months interval, lordship.
That definitely.
Fix the hearing every 2 months, at 2 months intervals.
1 month and 2 months interval. Sometimes it was interval 2 months, sometimes it was 1 month.
The affidavit of compliance, it transpires from the affidavit of compliance that purportedly pursuant to the order of this court dated December 6, 2023 in WPA 22875 of 2022, the alleged contemner, by an order dated April 2, 2025, has disposed of the proceeding under Section 10 of the West Bengal Highways Act 1964. Full stop. Learned counsel for the petitioner points out that in the order of this court, comma, it was kept open for the alleged contender to direct concerned authorities to produce proper land acquisition map and or other corresponding document to substantiate the case of encroachment made out in the proceedings. Full stop. Next para. However, comma, the same has not been resorted to by the alleged contender. Full stop. Not only that, comma, it is argued that in blatant violation of the timeline of 2 months given by this court, comma, within which the proceeding was to be positively concluded, comma, the alleged contender fixed even the first date of hearing after 2 months from the date of communication, and thereafter has been fixing dates at intervals of either 1 month or 2 months generally. Full stop. Next para. As such, comma, it is argued that there is blatant violation of the order of this court. Full stop. Learned counsel for the alleged contender submits that even if there is some legal or factual error in the order dated April 2, 2025, comma, the same may be challenged before the appropriate forum. However, comma, it cannot be said that merely because of such error, comma, there has been some deliberate, comma, willful and contumacious act on the part of the alleged contender. Next para. However, comma, there is more to the matter than meets the eyes. Full stop. It cannot be lost sight of that on the previous occasion, comma, when the writ petition itself was preferred, comma, the same approach was taken by the alleged contender. Full stop. At that juncture, comma, an order of remand was passed, comma, against which the writ petition had been preferred. Full stop. It transpires that the alleged contender, he was the same officer.
No.
Full stop. Next, although the officer who had passed the order impugning the writ petition was a different person than the present alleged contender, comma, it transpires that the office of the subdivisional magistrate, comma, Egra, is inculcating a habit of remanding matters by shirking their own responsibility of adjudicating matters on merits. Full stop. The error in the impugned order is not restricted to a mere legal or factual error. Full stop. First, comma, despite the specific direction of this court to conclude the entire proceeding positively within 2 months from the date of communication, comma, the first notice of hearing was given beyond 2 months, and thereafter it became a monthly affair of fixation of dates. Full stop. There is no plausible explanation in the purported affidavit of compliance as to such delay in even initiating the proceeding beyond the time within which the entire matter was to be disposed of. Full stop. Next para. Secondly, comma, in the teeth of the specific finding in respect of plot numbers 7, 246 and 5 of Mouza, Rasan, comma, Hamarjita and Rasan respectively, comma, to the effect that those belonged to PWD or were recorded in favor of the PWD, comma, the alleged contender proceeded on the premise of LA case number 1 of 1965-66, which pertained to a different plot altogether, and again remanded the matter back by directing initiation of a fresh proceeding under section 10 within bracket 1 of the West Bengal Highways Act, 1964. Full stop. It is surprising that despite the order of this court having left it open to the alleged contender to direct the concerned authorities to produce a proper land acquisition map and stroke or other corresponding documents to substantiate the case of encroachment, comma, the alleged contender, comma, instead of doing so, comma, merely came to the finding that the demarcation report produced before him did not identify the encroachers correctly. Full stop. In the event the demarcation reports were held to be null and void by the alleged contemner, comma, which has been done in the order passed subsequent to the order of this court by the alleged contemner, comma, it was the incumbent duty of the alleged contemner, comma, in terms of the direction of this court, comma, to direct concerned authorities to produce appropriate land acquisition map and or other corresponding documents to substantiate the case of encroachment. Moreover, comma, the palpability of the error in the impugned order cannot be said not to be willful and deliberate, comma, since, comma, in spite of having held in favor of the ownership of PWD in respect of plot number 7, 246 and 5, comma, in the very next paragraphs, comma, the alleged contemner has shirked responsibility and has dropped the entire proceeding by directing fresh proceedings to be initiated under section 10 within bracket 1 of the 1964 Act without taking the proceeding to its logical culmination by directing encroachers to be removed from plot numbers 7, 246 and 5. Full in such view of the matter, a prima facie case of contempt has been made out. Full accordingly, a rule do issue calling upon the alleged contemner to show cause as to why he should not be punished in terms of the prayers made in the contempt application for the willful and deliberate violation of the order of this court dated December 6, 2023 in WPA, passed in WPA 22875 of 2022 by paying lip service to the said order and having palpably flouted the essential components of the said order. The rule shall be made returnable on June 20, 2025 at 2 p.m. You also prepare a show cause and bring it on that date so that you can do the needful on the same day. He will come and bring the show cause and we'll decide on that. Yes.
37, I'm the petitioner. Rejoinder to the ability to compliance by the petitioner be please kept with the record. I served the copy of the compliance today. May this matter be fixed
Today?
Today.
Serve the copy of the exception.
Yeah, I served it today. May this matter be fixed next after vacation.
He just told everything on you.
After vacation. Right.
Say anticipated what he will say. We'll keep it on 13th, then the first Friday after the vacation.
My lord.
June 13th.
My.
The rejoinder to the affidavit of compliance of the alleged contemner, comma, filed by the petitioner today, comma, be kept on record. Since a copy thereof has been served only today on the learned advocate for the alleged contemner, comma, let the matter stand adjourned till June 13, 2025, when it will be listed under the same.
And only one thing, my lord, my lord, that is paragraph 5, your lordship on the last occasion order, even if any reply is short, that I can use the reply.
To this?
Because your lordship's last order is actually indicated.
Reply, comma, if any, to the rejoinder shall be filed on the returnable date with an advance copy to the learned advocate for the petition.
Deeply grateful.
My lord, I appear for the petitioner, my lord, appearing virtually.
Yes, please.
My lord, they had, my lord, preferred an appeal. Last day, lordship had recorded in the order unless they bring some kind of a stay, my lord, lordship would proceed with the contempt.
Yes,
but I must indicate today
Yes.
before the division bench, my lord, it was orally observed, not written down, my lord, that we will not pursue the contempt because the division bench kept it 1 week after vacation. So
Very
the only prayer is, my lord, 2 weeks after vacation, lordship kindly keeps it. That will give some impetus to them to, my lord, move the appeal.
Very. Learned counsel for the petitioner, comma, in his usual
My lord,
fairness,
one
comma.
more thing. I'm sorry, my lord,
Yes,
for an
yes.
interjection. One more thing, my lord. There has been a change in the name of the petitioner. My learned junior is there with the, my lord, certificate of incorporation. If lordship permits, we can incorporate the change, my lord, if lordship permits us, in the, my lord, records of the court.
Very well. There has learned counsel for the petitioner submits that there has been a change in the name of the petitioner in the meantime, and the certificate of incorporation.
My lord.
And
Yes,
and a photocopy of the certificate of incorporation in that regard is filed in court and kept on record. Full stop. Necessary consequential amendment to the cause title of the contempt application shall be carried out by the learned advocate on record for the petitioner during the course of the day. Full stop. Next para. It is submitted that the appeal preferred against the parent order came up before the concerned division bench, which has kept it in the first week.
Yes, 1 week after vacation. That is what was
1 week.
observed.
1 week after the reopening of court, after the subsequent to the upcoming summer vacation of this court. Full stop. Accordingly, let the contempt application be listed on June 20, 2025 under the same heading to await the orders, if any, passed by the division bench.
Grateful, my lord.
Thank you. But please do that during the course of the day with that correction.
Yes, my lord.
Yes.
Number 39. Thank you, Lordship. My lord, this is my application.
This not for the first time. There are
First
envelopes.
time. My lord's order is at page 18.
Oh, this is appearing for the first time?
My lord. My lord's order is at page 18.
18.
The direction is at paragraph number 6, 7, and 8. Page 19.
What have they done?
My lord, section 10(1) has been complied so far.
Only notice has been given?
Yes, my lord. Notice of removal has been done by the assistant engineer of the PWD. Thereafter, nothing is done. The next step has not been taken.
When was the notice given, Mr.?
My lord, notice is at page.
Give me the date only.
This is.
Was any timeline fixed? Timeline was not fixed. Inquiry
my lord, it was as expeditiously. It was there.
Then there is no contempt. There is a contempt.
My lord, kindly see that it is.
No, the inquiry shall be concluded within 4 weeks from date.
Initiated
but that was a preliminary inquiry.
Paragraph 8, my lord. My lord's order.
Proceeding has been initiated.
Has been initiated, but
no
they are
contempt.
doing it in a lackadaisical manner.
No contempt.
They are not doing anything.
No contempt. Learned counsel appearing for the petitioner submits that in willful and deliberate violation of the order of this court dated April 25, 2024, passed in WPA 7858 of 2024, the alleged contemner has not yet taken concrete steps in initiating proceeding for removal of encroachment on PWD land.
It is already 1 year is over.
In terms of the said order. Full stop. It is pointed out that despite the passage of a year in between, only a notice under section 10 within bracket 1 of the West Bengal Highways Act 1964
my lord
has been given. Full stop. Next para. Although the petitioner has a point in submitting that there transpires to be some delay in complying with the order of this court, I find from the order dated April 25, 2024 that no specific timeline was fixed, and it was only observed that the proceeding should be initiated and concluded as expeditiously as possible. Full stop. As such, since the nature of such directions, since such directions are in the nature of orders in terrorem, it cannot be said that the extreme step of punishment for contempt for willful and deliberate violation of the order of this court can be meted out, meted out to the alleged contemner. Full stop. Thus, although a cause of action might have been created in favor of the petitioner for taking out a fresh writ petition to ensure that a timeline is fixed for the conclusion of the proceeding in question, I do not find that any case of contempt has been made out. Full stop. Accordingly, CPN 467 of 2025 is dismissed without any orders to cost, with the above with liberty to the petitioner to prefer a fresh writ petition alleging inaction on the part of the alleged contemner in compliance with the direction of this court dated April 25, 2024. Oh, Mr. Kaushal, only you are appearing. Just give it on a slip of paper, Mr. Islam. It will be difficult otherwise.
My lord, 40. My lord, I am in an embarrassing situation to pray your lordship for another 7 days time.
Second time.
No, I have, my lord, this. No, not
Let us send Mr. Cole to jail so that.
That your lordship.
If Cole is sent to jail, none of the orders will be complied with.
That your lordship
is the
can
factor
always.
which is in between court and the WBSC. Because these people are there, the orders have been complied with still.
Well, I just,
otherwise, the entire WBSCDCL officials would be behind bars.
well, what has happened, my lord? 2 poles have already installed. Meter has already issued in his name.
North and the south. There will be North Pole and South.
No, my lord, there is some.
You also install the equator.
Kindly give me 7 days time. It will be complied with because station manager says 2-3 days. My lord, I abundant precaution. I am praying, my lord. 7 days.
Learned counsel for the alleged contemner submits that the order of this court shall be complied with. First up, it is submitted that already 2 poles have been installed to the end. First up, learned counsel for the petitioner points out that already 2 adjournments have been given on such count. First up, be that as it may, since the purpose of the court is to ensure that the order of the court is complied with. First up, another opportunity is given to the alleged contemner to complete to comply with the order of this court in full. First up, accordingly, let the matter stand adjourned till June 13, 2025, within which the alleged contemner shall positively comply with the order of this court.
I'm grateful.
You get more than your 1 week.
No, actually, my lord, work was started. That was true.
Okay.
Grateful.
Yes, Pathat matters. Yes.
The last occasion, my lord, I was addressing your lordship.
Yes. এটা এরকম অর্ডারের সঙ্গে বেঁধে দেবে। আচ্ছা, একটা কথা বলছি, এরকম অর্ডারের সঙ্গে এই হ্যাবিটটা এবার ত্যাগ করুন। এই অর্ডার এটা কি আমাদের এই মামলার অর্ডার? না, এটা অন্য। আমাদের অর্ডারের মধ্যে যেন আর কিছু না ঢোকে। তাহলে ঠিক আছে, তাহলে ঠিক আছে। এটা রেসপন্ডেন্টের রয়েছে, অ্যাপেলেন্টটা কত আরেকটা নোট ছিল না? শুধু রেসপন্ডেন্টের নোট। ওহো, এই যে এর সঙ্গে ঢুকে এর সঙ্গে স্টেপল করে দেবে না? Yes, last occasion.
I had tried to demonstrate, Lord, the difference between Lord occupation certificate,
Occupancy certificate.
occupancy certificate,
And completion
Lord
certificate.
completion certificate.
Yes.
Lord, I had placed before your lordship the provisions.
Mr. Kormakar, complete your submission in a nutshell and I'll direct written notes to you file.
Lord, a few points had to be met. Lord,
Make the few points, make it few.
One point was raised with respect to limitation.
Yes.
Lord, I was in reply to that Lord limitation point. I was addressing
43, 44, should I release them? Nobody is there to release. All they are appearing with you.
No,
43, 44 released.
this will take some time. Yes.
Yes. Yes. Please
Lord,
continue.
With respect to limitation, in reply to the aspect of limitation, Lord, I tried to make a distinction between Lord completion certificate and occupancy certificate. The reason being, Apartment Ownership Act, after the Lord incorporation of Rule 2A, Lord says completion certificate. Lord, I also tried to demonstrate before your lordship that initially, Lord, there was no.
Yes.
Initially, Lord, there was no concept of this occupancy certificate. This occupancy certificate concept came for the first time in 2002. And 2002 onwards, your lordship would find all the Lord provisions that I had indicated on the last occasion. Lord,
You also refer to the RERA Act.
Yes, everything.
Because that
RERA
is
is 2000.
parliamentary, yes.
Everything, all. So, Lord, this concept of occupancy certificate is only to address, Lord, the problems that these entire big projects used to face. That's why, Lord,
part of the project is completed. They have to be given, occupation has to be given, but the completion certificate is still awaiting. That is the reason.
That is the reason.
Yes.
So, Lord, in this case, Lord, apparently, all the annexures, those have been annexed by them and by us also. Your lordship has seen only occupancy certificate is there. There is no completion certificate admittedly. So, Lord, once there is no completion certificate, the time cannot run as per Lord Rule 2A of this Act. Now, my lord, they had cited a judgment, Lord, where I was at the receiving end, Lord.
But they are appearing in that matter.
That matter. Lord, I could not convince your lordship, Lord. The facts were something different. Later, Lord, I came to know about that.
Yes.
Be that as it may, Lord, in that matter, the completion certificate was granted. It was a standalone building. This was a standalone building and completion certificate was granted. Your lordship would kindly come. Paragraph 5. The learned senior counsel contends that the application declaration for bringing association within the fold was also patently time barred since the completion certificate response was issued in the year 2011. So, Lord, the premise of that judgment was completion certificate was issued in 2011. So, the question of, Lord, this application, this, Lord, judgment being applicable to my case does not arise. The reasons, Lord, I have already indicated because of the way the law has developed.
Yes.
So, Lord, this is the answer to their point of limitation. Yes. Now, Lord, the second point was with respect to the date of submission of declaration and, Lord, acceptance being on the same date. That was their second point. For that, Lord, they had indicated
So there was no scope of any notice or anything.
Lord, I'll show it from the order passed by the competent authority that, Lord, the application was made previously. Thereafter, a hearing was provided. And on the final date, Lord, the formal hard copy was submitted. That was accepted. I shall demonstrate that. Lord, 25. Wait, Lord, kindly comes to the straight away to the Lord, the order passed by the competent authority at page 80. 3rd of Lord, August 2022. I'm sorry, Lord, affidavit in reply. The affidavit in, I'm so
Page 80 I've got, and that contains 3rd of August. So this must be.
Lord,
Yes, reply.
Kindly comes to kindly comes to page 84, facts with respect in the instant case. This is the recording of, Lord, the competent authority. Online application for formation of association with respect to Greenfield City was made on 29th of March 2022. Now, Lord, this online application thing in furtherance of, Lord, the powers of the competent authority to facilitate, Lord, this filing, Lord, of this declaration and all, Lord, the government of West Bengal had issued a circular of, Lord, April 30, 2021, whereby how Form A and Form 1 for formation and registration of association has been, Lord, laid down.
So that contemplates an online application.
Yes.
The notification was dated 30th April.
30th of April. I'm just not handing up a copy. Lord, grants me 1 minute.
Yes. They can find
Lord,
in the meantime, you can continue.
Yes, Lord, may I just hand up? I have only, Lord.
1 copy, you should give 1 to them.
Yes. Andara piche chole geche ora. একটু বের করে দাও। ওই যে একটা দেখ অনলাইন অ্যাপ্লিকেশনে সার্কুলার আছে গভর্নমেন্ট অফ ওয়েস্ট বেঙ্গল।
Yes, portal.
দাদা আমি একটু প্লেস করে দিচ্ছি তোমাকে। Your Lordship has seen the circular first page. Thereafter, Your Lordship kindly turns over guideline regarding practicing such and such.
Yes, yes. On the portal, it has to be.
Portal, it has to be
Menu
done.
is
The
given.
manner in which it has to be done.
4 steps.
Kindly
download.
turns over to page number 3, internal page number 3.
Yes, 3.
Competent authority, the Milord second paragraph.
Yes.
Competent authority, after examining the same in the system, will approve the application. If found correct and immediately an auto-generated information of such approval of application and a request for submitting hard copy of Form A. Solemnly affirmed before the magistrate or notary, either magistrate or notary, with all its annexure as per law of his office, be sent through SMS and email to the registered mobile number such and such. If any other competent comment made by the competent authority regarding the application, it will be updated in the system and auto-generated such and such. Comment will be sent to the such and such. So, submission of hard copy of form is there. Whom to submit, such and such, where to submit, documents and papers, such and such. Everything, the manner is there. Disposal of Form A, kindly turns over. If after examination of the Form A, it is found that the property concerned comes within the purview of West Bengal apartment owners, such and such, and the declaration is in order.
No difficulty on that, but Mr. Karmakar,
my lord,
if notice was given only to the declarants. Same mistake.
Lord, the problem here is, Lord, what the authorities would have adjudged. I'll address on that also.
Notice has to be given on all concerned.
Lord, all concerned, that is also there. That notice in Form E was also given.
It appears from page 83 that only declarants were given the notice.
Lord, the notice is under Form E, that the declarants are proposing to submit this society before the competent authority. That is Form E.
Please read the next sentence. Online application was made on 29th March, and the very next sentence says on 9/4/22, CA issued a notice to the declarants under clause A 10A. His apprehension is still the same, that declarants only have to serve to attend the hearing.
Lord, may I place section 10 once for this 10A of the apartment?
It has been held in other cases that not only the declarants, all have. What is the purpose of giving a notice to the declarants only?
The notice of the notice to the other parties were already there. Kindly comes to
recording.
Kindly comes to Form E once. It's on record. Form E is on record. Form E is on
reflected because you're relying on this for the narrative.
But if form
and it is reflected. The declarants present in the said hearing submitted a letter. Everything, all the
because no objection was raised by the other owners.
Nothing. If there was a notice on the others, they should have been mentioned here.
Not kindly comes for once, not for to Form E.
We cannot go beyond this order, Mr. Karmakar.
Yes,
you cannot just spring up a surprise on the other side that Form E is there.
It's there on record.
If the competent authority does not record that, then how can we rely on you? You are a party. How could you get hold of that document?
It is my specific case that before Milord depositing or submitting Form A, I had given a Form E notice to all the parties concerned.
That's different. Under 10A, clause A,
my lord,
notice is to be given to all. Just see the languages, read out the language of 10A.
I shall.
Clause A.
Any declaration referred to such and such on receipt of a declaration or an amendment thereto or an instrument referred to such as the competent authority shall, after issuing notice to the parties concerned.
This parties concerned has been interpreted in judgments.
Yes. Now,
all parties who are concerned.
Parties concerned here.
Parties interested.
But then the requirement of Form E.
Otherwise, the language would be declarants.
I understand what is falling from.
Or the applicants.
Else, Lord, the requirement of Form E will be adjudged as nugatory. Look, that is the purpose of Form E. Kindly comes to Form E once.
देखिए बोलते दिन apartment ownership. West Bengal apartment. You can read out the relevant portion in the meantime.
Yes. Intentions of notice to submit the property under the provisions of the West Bengal Apartment Ownership Act to such and such, my lord, all concerned. Submission of our property situated at such and such to the provisions of such and such under this act. Sir, We are the owners of apartment number such and such, respectively situated within the property aforesaid. We intend to submit our property to the provisions of the such act. We have information that you also own apartment within the said property. In view of the above, you are requested to furnish the particulars of your apartment as required in Form A, and you are further requested to execute Form A when the same will be prepared. So, my lord, after this notice is formally given, or my lord, affixed in the notice
This
board.
notice is under Rule 6.
Yes.
This is a prior notice.
Prior notice.
But upon getting that declaration, the competent authority itself has to give another notice under Rule 10.
That, my lord, to that, my lord, once
These are two different steps.
Lord, once Form E is complied with and nobody comes up with an objection.
Yes, yes.
Lord,
Again,
then the requirement, my lord, perhaps, my lord, under Form A, my lord, what the authorities will adjudge in Form E. May I, my lord, address your lordship on that? What
whether the others are
can be
willing,
addressed?
whether the others are willing, it has to be the majority.
Yes. Here the majority is there, my lord, before
you are saying that they may come and dispute. They said they are not the majority.
There has been a vote.
They may say you don't have any locus standi. You
What-
are not an owner even.
What is the problem? What is the problem here?
They may say many things, Mr.
What is the
Kormokar.
problem here is they want, my lord, HIG community to be segregated from the
Whatever
MIG
they may
community.
want, we cannot look
That
into
is
their
their
minds.
only
But
objection.
we can look at the statute.
No, that is their only objection. There is no other objection coming forth before your lordship. The only objection is they want two my lord, associations to operate from a single my lord, project. That is impermissible under the law. That adjudication
Whatever they want,
is not
you have to
required.
comply. The competent authority cannot be governed by their intentions or cannot look into their minds.
Yes.
Competent authority has to follow the law.
Lord, with respect, my lord, may I address your lordship on this? That the objections that they have raised, Lord, if it is beyond the scope of adjudication of the my lord, authority, then the question of my lord, that adjudication will be not
Competent
required.
authority has to give a notice on all the parties concerned.
Lord, it is to the parties concerned.
To the parties concerned, and if you read that with Rule 6 and E,
my lord,
they also become the parties concerned. Unless they were parties concerned, Mr. Kormokar, why would there be a necessity of giving a prior notice to these people?
If they have any objection to submit, that's why to record that objection, my lord, this notice is required.
You may dupe the competent authority. You may frivolously file something to show that you have served notice, but you have not actually served.
Look, that inquiry has to be made. That inquiry has to be made. Look, without that inquiry, there is no allegation of that sort even anywhere in the petition also. Not in the pleading, not in the objection.
It's a statutory non-compliance. You have to give notice to the other party.
But the only
you cannot this modus operandi of bypassing the other side. This is deprecated everywhere. Statute categorically provides under section 10 A to small a that you have to give a notice on parties concerned, and by virtue of this and by virtue of Rule 6 read with E, they become parties concerned automatically.
Lord, may I place this in different way? Lord, kindly
parties concerned has been settled.
Lord, kindly seize, Lord, the Form E once again.
Whatever.
That's the reason.
There would not be any requirement of this Form E if they were not concerned parties.
That's the reason why particular persons are invited, Lord, if they are interested to, Lord, submit their Form A. That is important. That is the most important point. For being parties concerned, one has to come up before the authority, because the authority will not, Lord, go and inquiring, Lord, how many flat owners are there. The flat owners have to come up. That's why Form E is required. If your lordship is satisfied on that, Lord, then kindly, Lord, seize from this angle. Seize the matter from this angle. Lord, Form E is given in a situation to notify all the building owners, all the apartment owners. Lord, once that apartment owners are notified, if they are interested, persons will come up and file Form A. If not, then in such a situation, they will raise an objection saying that the majority is not there with you, you cannot submit. These are the two objections.
Oh, Mr. Kormokar, absolutely not. Rule 6 is for the purpose of ascertaining if everybody is wanting to join you in that application.
Yes.
Rather, contrary to what you are submitting, those who do not agree, do not respond to that, does not mean that they don't have an objection to your filing that declaration. It rather means that they don't want to join you. If somebody does not respond, That means he or she does not want to join you in that application. That presupposes that they may have an objection to your application.
That will
Contrary to
them-
what you are submitting, you are submitting that if you don't respond, you don't have any objection. No, rather that notice under Rule 6 is for inviting them to join you in the declaration. If they don't respond, they may oppose your application. That's why they may not
Absolutely,
respond.
I'm on that. If
So
the-
rather the parties who responded, they would be joining you. If they don't respond, they would become more parties concerned.
it will be their duty then.
No duty on
the
them. Absolutely not. They cannot go and keep a watch and spread a newspaper and sit on that and wait for the entire day when you will come and file that application. No,
The representation has to be there.
no, nothing has
That's
to be given. No,
properly.
no. Rule 6 read with rule for me does not mandate on the non-responding parties to do anything. To do anything, they may sit tight. You may give a notice under section for me, and then you may not make the declaration ultimately. Suppose I comprise of some of the owners. I give a for me notice, and then I see that nobody is joining. I may decide not to go there and file that application or the declaration. I may decide that. How do the others know who are not responding? That is the mode of notice. That is why section 10 to A provides that you have to give a notice on parties concerned.
But in such
All
a
owners.
In such a situation, all owners
That would be an absurd proposition that the non-respondents won't be given a notice.
notice to all owners. For that, the particulars of the apartment holders who have been sold, who has that has to be there also before the competent authority. It is not there.
That is the problem of the competent authority. They may direct you to do it. You have to do it. You don't know the forms. You have not looked into the forms. But that is the lookout of the competent authority. Competent authority asks you to furnish. Competent authority may of its own ascertain.
Very, I shall address, in that case, I shall develop that.
There is no notice on them. How could there be? You are challenging this.
Yes, my lord.
This order is challenged here.
Not only that, my lord, the for me notice.
So this order was already challenged. Against this order, my lord, the competent authority, it was remanded, my lord, before the authority.
For me notice has to be issued by the majority. Here, the for me notice has been issued only by 5%.
Remember your arguments. Take your seat, Mr. Rai. Yes, Mr. Korma. Anything else?
Yes, my lord.
Finish in a minute. You have a minute. I'll take up only this matter on the last day before vacation.
But I was just
I'll release the other matters and I'll keep only this matter.
I was just saying that if today it's not completed, let us come back after vacation.
No, Mr. Roy will be there. You come. You are arguing. He will keep someone and you will complete your argument.
That not I can. After vacation, not if it's so common.
Why after vacation? We'll have no work on the last day. No, I am a workaholic. I'm a declared workaholic. So you have to come.
We are kindly not keeps it after 13th of June.
Like on the ardent plea of learned counsel for the respondent, they might order ardent part for further hearing on when? June 13th. June 13, 2025.
If your lordship allows me to say only one thing, so far as that first submission is concerned, it's an admitted position.
Sir, Karmakar will lose the matter most probably. I'm not sure. I cannot conceive. I don't have a preconceived notion. But apparently, up to now, it's 80-20.
A lot of limitation.
80-20 in your favor.
Not on limitation.
I will try to make it 100 out of 100 if lordship.
So limitation point we have to.
Limitation
points,
he
has the better.
I can demolish them in 1 second. Because why? Because if lordship allows me to say.
No, I won't. I will allow you to say on June 30th.
But on that day also, lordship, we will file our written notes of argument.
You have filed already?
I have filed yesterday, but I have to take it back.
No,
because some new points have been raised by my learned friend, which I have.
To write something there, written notes of argument.
They have taken, Lord, I have tried to argue on that.
Because these points were never taken in the.
You exchange your written notes between yourselves before June 13th. That will ease things.
Are raised in the pleading also. That's why I could not raise
I
the
have raised
opposition.
it
He has argued. That's why I'm meeting those points. Nothing
Whatever written notes, you give the date on the written note so that I can know which is the latest. Otherwise, I'll
We shall
confuse.
file it on 13th. ওই দিনই শেষ করি
ঠিক আছে ওদিন শেষ হয়ে যাবে